We are live, Mr. Chairman.
Thank you very much. It is May the 3rd, 2021. This is the Maryland House Judiciary Committee. Welcome to our hearing today. We have hearings on quite a few bills that we'll be covering. We're going to start with House Bill 1070. House Bill 1070 is being brought to us by Delegate Boyce. Delegate Boyce will be joined by Dan Sparacco, Gregory Countess, Safar Shaw. We'll also go ahead in the first panel and hear from Catherine Howard. Even though she's favorable with amendments, we'll just get everybody out there and testifying right fresh out of the gate. So with that, Delegate Boyce, you're going to get 3 minutes. Everybody else is going to get 2, and go right ahead.
Thank you so much. I want to just with the caveat, I know you've heard these bills before, so I want to read my testimony, be brief, and also let you know that there are amendments because I have been working with all parties. So for the record, I am Regina T. Boyce, delegate of the 43rd District, presenting HB 1070, Baltimore City Landlord and Tenant Repossession for Failure to Pay Rent. HB 1070 creates new procedures for repossessing property by requiring a notice of rent due to the tenant on the due date, defining the types of delivery of notice, stipulating what the notice must contain, and prohibiting a landlord from filing a written complaint in district court until 14 days after the notice for rent due is delivered. The landlord may, on the 15th day, file a written complaint in district court. I've often asked myself the question, does the landlord have the right to sue a tenant for rent due without notice of what is due? And if they do, is it right? Is it fair? Is it just? My personal and professional answer is no. I do not believe the landlord has the right to sue a tenant for rent without notice of what is due. When I think of financially contracted obligations, mortgage, utility, water, phone, insurance, etc., each obligation has a notice sent by mail, email, or text, a date due, a period of time before penalties are assessed, and the consequences or action that will be taken if the financial obligation has not been satisfied in the contracted reasonable time frame. Generally, no one is sued the day after their contracted obligation is due without notice from any of the mentioned financial obligations, yet this is what we do to renters for rent. As you know, the district court has about 650,000 rent filings a year. From the 650,000 filings, we know that about 20 to 22,000 occur a year, or 20% actually are evictions. Many of these cases are dismissed with payments made before court dates or tenants have already voluntarily moved out. If the data tells us that renters are paying the rent on or before the court date, we need to change our policies, our procedures, and processes to match behaviors and provisions needed to give tenants time to pay rent. The goal I strive to achieve with HB 1070 is to cut down on the court filings for evictions, which will remove the inundation of unnecessary filings and provide the grace period tenants need to pay the rent every month without the trauma of being sued monthly. This provision will also help keep renters' rent filings from frequently making the Maryland Judiciary Case Search database for being sued for rent in most cases that, of course, has already been paid. Less inundation of our court filings will allow the system to bring to the surface tenants who are coming through the district court in critical need of resources that rent advocates, case workers, and lawyers can provide so that they can begin to tackle underlying causes of housing instability, housing affordability, and homelessness. I thank the House Judiciary Committee for your time and consideration and support, hopefully, of HB 1070. Thank you,
Thank you. Thank you very much. We'll go to Dan Sparacco for 2 minutes, please. Dan Sparacco needs to unmute himself.
There we go. I was too busy starting my 2-minute timer, Mr. Chair. I will keep a close eye on it. Thank you to the committee and, of course, to Delegate Boyce for introducing this bill. I think this bill, this is a large statement given the many things that are going on in front of you all this session. This bill has the potential to be the most impactful bill on Baltimore City of anything else going on, simply by making basic changes to black letter law that the vast majority of states already have. You know, when I moved to Baltimore over 10 years ago, the first thing that stunned me was that there was no notice requirement before suing a tenant for non-payment of rent. I spent over 3 years working in Brooklyn, New York at the Legal Aid Society. I was an anti-eviction lawyer. At the time I worked, there was a 5-day notice. And now in New York has actually expanded that to 14 days, and there's a right to counsel. And I really beg this committee to reflect on who we believe we are as the state of Maryland, and where we should be looking to model ourselves after. There's the other states that don't have any notice requirement. I don't think we want to be those states. If you live in Missouri, if you live in St. Louis, Missouri, you have no right to notice. If you live in Camden or Trenton, New Jersey, you have no right to notice. That's wrong. And I really think you should reflect on why certain states have no such notice requirement. I think this bill, in tandem with the bill to change the fee structure in the courthouse, will drastically change the entire structure and culture of the courthouse, make it possible to identify, as the delegate said, make it possible to identify tenants who actually have needs, whether it's diversion or right to counsel, et cetera. We don't know what those needs are until this has, until you institute this change. And I hope you do so. Thank you so much.
Thank you very much. Gregory Countess, please. Mr. Countess? All right, I see Zafar Shah. We'll hear from him. Zafar Shah for 2 minutes, please.
Hey, thank you, Chair Klippinger, Vice Chair Atterbury, members of the committee. My name is Zafar Shah. I'm an attorney in the Human Right to Housing Project at the Public Justice Center. Public Justice Center is also a member of the Renters United Maryland Coalition of Advocates and Renters, and we've submitted written testimony in support of this bill. We thank Delegate Boyce for bringing HB 1070. The committee has heard on other bills in just the past couple of weeks about how landlords file failure to pay rent eviction actions quickly and prolifically. In Baltimore City, that crush of eviction litigation ran up to 135,000 filings in fiscal year 2019. And it's not mom and pop landlords who immediately file eviction cases without prior communication with the tenant about delinquency. It's professionalized large holding housing providers and management groups that skip the engagement part and go to the churning of eviction cases in court. We know that large landlords have automated this practice. They export spreadsheets on the 6th day of the month, send that data to a bulk filing vendor who then files hundreds of fair to pay rent cases at a time, typically by the 10th of the month. And like House Bill 52 that the committee considered last month, House Bill 1070 presents the fix to overuse of the courts by creating a notice and cure period. HB 1070 does this for Baltimore City. House Bill 52 is a statewide bill that does not cover public local law of Baltimore City. So what's the importance of this notice period? Baltimore City has a filing rate of 2.55 cases per cost burden renter household. DC, just down the road, has a filing rate of 0.54 cases per cost burden household. So what's the key difference? Both of these jurisdictions have a right of redemption, but DC has a 30-day notice and cure period in non-payment cases. Baltimore City has no notice and cure period. So this difference in notice provision helps to explain why cost burden tenants are faring better in DC than in Baltimore City. And simply put, we think that a notice and cure period before litigation can commence will reduce litigation and housing displacement. Finally, this bill also includes documentation requirements in the notice. This is crucial because, as you know,
Mr. Shaw, I need you to wrap up, please.
in these cases, tenants have no right of discovery, not even one limited to the documents that are used in court against them. So we urge a favorable report on HB 1070. And I thank you for your time.
Thank you very much. Catherine Howard, please.
Good afternoon, Mr. Chair and committee members. My name is Catherine Howard. I am the Legislative Committee Chair for the Maryland Multi-Housing Association, and I'm also General Counsel to a real estate management company in Baltimore City that has about 5,000 rental units between Baltimore City and Baltimore County. We have come in favorable with amendments. We've had a number of conversations with Delegate Boyce, the sponsor, and as a general rule, most landlords, particularly in the space of multifamily landlording have already got a grace period built into their leases. Most of it varies from landlord to landlord, but it is generally around 5 days. That's why we are coming in favorable with amendments with the notice period that Delegate Boyce and I have been talking about. And also, I think it's wonderful that we are finally getting to deal with bringing the public portions of the public local law of Baltimore City into a sort of a bit of a more modern world, if you will. We are still working on getting some of those amendments worked out. I intend to make sure that we get to closure on all of that. And I would suggest that to the committee that if you'll give us the time to finish that, we'll have a great product that will be of assistance to both landlords and tenants in Baltimore City, as well as throughout the state. And that would be my testimony. I'll take any questions that the committee has.
Other questions for the panel? Delegate Watson.
Thank you, Mr. Chair. My question is for Delegate Boyce. A couple questions. Is this bill only applicable to Baltimore City?
Yes, sir. This changes our public local law. Yes. Mhm.
Okay, and we have a letter of support from the Baltimore City delegation?
Not yet, sir. Last Friday, this bill was heard in committee, and because I have been diligently and openly working with all parties in this, I submitted a first set of amendments, so it will be voted on by Friday, and then you should get. We should have a lot of things wrapped up by the end of this week, so you should get that letter soon. Thanks for asking about that.
Great, that's great. My one last question is, when you led out, you mentioned that, gas and electric utilities and all of the bills kind of come each month with the amount owed. And the reason that is because those bills vary from month to month. But when it comes to rent, there's the implicit assumption that the rent is fixed, the rent due date is known. And so I'd just like to know, why do you think that the landlords need to take this extra step to notify, when it's already been documented, what the priorities of their contract are?
That's a great question, and it's touched on it in my testimony, is because for all other financial obligations, those steps are also taken. And so you think about your mortgage. Mortgage is due on the 1st. That is known. You get a notice about it, whether you signed up for a paperless a notification or not. You get that notice. You get when it's due. You get when it's late. You get the fee for when it's late, and then you also get what the consequences are if you go past that time. So I would argue that it's a great question, but it's no different than what you get from other financial obligations. My argument is that we don't do this for rent.
All right. Thank you, Delegate Boyce. Appreciate it.
You're quite welcome. Thanks for that question. I appreciate that.
Delegate Grammer.
Thank you, Mr. Chair. Question for anybody who can answer it. It's been my experience that an invoice is sent even for rental properties. Is that the case? Is that not the case? Like a monthly, like a mortgage or my cable bill. Is that not common practice?
I'll quickly answer that, and then I'll let I believe Catherine Howard, she's going to answer that. It is not common practice. You'll hear Catherine say for her it is because of her kind of like multi holdings, but it is not.
Delegate Grammer, to follow up on that, to your question, generally speaking, there is not an invoice sent by landlords to their tenants. However, what I was speaking of was most leases, say they start on the 1st of the month. Most leases have a built-in grace period that basically tells the tenant your rent is due on the 1st. It's due sometimes it says it's due in advance of the 1st, but within a 5-day grace period, if the rent is not received, there will be a late charge. There will be a late charge assessed. That's within the terms of the lease. I think that, and most of us do follow that. Again, like I said, some of the periods are sometimes 3 days, sometimes 10 days, but for the most part, general industry practice is 5 days. And that's what we have been relying on all this time. I think Delegate Boyce has, and some other legislation this year has brought to the fore the fact that perhaps some sort of billing notice or reminder notice, or however you want to term it, would be is some step in the right direction to making sure that everyone knows what their obligations are and how fast and what the consequences are of not meeting those obligations. And we certainly think that on both a local level and a state level, that is something that we are willing to look into and potentially support, depending upon how the language looks.
So as I heard it initially, there is either no requirement or it's not common practice that an institution, a business sends hey, here's your invoice for your monthly rent payment. That is not practice.
That's
Not
correct.
practice.
Okay.
Yeah, some people do, but that's not a large industry practice. The automatic grace period, and we're trying to mirror that in this bill.
Second and final question. In this bill, a lot of times especially with housing issues, if there is a requirement of notice, a lot of times people will say, well, I didn't get that letter. And that becomes, a submissible fact in court.
Yeah.
Is it a provision in this bill where somebody could say, well, I didn't get the letter, that could be used as evidence to preclude the repossession?
Absolutely, Delegate Grammer, and I'm so glad you said that. I don't know if you guys were able to receive my amendments, but my amendments actually speak to kind of modernizing how you can even send notice. So you could send it by paper, but if you're a facility, a company like, for instance, Ms. Howard's, you may send your rent notices and from other notices by text or email. And so there are different provisions on how one can send that notice.
Okay, thank you.
And I would also like to add to Delegate Boyce's point. There in our amendments that we've proposed, there would be a rebuttable presumption that the landlord would have going into court, that if those notices were sent, and there are various ways of doing that, so that the landlord should retain some form of receipt or record that they actually did send that notice. There's a rebuttable presumption that the tenant received that if it was sent in one of those enumerated ways of doing that.
So when you say that, you mean it's assumed it's assumed that the landlord sent it, but it is rebuttable by the tenant that if they could provide evidence that they didn't receive it.
That's correct, sir.
They would have to rebut, yes, that would be a rebuttable presumption that the tenant would remain having. And then the judge can decide based on whatever is presented to him on both sides of that issue.
Okay.
Him or her on that side of the issue.
Thank you very much both for your answers.
You're welcome. Thank you.
We have Mr. Countess, who now has arrived in the room. We missed him before. We're going to give him 2 minutes right now, allow him to talk, and then we'll see if there are any further questions. Mr.
Chairman,
2 minutes, please.
yes, sir. Chairman Clippinger, thank you very much. Members of the committee, I'm not going to take the entire 2 minutes. I'll take this time to thank Delegate Boyce for introducing this bill and also for the invitation to testify. I'd say to the committee that all of this is important procedurally in order to more fully one, give due process or perfect due process in the district court in regard to failure to pay rent actions. But one of the things that is particularly important to us is sort of codification of the case McDaniels versus Baranowski, as well as current and existing Baltimore City law that says that if a landlord doesn't have a license, then they should not be able to pursue a court action against a tenant. And not only would this save time for the court and cut down on court expenses for unnecessary filed cases. It also would save the time of tenants. And I just give you an example. Mr. L was a client of ours. He died back in October, and he died, and now his estate is taking up the case where they are in fact contesting an action that was filed by a large landlord in the city of Baltimore who did not have a license when they filed the complaint, and they should not have filed the complaint. Mr. L, who was elderly and who was ill, fought this action for months. It was months that he should have been spending elsewhere. And this very simple fix to our failure to pay rent statute in Baltimore City would help to remedy that problem. And so we urge a favorable report for HB 70.
Any further questions for anyone on this panel? Seeing none, we thank you all very much for coming to testify today, and that'll conclude the testimony on House Bill 1070. Thank you all.
Thank you so much, Judiciary. Have a good day.
All right. Now, committee, House Bill 1186, brought to you by me. I'm going to begin my testimony now. We passed the bill to do a study on firearm crime, injuries, fatalities, and crime firearms. Because of the COVID crisis, the Attorney General's office has needed to take more time to be able to gather the information. So this bill extends the study and allows for reporting 1 year later. The first group of information for the data between August 1st and July 31st, 2019 would be reported on December 1st, 2021. Then December 1st, 2022 for information from August 1, 19 to July 31st, 2020. December 1st of 2023 for August 1st through July 31st of 2021. And it says that by December 1st, 2024, the Attorney General's office will also provide information now for this data between August 1st, 2021 and July 31st, 2022. That is what the bill does. There is one person here, is here to sign and has signed up in opposition. So I'll take any questions that you have first regarding extending the study a year, and then we'll hear from John Jocelyn. Are there any questions? Seeing no questions for me, let's hear from John Jocelyn. If we could have him come into the room. See if we're having a problem. Is Mr. Jocelyn there? There he is. Mr. Jocelyn, go ahead for 2 minutes, please.
Thank you, Mr. Chairman. John Jocelyn with 2A Maryland. We really would like to see the data. We opposed the bill in House in 2020 simply because we felt that anything that was done by the Attorney General's office would ultimately reflect the Attorney General's well-known anti-gun bias and agenda. For that reason, we opposed the bill. At the time last year, the fiscal note was $200,000. Westlake Law was awarded a subcontract to compile the data. That amounted to $513,468, or 2.6 times the estimated costs. We believe that this is exorbitant. We don't think that the existing fiscal note predicting very limited expenditures is accurate. And for fiscal reasons, we believe that the state of Maryland should cut its losses, and we ask for an unfavorable report.
Are there any questions for Mr. Jocelyn? Delegate Cox?
Thank you, Mr. Chairman. Mr. Jocelyn, thanks for your testimony. Just checking, are you saying that was 500,000 with this current extension, or are you saying that there would be an additional cost? I'm confused.
The 513,000 is related to the cost of the original bill as passed in 2020.
Okay.
We did request the data, the raw data, through Delegate Kipke. He asked the Attorney General for it. The Attorney General has declined to provide it. So we really don't know what we'll be dealing with or what the additional cost might be in the future. We can't put a handle on that. So we're a little skeptical about where the cost may end up.
Are there further questions for the panel? Seeing none, thank you very much. And that concludes the testimony for House Bill 1186. Let's go now to House Bill 966 and Delegate Parrott. It will be the only person to testify on this bill will be Delegate Parrott. So we'll have him begin and go with 3 minutes, please.
Mr. Chairman, it's great to be with you in front of your committee today and committee members. Thanks for having me. It's great to be back in the Judiciary Committee. This bill is actually quite a simple bill. I do have a quick PowerPoint. I don't know if we can show that or not.
Staff can help him.
I'll just wait a little bit
Yeah,
here.
I'm not sure.
Well, that's fine.
You're being made a co-host, so you should be able to share your screen.
Thank you. I click. Oh, wait, something just changed. Let's see here. There it is. Great.
All right.
Thank you, Mr. Chairman. So this is House Bill 966. It has to do with handgun qualification license. And of course, right now, to get the handgun qualification license, you need to take 4 hours of training. It's in a classroom, get fingerprints with the state. And of course, that costs some money to go through the training. This bill simply allows law enforcement in neighboring states and the District of Columbia to basically exempt out of that 4-hour training. Of course, we're only talking about Virginia, West Virginia, Pennsylvania, Delaware, and DC. Currently, people who are law enforcement officers in any county or municipality or the state in Maryland are exempted from the HQL. And this would just extend that courtesy to our neighboring states. Now, it's not people who live in those states. This is people who, let's say they're a police officer in Pennsylvania, but they work in Maryland. So with that, I would like try and unshare the screen here if I can. Great. With that, I would just encourage the committee to please support this bill. Basically, all we're doing is saving 4 hours of time, saving some money. But I think more than that, like one of my neighbors, he works for DC, one of the police facilities there. And he was just really surprised that he had to do this at all. I think we could give a courtesy to the police officers who serve nearby. Also acknowledge that they already have these skills. 4 hours of training is one thing, but they've had countless hours training on handgun training. So there's no reason for them to really have to go through this. We've already exempted the HQL requirements for state police in Maryland or municipal police or county police. I think it just makes sense to extend this courtesy to people who live in Maryland, but are serving as police officers in adjacent areas. With that, I just hope that you all can support the bill. Thank you.
Are there questions for Delegate Parrott? Delegate McComas.
Delegate Parrott, do you know if other jurisdictions allow reciprocity for law enforcement?
That's a great question. I would think that they do. Now, other states near us don't even have this HQL qualification, like West Virginia. I know they wouldn't have this. And so I'd have to look at the laws in other states and see what they're doing.
But a lot of states generally have reciprocity just for the right to carry, correct? One state to another. In other words, like Utah, if you have a license in Utah, you can carry elsewhere in other states. That has nothing to do with law enforcement, but in other words, they're pretty, there's a lot of, because I know we've tried to put bills in for reciprocity for Maryland and they're no go, not with law enforcement, because that's even more specialized, qualified group of people.
Right. And so you are right about reciprocity, but this really doesn't, like you said, doesn't touch that. This is just the training requirements. Those folks are going to get the license. That's not the question. The question is, do they have to take 4 hours of training and pay for the training or not? And I think this would just be a great courtesy to tell people who live in Maryland that are serving as police officers nearby that we do respect the work they're doing, and we know they have the training, and we wouldn't have to require them really just to go and check off the box for no reason.
Okay, thank you. It's a good bill.
Thank you.
Delegate Watson.
Hey, Delegate Parrott, quick question. So the HQL that we're talking about, a regular person who gets an HQL, is that valid for life? Or is there a period of time where they need to go back and get an updated safety training course?
You know, that's a great question. My understanding is that it is valid for life. Once you get it, you don't have to take it again.
And the HQL is separate and distinct from wear and carry, correct?
Yes, sir.
All right, thank you.
Thank you.
Apparently do have someone who's going to testify on this bill, although they signed up to say that they did not wish to offer oral or written testimony. Bradford Sharpless. We can have them come into the room. We'll go ahead and give them this 2 minutes.
Thank you.
Mr. Sharpless. Oh, boy. Well, not going to wait too much longer here. Staff, are we trying to get Mr. Sharpless in the room? All right, so he's having technical issues on his end. Going to give it a couple more seconds here, but we have a very long docket, so. He's no longer in the waiting room. All right, we're going to note that Mr. Sharpless would have testified today. If he has something he'd like to provide to the committee in writing, of course, we will take that. We will include that with the file. Are there further questions for Delegate Parrott? Seeing none, we thank you very much. And that concludes the testimony for House Bill 966. We thank you
very much.
We'll go to Delegate Cox now. Delegate Cox and House Bill 845. Delegate Cox is going to be joined by John Jocelyn, Mark Penack, Beth Lawson, Ari Plouch, Frank Boston. We'll just hear from everybody. Daniel Carlin Weber, George Marshall, and Lisa Feinberg. That is what we'll do. Delegate Cox, if you'd like to begin for 3 minutes, that would be fine. Delegate Cox.
Thank you, Mr. Chairman and members of the committee. It's my privilege to present House Bill 840. Can you hear me now, Mr. Chairman?
Yes.
Okay, thank you, Mr. Chairman, members of the committee. It's my privilege to present House Bill 845, public safety permit to
All right, Delegate Cox appears to
handgun qualifications. This bill is a simple bill. Can you hear me?
We're having difficulty. We're having great difficulty. It's breaking up quite a bit. I believe you're in the building. I think if you're using the in-house Wi-Fi, it should be fine, but why don't we try one more time to let you start up? Although now you appear to be.
There's a Wi-Fi issue here. Let me.
Delegate Cox. Did we just lose Delegate Cox? No, he's still here.
Can you hear me now, Mr. Chairman?
I can.
Okay, I apologize. Let me start real quickly again.
That's fine.
Thank you, Mr. Chair. It's my privilege to present House Bill 845, permit to carry and transport a handgun. This is a simple bill. Is your life a good and substantial reason to be protected. That's the issue before you. Washington, D.C. actually says, yes, you have the right to obtain a wear and carry permit for a handgun in Washington, D.C., but not in the state of Maryland. This bill will make your life a good and substantial reason to be protected. It's a simple approach. It's just simply not changing any of the requirements of the law that would mandate the necessary training that Maryland requires or any other principle of safety. And it certainly provides an added benefit for protection for individuals, both yourselves and those that you love. One of the things that I want to point out is that there's been some argument that this will not, that this somehow can endanger women and minorities, particularly women in domestic violence situations. And I want to mention something. First of all, the most serious candidates for these permits will be most likely residents of Baltimore City, which are completely denied permits as a matter of course. And so thousands of them are known to carry legal individuals, people who are law-abiding individuals carry a handgun into Baltimore City illegally because they're not allowed to get a permit like many businessmen can get in Maryland. We shouldn't have a disparate impact on handing out these protective permits based upon your socioeconomic status. And then as to the domestic violence issue, I want to point out that the study that was mentioned in one of the testimonies opposing the bill states that there's a 500% increase of violence, of homicide of women when there's a gun in the home. And I want to clarify that that's not actually true. The case study was an old case study from 2003, which said very narrowly, they focused on whether or not an individual was abused in a relationship, and it only focused on physically abusive relationships. And the findings indicated that the women in those relationships, only 5% of them owned guns. So this bill will actually empower women who are in a domestic violence potential situation or in a separation, trying to protect themselves, to ensure that their lives are good and substantial. And I ask for a favorable report. Thank you so much.
All right, we'll hear from John Jocelyn now for 2 minutes, please.
Good afternoon, Mr. Chairman. John Jocelyn for 2A Maryland. The carry permit legislation began about 50 years ago, and since that time, the undefined term good and substantial has become a political football. We've heard various excuses over the decades. Often the excuse we hear is that we cannot have untrained people carrying guns, or we need background checks to make sure the people who have guns are not criminals. The Firearms Safety Act of 2013 should have resolved all those arguments and settled the issue. But the background checks and the required safety training weren't a step forward. They were rather a politically correct sounding excuse for additional hurdles. The legislature seems to accept that criminals will always carry firearms, and they've come to accept that as being the reality. The legislature can't stop criminals, but it can stop the law-abiding and has done so. Criminals have protection by operating above the law. We, the law-abiding citizens, lack protection because of the law. We seek and deserve the equal protection under the law is guaranteed to all citizens by the U.S. Constitution. Exactly when will our lives matter? Thank you.
Mark Penn for 2 minutes, please.
Thank you, Mr. Chairman. Trying to unmute here. So we support this bill wholeheartedly. It is necessary to bring Maryland into constitutional compliance. 42 states are shall-issue jurisdictions. 16 states are constitutional carry, require no permit at all, including most recently Utah and Montana. I wanted to focus, however, not on the law, but I wanted to focus on Baltimore. You will find attached to my written testimony a June 2020 report of the Johns Hopkins University. concerning firearms and firearms carrying in the city of Baltimore. I commend this report to all of you. You should read it if you care about Baltimore. And it demonstrates that people are carrying in Baltimore rampantly. And they're carrying not because of two things. They know that the police will not protect them because the existing gun laws are not enforced, and the murders are not prosecuted, and the assaults are not prosecuted. And they carry out of sheer fear and self-protection. These are law-abiding people who carry out of necessity. We would like this bill to be enacted because it will enable these individuals to get the training. I'm a trainer for this permit. I train these people. 16 hours of training. It's very intensive. They end up firing around 300 rounds. Extreme instruction on the law. They get a lot of information about what self-defense law is, how you can use your firearm, when you can use your firearm, and when you can't. That kind of training is desperately needed for the law-abiding in Baltimore and elsewhere. But no one will actually apply for that because they know full well that they won't get it under current Maryland law. So you have a lot of carrying by law-abiding citizens illegally who will be, if caught, stand the chance of being prosecuted. And that, as the Johns Hopkins report itself says, that is contrary to the public interest.
Mr. Pennock, if you'd wrap up, please.
I urge a favorable report, Mr. Chairman.
Thank you very much. We'll go now to Beth Lawson for 2 minutes. Beth Lawson?
Okay, how do I get in?
You're
Can you
fine.
hear me?
Yes, turn on your video,
Okay,
please.
awesome. Hi, I'm Beth Lawson. I'm a 55-year-old woman, slight build, and I live in Howard County, and I don't feel safe. I've had gun training. I have my HQL. I've been around guns for the last 30-some years. And at least every week, an acquaintance relays an account of either themselves, a relative, or a friend feeling or being threatened, followed, or targeted by someone aggressive with malevolent intentions. Recently, a good friend was threatened at knife point, only 19 miles from me. Someone tried to abduct another only 10 miles from my home. These occurrences are in the city closest to me where I need to go to shop. Understandably, most of these accounts go unreported by the news media. I don't want to be one of those accounts. Maryland has had gun control measures in place since 2013. These laws have failed to reduce violence or save lives. Maryland is the most anti-Second Amendment state in our region. Pennsylvania, West Virginia, Virginia are not trampling our constitutional rights like Maryland has. Yet Baltimore City's homicide rate is skyrocketing. It's obvious the current method is not working. Please let Marylanders exercise our constitutional rights and given to us by God, our founding fathers, and the Constitution. Thank you very much for your time, and that's a yay in favor of this bill.
Ari Plout, please, for 2 minutes.
Thank you, Mr. Chairman. Mr. Chairman, Madam Vice Chair, esteemed members of the Judiciary Committee. My name is Ari Plout, and I'm here on behalf of the NRA in support of House Bill 845. Mr. Chairman and the committee, this bill simply clarifies personal protection and self-defense as good and substantial reasons to receive the permit to carry, wear, and transport a handgun. Without the legislation of this bill, it leaves too much discretion into the hands of the decision makers with regard to who will be able to receive this permit. So this bill would just simply provide more clarification and remove some of the discretion. And we believe that if self-defense isn't a good reason for this permit, then I don't know what else would be. And with that, I appreciate your time and would urge a favorable report on this bill. Thank you.
Thank you very much. Frank Boston.
Good afternoon, Mr. Chairman, members of the committee. I'm Frank Boston III. I am here also on behalf of the NRA, and we support this bill. And we thank Delegate Cox for putting it in. Just to pick up on what Mr. Plout said, this change would create a fair and more predictable permitting process and would ensure more law-abiding Marylanders could exercise the right to carry in defense of themselves, their families, and their communities. You know, Maryland is an outlier on the right to carry. At present, 40 states and the District of Columbia have shall issue laws requiring carry permits be issued to qualified applicants. Moreover, 16 states allow law-abiding residents to exercise the right to carry without a permit. Another fact you should know about Maryland, as of June 30th, 2020, Maryland has 27,760 active handgun wear and carry permits. Among states that have a permitting scheme, Maryland is ranked 5th lowest in the number of permits granted as a percentage of the adult population. You know, about 3 weeks ago, myself, I lost a friend who was 58 years old, who actually had kids. And he was servicing an ATM machine. He's from Pikesville. You know, had this bill been in effect, had he had the right and the ability to carry a gun, maybe he would still be here today. But he was servicing the ATM machine 11 a.m. on a Saturday in Baltimore City. And when he came out of the store, bang, he had no way to defend himself and he died, leaving a family and a young kid there. So, you know, with that, Mr. Chairman, we ask for a favorable report.
All right, Daniel Carlin Weber, please.
Good afternoon, members of the committee. Thank you, Chair. My name is Daniel Carlin Weber. For the record, I'm a District 40 resident, and I'm also a qualified handgun instructor under by the Maryland State Police. I do teach carry permits for Utah, and I am familiar, unfortunately, a little too familiar with the process for getting a wear and carry permit in Maryland. As has been explained by my esteemed colleagues here, it is a very difficult process. It leaves a lot of guesswork for the person who's trying to go through the application process. They have no guarantee of knowing whether or not they'll get it, regardless of whether or not they pay the fees, pay for the training, etc. There's actually another bill on that point, SB 309, that I hope you consider sometime that talks about the training requirement. But I'd like to mention that carry permits are overwhelmingly common amongst the rest of the country. If you refer to my written testimony, I've listed the practices for all the contiguous states of ours and how they issue permits, and a link to how those applications work, et cetera. I've personally gone through the DC process. It is easier for a Maryland resident to be able to carry within the nation's capital than it is to carry across their own street. And I think that's egregious, especially in this day and age. The process should be an equitable and fair process. There's still a great level of responsibility that comes with having a carry permit. It is not trivial. It is not merely just carrying a gun. There are very serious requirements. A very high threshold needs to be met to be able to use that gun. This isn't something that anyone should think is something like a Wild West situation. That's not at all what we would have here. That's not at all what exists in the rest of this country, where carry permits are overwhelmingly common, and the typical person can get a carry permit to be able to protect themselves in public. So for all those reasons, I urge a favorable report. Thank you very much, committee.
Thank you. We'll hear now from George Marshall, please, for 2 minutes. Mr. Marshall. Mr. Marshall appears to be frozen. So we'll go to Lisa Feinberg and then we'll come back to George Marshall. Lisa Feinberg.
Yes, thank you. I'm Lisa Feinberg and I'm testifying in favor of HB 845. I'm a resident of Howard County, Maryland, and every few years I learn a new sport, and this year's sport is handgun target shooting. So in order to do this, I paid a fee and completed a handgun qualification licensing course offered by a certified instructor. I then applied for the HQL to the Maryland State Police, submitting my fingerprints, a fee. I passed the background check and I was issued a handgun qualification license. The HQL is valid for 10 years. It's not a life thing, 10 years, and is required to be presented anytime I intend to purchase, rent, or receive a handgun in Maryland. This license does not allow me to carry a handgun, and it does not authorize me to transport or wear a handgun. As a responsible citizen, it's up to me to learn the laws of Maryland pertaining to guns. We are a quote duty to retreat state. That means if I ever purchase a handgun and am licensed to carry that gun outside of the home and I was attacked, the law requires me to do two things. One, avoid danger before using deadly force. And two, if I did use force on an attacker whom I believe would cause me serious harm, I would need to prove later in court that my life was in real danger, since the law requires you to try to find a safe way to escape before fighting back. Sadly, criminals don't follow the law, so the law-abiding person, such as myself, is at a disadvantage. I have a valid Maryland driver's license with a little star on it. I have an HQL from the Maryland State Police. I even have a global entry pass issued by the Department of Homeland Security that I enter the United States, I bypass customs. All of this, and I have little to no protection or gun rights in my home state of Maryland. Please vote in favor of HB 845.
Thank you very much. Now I see George Marshall. We'll let him testify now for 2 minutes.
Okay, can you hear me this time?
Yes.
Excellent, excellent. Good afternoon, Mr. Chairman and committee members. My name is George Marshall. I'm a retired resident of Prince George's County, Maryland. Thank you for this opportunity to speak to the panel. I also want to thank Delegate Cox for sponsoring this bill. I think is much needed for our area. This topic is very important to me. Over the years, I've taken numerous firearms training classes, both handguns, long guns, and I have no problem with additional classes required by Maryland. I actually have non-resident carry permits from several other states. I'm legal in numerous states, but not my home state. I'm 64-year-old, in fairly decent health, but I live alone. Most of the things I do, I'm alone. And needless to say, I no longer can defend myself as I could 20 or 30 years ago. I'm a law-abiding American citizen. I strive to stay in compliance. I have some serious issues with the way Maryland views a citizen's right to bear arms for self-protection. I wholeheartedly believe that the citizens of the United States should have a right to bear firearms for self-defense, and that we should also consider that here in Maryland as a reason to be able to get a carry permit. These laws, they don't do anything to circumvent the criminals. The only thing they do is to have a negative effect on the law-abiding citizens. And I think that the way it is right now is almost similar to saying, wait till I have a car accident to put airbags in my car if I have to wait until after I'm attacked or somebody threatens my life to get a carry permit. I actually ought to really consider passing this bill. I would put my full support behind it. Thank you so much for this time.
All right. We have some degree of confusion. I have here that Omar Chang is not speaking today. However, we have a sign language interpreter for Mr. Chang. So I'm Mr. Chang, I think, or Chung, I should say. Is it the intention of Mr. Chung to speak? He is not speaking or signing. This is the note that I have from staff. That's fine. Thank you very much. We'll stop right there with those people set to testify. We're going now to Delegate Grammer.
Thank you, Mr. Chair. I think I'll ask this question to Mr. Ballston. And first off, I'm sorry about your friend. I saw the news. It's terrible. This issue used to be something I only heard about in Republican circles, but I'm hearing about it more and more from average people every day. And frankly, I'm hearing about this issue more from Black Marylanders than I've heard in my entire life. But a question came to mind. I've started to hear people say, like, almost jokingly, like, you know what, I'm just carrying despite the law because I'm in this particular scenario and I fear for my life. And they're joking, but I'm asking myself, are they really joking? Do you have any information on the amount of people, the amount of cases, the amount of times the charges are pressed for carrying without a permit in this state? What I'm trying to get at is how many people are we making criminal, and the only act they're committing is carrying without a permit? Do you know anything about that? Can you speak to that data?
That's actually a fantastic question. I'd like to know the answer myself. I don't know the answer, but I can check with my folks at the NRA and see if they have any specific information in that regard, and I'll get back to you.
Yeah, if you could. I feel maybe I should have pinged one of the gun organizations, but if you could maybe get that for me, it would really help. Thank you.
And you basically want to know.
Yeah. What I'm not looking for is like people who are their charges are pressed for carrying without a permit and maybe possession or distribution of drugs and theft. I'm not looking for all that. I'm looking for how many cases are there where someone is just charges are pressed because they were carrying illegally.
Yep, got it. I'll see what I can find out for you.
Thank you. And sorry again about your friend.
Yeah, thank you.
Thank you very much. We'll go now to Delegate Watson.
Thank you. A follow-up question for Mr. Boston. So if you're going to get that data for Delegate Grammer, I'd be curious to know what is the percentage of those whom you believe could pass the background check, right? It's not so much that they were caught. I don't care about, the people who were caught and they were trying to do something illegal. But if I feel threatened and I want to carry a gun and maybe I could not have gone through the process to qualify, or I'm not a business owner, or I don't fit some of that criteria. That's what I'm interested in. And my question is for the sponsor of the bill, Delegate Cox. Are you saying that, when you go through the wear and carry permit, one of the first things you have to give some thought to is, what is your statement of need, right? That's the first thing they asked. And I had to really think about, how I would justify requesting this permit. And, based on your bill, is it true that would just be a one sentence, I want personal protection? Is that what you're trying to get at with this bill?
Thank you, Delegate. And yes, that is the focus, that your life is a good substantial reason. And obviously that's a personal choice. So there may be some who don't wish to pursue that, but for those who, for whatever circumstances that they may live in or experience or have an interest in, putting down the fact that they want to have protection is certainly a good reason, because their lives and the lives of their family they matter.
All right. Thanks for that. Appreciate it.
And if I could just, if I could just agree with you as well about the business issue. I mean, one of the things that has bothered me historically about this status in Maryland is that if you're somebody who has money and a business, somehow that person's life seems to be more good and substantial under the law in terms of how they hand out these permits than someone who may not have as much money. And that's just not right.
Thank you, Delegate Conaway.
Thank you, Mr. Chairman and committee, people that came in to testify. Ms. Feinberg, can I ask this question? If a person is at an ATM machine and money is coming out the machine and they feel that they're threatened, how would that work in what you call a duty to retreat state? Would the person have to leave the money, or because they have their money coming out of the machine, can they protect themselves and their money? How does that work?
Okay, that's a great question. And I must say, I'm just a lay person. I'm not a lawyer and I'm not a gun legal expert. I'm just a citizen learning all the laws so I don't break them. My understanding, because I looked it up and read the legal writings over and over, is that Maryland's, I can read it to you, it's just real quick. Maryland's duty to retreat law requires people who are not in their homes to retreat or avoid danger before using deadly force to defend themselves. A person who does use force on an attacker whom they believed would cause them serious harm would need to prove in court that his life was in real danger, since the law requires you to try to find a safe way to escape a threat before fighting back. So I guess you're really supposed to run away, leave the money,
Some
and
of us
run away.
can't.
According, that's how I interpret it as a
Well,
citizen.
thank you for that. And I was wondering, does anyone know what the FOP or what the state troopers might think about this bill?
Well, it's not up to the state troopers, it's up to the judge.
Well, no, I'm talking about this bill, in reference to this bill. The reason that it's sensitive is because in Baltimore, we have a consent decree. And as I understand it, if the police observe you with a certain type of bulge that they believe might be a firearm, they're really not supposed to stop and frisk you unless they actually have a certain level of evidence that it is a firearm. So they're going to be seeing all these bulges, and you're going to know people walking around with these firearms. I was just asking anyone have any idea how law enforcement feels about this. Okay, thank you very much.
Well, if I may say, I do have some close friends and family members who are law enforcement on Prince George's County, and they support us being able to carry, because most people who are carrying are responsible gun owners. We're not out looking for trouble. We're not out trying to print, as they say, to show a firearm. You want to protect your life. So most of the people I know who are in law enforcement are behind this.
Thank you very much.
Unfortunately, I don't know
It
whether I
seems that
have the
Mr. Chung,
floor.
I'm sorry, he said, thank you very much. That stops it. It seems that Mr. Chung does wish to speak. We're going to give Mr. Chung the ability to speak. He has a sign language interpreter. So we're going to need to have her on the screen translating for Mr. Chung. So if the interpreter has conveyed that information, Mr. Chung is still in the room. Let's ask Mr. Chung to turn on his video.
Okay, I'm gonna try to talk, like I usually sign, but I'm gonna talk for you guys. So anyway, my name is Omar Chung. I live in Prince George County in Capitol Heights, Maryland. I am a upcoming NOA basic pistol instructor. So long story short, I've been here since 2013 from Rochester, New York. So long story short, you know, with the what do you want to call it, training requirement, it's very difficult for me to get a ASL interpreter because of the finances of the businesses, and you know, I have to jump through to get the ASL interpreter to make sure that I can self defend myself. And also, I live in a decent neighborhood where crime rate is very ridiculous. So if I'm a member of NOA and Maryland Saw issue, and I'm trying to defend myself, I am not allowed to defend myself outside of my home. So, if I carry a firearm on me, and that means that I'm breaking the law, right? According to HQL, I can only carry from home to the gun range or to a gunsmith, and gunsmith to home. Like, I can't have it on me if it's loaded. I can't do anything whatsoever to defend myself. So if you think about it, I'm a Black male who have no criminal record, who works for the federal government, who have security clearance, and I still have to jump through to abide the law just to get wear and carry permit. Other than that, I just hope that you guys are very supportive of HB 845, and I hope that you can revise your laws going from there and take it as a consideration. And also you have to be mindful with people with disabilities. I'm disabled. I don't look like I'm disabled. I'm well educated, and I'm trying to be able to defend myself. So if you can at least support this bill, I'll be very happy to support your other bills in the future. All right.
Thank you.
For your
Thank you
time.
very much. Does anyone have any questions for Mr. Chung? All right, thank you very much. That concludes the testimony on House Bill 845. Appreciate it. We're going to move on now to House Bill 932 and Delegate Arakan, who will be joined by Edward Coyne and Robin Stimson. Those are the only people set to testify. We're going to have Delegate Arakan for 3 minutes here, and then the other two for 2 minutes. Delegate Arakan, go ahead.
Thank you, Mr. Chair. Good to see everybody again and to bring you this bill again. I had it last year, but you know, I had to leave early for medical reasons because of COVID, so I wasn't able to follow it through. So I'm here again in support of HB 932, drug driving controlled substance testing authorized police officers. Last year it was HB 1334, if anybody wants to look it up. The cross-file bill has passed the Senate. It did not get passed the Senate last year, but obviously did not move on the House side. This bill has no fiscal impact. It would just clarify some confusion about whether the police officers can get warrants for blood from suspected drunk and drugged drivers. Right now, only drug recognition experts can request for a blood sample from a suspect that they believe is impaired. And there are only 183 of those DREs statewide. So if a DRE is not available, the driver really can't be requested to consent to a blood test for drugs or controlled substances. But there are 1,000 ARIDE certified officers who could perform those tests. And the ARIDE stands for the Advanced Roadside Impaired Driving Enforcement. This legislation would just allow for the ARIDE certified officers to have the ability to utilize those detection skills and testing capabilities that they've learned to get some more of our impaired drivers off of the street so that they can't kill our fellow citizens. So I urge a favorable report, and I will pass it over to my panel. Thank you.
That's fine. Let's hear from Edward Coyne, please, now for 2 minutes. Mr. Coyne? Well, there we go.
Sorry about that. Thank you, Mr. Chairman, Madam Vice Chairman, and members of the committee. I'm Edward Coyne. I'm one of the Deputy State's Attorneys for Carroll County. I'm also testifying on behalf of the Maryland State's Attorneys Association. Mr. Daggett submitted written testimony, and we support House Bill 932 because it will enhance public safety by getting more drug impaired drivers off the road. And every year, on average, there's about 150 fatal collisions and over 2,000 non-fatal injury collisions as a result of drug or drunk driving. Under the current law, as the delegate said, only a drug recognition expert can even ask for consent to get a blood sample from a suspected drug impaired driver. Under this bill, the officers who complete the 16-hour course, the ARIDE course, which is a NHTSA course, so it's a national course, the curriculum's national, would be able to ask for consent. And an example Mr. Daggett put in his writing is that if an officer comes up to a scene where a suspected drug impaired driver crashes his car, he's got a needle in his arm, they find a vial marked heroin, he tells the officers he's stoned, that officer could not ask for the consent to take a blood draw to confirm or dispel whether or not that suspected impaired driver has heroin or illegal drugs in his system. So this bill would allow extra officers, the 1,000, and I looked on the website, Delegate Arakan, there was 183 last year, and apparently we must have lost 12 because currently on the website for the Maryland State Police DRE site, there's only 171 now. So there's even fewer this year than last year. So it makes it that much more important. And they have to cover all 24 jurisdictions. So I would ask for support on this to get more officers to ask for consent to get a blood draw, determine whether or not there's objective evidence that drugs are in someone's system causing the impairment, that it's not some medical emergency or something like that. And we would ask for a favorable report on this bill. Thank you.
Robin Stimson, please, for 2 minutes.
Thank you, Mr. Chairman, members of the committee, for allowing me to testify in favor of House Bill 932. My name is Robin Stimson, Manager of Victim Services with Mothers Against Drunk Driving. MAD thanks you, Delegate Arakan, for sponsoring this essential piece of legislation. House Bill 932 seeks to allow specially trained drug detection officers who have graduated from the ARIDE, which has been mentioned already as the Advanced Roadside Impairment Driving Enforcement Training, or comparable program of training to request, require, or direct tests of blood in order to test for drugs. ARIDE is a 16-hour course developed by the National Highway Traffic Safety Administration, and is designed to train officers in the detection of drugs and how they impact drivers. MAD supports HB 932 because suspected drunk and drug drivers should not be allowed to refuse a chemical test. Conservative estimates show impaired drivers have driven drunk at least 80 times before they are arrested. HB 932 will help enforce Maryland's impaired driving law while also holding impaired drivers accountable for the potentially deadly choice to drive drunk. Reforming and improving DUI and DUID laws are a critical tool to create a future of no more victims. Every one of us at this hearing expects to make it home safely at the end of the day. Maybe we are running errands or headed home from work, or our parents are driving home after finally procuring their vaccine. I can tell you, as a longtime victim advocate, not one of us, myself included, is prepared to get that phone call or knock on the door where we learn that our loved one is gone and is never coming home due to the dangerously poor choices of an impaired driver, or that we need to get to our local hospital as quickly as we can because our family member or friend is fighting for their lives after a crash. Not one of us honestly thinks the unthinkable will happen to them, but it does every day, all over this country and all over this state. And when it does, as you can imagine, the pain can be all consuming. The truth is this anguish, trauma, and grief is avoidable. I'm not here to tell you that statistics and data are not important, but at MAD, these are not just data points. They are not numbers. They are mothers, fathers, siblings, husbands, and wives. MAD thanks you for your time and attention, and I'm happy to discuss any of the above data if the committee would like any more information.
Are there any questions for the panel? Delegate Conaway, remembering to press the button, but Delegate Conaway?
It won't press. Thank you, Mr. Chairman. It won't press on the participants. But my question was for the sponsor. So under this bill, if the police officer has had the training, they'll be able to ask you for consent to draw your blood on the side of the road. And I guess would they have a blood test kit or something?
Yeah, or they can take them to the hospital.
And I can take that, Delegate. They have to get a nurse, and they do have to go to a hospital in a medical setting to get the blood drawn. And there's a kit that the Maryland State Police give to all the jurisdictions. So it's in a hospital setting. It's not on the side of the road.
Not on the side of the road. Okay, thank you very much.
Are there further questions? Seeing none, thank you very much. That concludes testimony on House Bill 932. We're going to go to House Bill 926 now. House Bill 926 with Delegate Arakan. Again, it is going to be Delegate Arakan, Edward Coyne, Joe Riley, Lenora Wilson, and Reginald Wilson. We'll hear from all of them. 3 minutes for Delegate Arakan, and that time will start when she begins. So Delegate Arakan.
Thank you very much, Mr. Chairman, Madam Vice Chair, and my friends Judiciary. I'm here today in strong support of HB 926, Josette's Law. This bill was named after Josette Wilson, a young woman who was tragically killed by a drunk driver in 2019. The driver only received 5 years in prison, and while the Wilson family will forever be without their baby for the rest of their lives, he will be right back out on the street very soon. The purpose of this bill is to change the statutory penalties for homicide by vehicle and vessel. The bill will increase the maximum term of imprisonment for the offense of manslaughter by vehicle or vessel from 10 to 20 and 15 to 30 for an individual who was previously already convicted of similar related driving offenses. The maximum term of imprisonment for the offense for homicide by motor vehicle while under the influence of alcohol or alcohol is 5 to 10 years for an individual convicted, and for if we're convicted of certain other driving related offenses. So Mr. Riley is going to help from the state's attorney's office, and Mr. Coyne will explain more about sort of the details of why these penalty changes, and you will get to hear from the Wilsons about their daughter. Thank you so much, Mr. Chairman.
Thank you. Let's go ahead and hear from Joe Riley, please, for 2 minutes.
Thank you, Chairman Clevenger. I'd like to thank Delegate Erican for bringing forth this important piece of legislation. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the current legislative chair for the Maryland States Attorneys Association. We are seeking a favorable report on House Bill 926. As Delegate Erican mentioned, this bill is named after Josette Wilson, who was a constituent of mine. She was a North Carolina high school graduated in 2012. She was the drum major for our Band of Blue. She was an all-state band member, and she was cut down at the age of 25 by a drunk driver who tested well above the current per se limit of 0.08 when he was flown out of Greensboro, Maryland to Christiana Hospital in Delaware. This new bill is really all about proportionality. Currently, if Delegate Erican and myself went out to an establishment and had drinks, and then we were at a per se level, and we went out into the parking lot and she shoved me, she could face 10 years for second-degree assault. If she got behind the wheel of her car and killed me, she could face 5 years. If she got behind the wheel of her car and demonstrated gross negligence or wanton disregard for human life, she could face 10 years. Again, the same as the shove in the parking lot. Now, some of you might think, well, there was some intent in the shoving. Well, we can no longer live under the delusion of what happens when we drink and drive. We currently also have many more options for people when they get inebriated through Uber, Lyft, ways to get home. The penalties work. In 1988, we had over 30,000 people nationwide die on our streets from drunk drivers. In 2018, it was 10,000. Maryland currently sits 46th of 51 jurisdictions. That's the 50 states and DC in the way it deals with drunk drivers. It's time to come to the modern era when it comes to how we treat DUI, DWI deaths. These are deaths, people. And I ask for a favorable report. Thank you.
Thank you very much. We'll go now to Edward Coyne, please, for 2 minutes.
Good afternoon, Mr. Chairman, Madam Vice Chairman, and members of the panel. Thank you again for hearing me. I'm Edward Coyne, Carroll County State's Attorney's Office. We joined the Maryland State's Attorneys Association in requesting a favorable report for House Bill 926. I concur with Mr. Riley's assessment, and my thoughts and prayers are with the Wilson family for their loss. Drunk driving, especially recidivist drunk driving, is a major problem. And I would suggest, especially the DUI homicide law, where you're capped out at 5 years for someone who's not committed a fatal DUI or fatal manslaughter, and recognizing that someone is entitled to parole, it's considered a nonviolent offense, so they can get out of jail in 1/4 or 25% of their sentence. And if you increase that penalty, even if the sentencing court did not give them all 10 years of the sentence, they'd have a sentence, part of that 10 years hanging over their head. It has something hanging over the drunk driver, fatal drunk driver's head, to make sure that they comply with the law, because recidivist drunk drivers are a major issue. It would add deterrence and accountability for those drunk drivers who kill people. And we would ask for a favorable report for House Bill 926. Thank you.
Thank you very much. Lenora Wilson. We also have Reginald Wilson. I'll go to Lenora Wilson first, please, for 2 minutes. You need to unmute yourself, however. There we go. Yep, there we go.
Okay. Good afternoon, committee chair, vice chair, and committee members. My name is Lenora Wilson. 2 years ago, February 9th, my life was changed forever. My youngest daughter, Josette, and this is Josette, was killed by a drunk driver just 4 days after her 25th birthday. It was completely devastating. It has completely devastated everyone who loved her. She was a shining light in all of her lives. She had a ready smile and an infectious laugh. She only wanted to do well for herself and for others. This light was put out by someone who made a decision to drink and drive. He was sentenced to 5 years for the crime, the maximum under the current law, and he is up for parole now. And all he had to say to us in the courtroom was, accidents happen every day. I, however, was sentenced to life. I was sentenced to life without my baby, a life where I wake up every morning with an ache of emptiness in my soul. I have a life sentence of imagining what her children would have been, what they would have looked like. I have a life of tending her grave, putting out flowers and decorating for the holidays and her birthday. I have a life where every workday I have to talk myself into going to work. I work in the emergency room where I had to go that night to identify her. Wait a minute, I lost my place. I no longer find joy in my job. I know that every parent who loses a child feels the emotions I feel. My feelings don't set me apart from any other parent. However, the way my daughter was taken from me was senseless, and to know a blatant negligent act on another's part is to blame makes me mad. When I was 12 years old, I attended my first funeral for my niece, who was never allowed to take her first breath. My sister was 9 months pregnant when she was hit head on by a drunk driver. I remember standing there looking at this perfect baby and promising to never do anything that stupid to put another family through what we were going through, and I haven't. To consider my Josette's life was worth only 5 years is an insult. My theory is this: if you intend to go to the bar and drink, to go to a party and drink, or just go out with friends and drink without a designated driver, then you have already made the decision while sober to drive yourself home either under the influence or intoxicated. Therefore, this makes the crime premeditated. If you
Ms.
take,
Wilson, I'm
yes,
sorry, if you would begin to wrap up, please.
I'm almost done.
Okay.
Therefore, this makes the crime premeditated. If you take an innocent life while doing so, the taking of that life should be considered premeditated also, because everyone knows the risk of drinking and driving. I urge you all to support this bill. Thank you.
Thank you very much. Reginald Wilson, now please for 2 minutes. Mr. Wilson,
There you go. Yes.
go ahead for 2 minutes, please.
Good afternoon, committee chair, vice chair, and committee members. Thank you for allowing me to speak today. I am speaking in favor of this bill. My name is Reginald Lee Wilson, and my daughter was Josette Lenore Wilson. It is very hard to speak of the tragedy that took my daughter, but I do, because she deserves to be heard and she deserves justice. However, that fell short. Instead, we sat and watched as a truly fine prosecutor and a very honorable judge tried to work within constraints while following the law. A law that leaves no room for justice. As a result of that, the person that killed my daughter is up for parole now. The man who killed my daughter stood in court and said he didn't understand why, quote, "This is so big. People die all the time. Planes fall out of the sky. All I was doing was going home." Well, my baby, all she was doing was trying to get home. I would ask the committee members to indulge me just a moment. If you knew a child who was born smiling and never stopped, a child that loved school, who would literally go into a panic if she wasn't prepared, a child who excelled in chorus, who fell in love with the clarinet and made first chair in high school. But even that wasn't enough for my daughter. She went from that to drum marching band, to junior drum major. And she capped her high school career off with leading the Band of Blue in the 251st St. Patrick's Day Parade in New York City. She went on to attend college after and work. And my daughter was interested in her career, more other distractions, and she put off having a husband and children because she had plenty of time for that. And having just been promoted and having just turned 25 years old, she kisses her dad and leaves to celebrate with her friends. And then she walks out the door and never returns. I would ask the committee to think of this as their child. What if their child, your child, was killed like this? Would 2.5 years make a dent in your pain, your suffering? I think not. Thank you, committee chairman, vice chair, and committee members for allowing me to speak.
Thank you very much. Are there questions for this panel? Delegate Cardin, please.
Thank you very much, Mr. Chairman, and thank you all for your very compelling and thoughtful testimony. This question is really for State's Attorney Riley, who is our resident expert, and thank you again for your testimony. And while we sometimes don't agree, I'm torn on this bill, and I appreciate your testimony. What would be the lesser included offenses on a vehicular homicide type charge?
All right. So from the top, assuming there's no intent, you have manslaughter, gross negligence, which starts off at 10 years. When the legislature passed homicide by vehicle driving under the influence per se, you in effect nullified the ability for driving under the influence per se in and of itself to qualify for gross negligence. So you need to have that DUI per se plus something to achieve that line, talking on the phone while driving, drag racing, something like that. Then we have the DUI per se homicide, that's a 5-year penalty. And you have driving while impaired, which is a 3-year penalty, all this resulting in a homicide. Then, of course, you have, if it's not DUI and it's simply a homicide involved, and the 5 years is also for CDS and for taking prescription drugs as well and causing the death.
So I know we can go on with maybe a couple smaller ones like negligent driving or the minor offense that you may have. My question would be: is an issue that the judge is not doing these consecutive if you wind up getting, or is the issue that you're pleading to one charge and so therefore you can't tack on the other 4 or 5 offenses?
With merger under the Blockberger test with the necessary elements, they would all merge. So you wouldn't be able to do consecutives unless you had more than one life being lost in the car. So they would all merge into the highest crime now because where the accident took place is such a remote area, there were no witnesses that could say how the defendant was driving. And he also had an older car that we couldn't pull any data from. So we really just had him going over the center line when it came to the time of impact, according to the accident reconstruction expert. So that driving under the influence and that slight deviation from the rules of the road was not enough to meet the gross negligence standard for the 10 years.
Because of the merger doctrine, you can't charge him with all the lesser included separate charges, and then
you can, but they would all merge upon conviction if we went to trial.
And okay, thank you. And the last thing is perhaps if you're seeking 10 years for second degree assault where it's just a shoving, we need to deal with that issue.
That's the maximum penalty set by statute. I just used that because
I know, but I wouldn't assume that you're not seeking 10 years for shoving, maybe for some kind of serious.
You are correct.
Yeah.
Are there further questions for the panel? Seeing none, we thank you all very much. And that concludes the testimony from House Bill 926. We're going to go now to Delegate Erican again for 927, House Bill 927. She will testify. Edward Coyne again will testify. Deontay Griffin, Robin Stimson, Marguerite Morris, Kurt Erickson will all testify. They'll each get 2 minutes. Delegate Erican will get 3. And we'll go ahead and we will begin with Delegate Erican for 3 minutes, please. You're muted, though.
We've been doing this for so many months and still I can't find the mute button. All right, thank you, Mr. Chairman and Madam Vice Chair and my friends. I'm back again for the third bill in a collection of bills that seeks to appropriately address the issues of manslaughter and vehicular death involving drunk drivers. I appreciate everybody sticking with us on this. It's a very important issue to me and to, as you can see, all of our witnesses today. This is HB 927, drunk and drugged driving testing warrants, Dan Sean's law. And I wanted to thank Delegate Bartlett for working with me on this bill over the interim. I very much appreciate her reaching out to me and connecting me with the family. This bill was named after Dan Sean Wells, a 14-year-old who was killed while he was crossing the street to get a cold drink on a hot summer night. He was killed by a driver who could have been impaired, but since the testing was not done at the scene, the impairment status, we will never know. The current law authorizes an officer to take a blood draw only if the accident involves a life-threatening injury or fatality, even if the officer suspects the driver is impaired. But any cases that don't fit that criteria, the law is currently being interpreted by some as a prohibition on a search warrant for a blood draw. So HB 927 would allow officers to use their discretion to be able to move forward in obtaining that warrant for testing, and in that remove more impaired drivers from the road and save a lot of innocent pedestrians like Dan Sean and many other drivers from a very sad fate. So I will urge the committee a favorable report on this issue. And I will also mention that all three of the bills in this package have absolutely no unfavorable or opposition testimony submitted. So thank you very much.
Thank you. Now we will hear from the witnesses for 2 minutes each. We will go first to Edward Coyne, please, for 2 minutes.
Thank you again, Mr. Chairman. Edward Coyne, CONE for the panel. I'm going in support of House Bill 927, and mostly because it clarifies existing law, and I'm also testifying on behalf of the Maryland State Attorney Association that supports it with amendment. And the amendment would simply be to pull in the court's article 10309, which is read in paramateria with 16205.1. So we'd ask that amendment, which is also in Senate Bill 559, be incorporated to this bill. The Supreme Court and the Fourth Amendment have consistently preferred warrants over other methods to get evidence. Consent is obviously a widely accepted alternative to getting search warrants, but it's not an exclusionary thing. 16205.1, unfortunately, has been read by some members of the judiciary to be an exclusionary thing because the language of the statute does say, except as provided within the law, a person may not be compelled to take a test. And that's been interpreted by some members of the judiciary to forbid warrants. And the Maryland State Attorney Association and our office got a opinion from the Attorney General's office, and their confidential opinion was consistent with this legislation that judges can give approval to an application for a warrant to get a blood sample to tell whether or not someone's impaired by drugs or alcohol. So we would ask that this committee give a favorable report for this bill. And this bill would clarify any confusion, because although our position is it's permitted and the Attorney General's letter seemed to support it was permitted, this would clarify it and leave no question that yes, judges can allow officers who apply for a warrant if there's probable cause. This neutral detached judge can allow a police officer to get a warrant to then obtain blood to determine whether or not someone has illegal substances or alcohol over the limit in their system. And this would also help fight drunk driving. The laws have consistently, through the courts and the opinions, have consistently said that the transportation article 16205.1, the statute at issue, was enacted for the protection of the public, not for the protection of the rights of the accused. So I would ask for a favorable report for House Bill 927. Thank you.
Thank you very much. Deontay Griffin, please, for 2 minutes. You are muted. You're going to have to start again.
Hello, everyone. I'm Dan Sean's mom, As you all have already heard, Dan Sean was 14 years old when he lost his life, senselessly and tragically due to a drunk driver. I'm in favor of the House Bill 927. It should not be up to the officer's discretion, especially in event of a fatality or someone that's critically injured. My son was not only a deceased victim, but he was also reviolated after his death by the officer requesting a toxicology screen to be done on my son's blood alcohol levels, which came back negative for everything, but yet the driver did not get a breathalyzer, nor was he asked for his blood alcohol levels to be tested. Just days after I lost my son, I went to Maryland Judiciary Court Search in Google, and I was able to print out 37 pages of the driver's lengthy driving record, criminal record, and arrest record. This person's license has already been suspended twice for reckless and negligent driving. It's evident that he has no regard for the law that are in place for the state of Maryland. Not only did he not, get anything done to him, was no jail time, no drug or alcohol acknowledgement. This person paid a fine of $500 for taking the life of my child. His wife reached out to me and she gave me 3 receipts, which 2 bar tabs were maxed out, and he started on the 3rd bar tab. He was out drinking that night, but due to the officers, in my opinion, poor discretion, he felt that, the guy wasn't drinking when in fact he was in drinking and extremely over the limit. This guy cashed out 3 bar tabs. He maxed out 2 and started on the 3rd bar tab. I was taking the life of my child. And based off of his driving record, based on what I was able to print out from public record, it's evident that this person has no regard for the laws that are in place in Maryland. That's all I have to say.
Thank you very much for your testimony. We appreciate hearing from you.
Thank you.
We'll hear from Robin Stimson, please.
Thank you again, Mr. Chairman and members of the committee. Thank you again, Delegate Erickson, for sponsoring this vital legislation. Impaired driving is still happening. MAD regularly gets calls from families across the region that have been absolutely wrecked and need our help. Their lives have been completely destroyed by an impaired driving crash that did not have to happen. It might come as a surprise to those listening today that deaths and serious injuries as a result of impaired driving have persisted, even during stay-at-home orders over the past year. Sadly, Maryland's fight against impaired driving is not over. According to the National Highway Transportation Safety Administration, in 2019, there were 167 people killed in crashes caused by drunk driving, representing 32% of all total traffic deaths. MAD supports HB 927 as this measure gives law enforcement and prosecutors the necessary tools to uphold suspected impaired drivers accountable for their careless choice. The legislation ensures safer streets while protecting constitutional rights for all people of Maryland. Refusals to submit to a chemical test is a problem in the United States. In a 2009 report submitted to Congress entitled Refusal of Intoxication Testing, data showed that typically 1 out of every 5 arrested drunk drivers will refuse a chemical test. However, in Maryland, more than 1 of every 3 people arrested for suspected impaired driving refused to submit to a test. Compared to other states, this is above the national average. There's a chart that is in my written testimony for anyone who has any questions about that. House Bill 927 establishes an exception to the prohibition on compelling a person to undergo a certain test of a person's breath or blood for a test that is required by a valid warrant. Without a legislative remedy, law enforcement and prosecutors remain at an extreme disadvantage in their ability to keep Maryland roadways safe. In conclusion, MAD encourages this committee to advance HB 927 and give law enforcement and prosecutors the full ability to request search warrants in order to hold suspected impaired drivers accountable for risking the lives of Maryland residents by making the choice to drive drunk. MAD thanks you for the opportunity to submit our testimony before this distinguished committee. And again, I'm happy to discuss any of the above data if the committee would like more information. Thank you.
Marguerite Morris, please.
Yes, good afternoon. My name is Reverend Marguerite Morris. I'm with Community Actively Seeking Transparency and For Kathy's Sake, and I reside in Odenton, Maryland. I'm the mother of Catherine Sarah Morris. I'm a community activist working with impacted families. I'm here today because I support HB 927. Danshawn Wells died July 16, 2016. He was a bright, articulate, and loved child of Deontay. He was a brother of 5 siblings. There will never be true justice in his case. As a community activist, I sometimes use a service called Bit Verified. One day while talking to Danshawn's mom, I popped the driver's name into the search engine. It pulled up more than what we can see on the Maryland Judiciary case search. I was shocked because it showed that he not only had multiple driving infractions in the state of Maryland, but multiple out-of-state infractions. The list seemed to go on and on. How can that be? This child was struck and killed by the same alleged drunk driver. This little boy was hit by an SUV one evening while he was hanging out with his friends. Yet as this child lay dying in the street, no one administered that needed and critical test. That moment of opportunity for that test is long gone. And we will never know if it would have resulted in an alcohol concentration of 0.08 or 0.15 or nothing. We know this person was involved in a motor vehicle accident that resulted in a death. And he had multiple reckless driving offenses. But for this child's life, there was no lose of driving privileges, not even for one day. We can never recapture those precious moments in time in which those tests would have been administered. This is all about a window of time. Collectively, anything we can do to increase the opportunities for law enforcement to be able to do proper testing, we must do. When persons choose to drink or drug and drive, those persons are making a personal choice, but the persons they harm don't have a choice. So today, I support all those that will come before you and testify in favor of this bill. Anything we can do to help Maryland residents or persons across this country, because we set the example, is what we need to do as a state. Thank you, and please vote favorably for HB 927.
Thank you very much. Kurt Erickson, please.
Mr. Chairman, members of the committee, I'll just take 1 of the 2 minutes.
Mr. Erickson, you need to speak up.
Sorry, Mr. Chairman, members of the committee, my name is Kurt Erickson. I head up the nonprofit Maryland Washington Regional Alcohol Program. I'm just going to echo the sentiments, take 1 minute to echo those sentiments of the Maryland States Attorneys Association in support of this measure, which proposes to add specific language which would then allow law enforcement to apply for a warrant to draw a suspected impaired driver's blood when there's probable cause to believe that said suspect is impaired and has refused a breath or blood test. Such would counter any belief and/or practices of Maryland District Court judges that said bench shouldn't be issuing such warrants. For that reason alone, never mind the fact that 2019 bore witness to Maryland posting a nearly 30% increase in the number of alcohol impaired traffic fatalities that year, according to NHTSA. We support House Bill 927 and ask for your consideration of favorably reporting the same. Thank you.
Thank you very much. Delegate Bartlett, please.
Thank you, Mr. Chair. Thank you, Delegate Ericon, for supporting and sponsoring this bill. Ms. Griffin and Reverend Marguerite Morris, I appreciate you being here. And I'm sorry for your loss, and I'm so happy you were able to share your testimony. My question is for Mr. Coyne. And you mentioned an amendment, and I believe I didn't catch it very well. So I just wanted to make sure I understood. Is it for impaired driving as well? If you could just explain your amendment, that would be great.
Thank you, Delegate. The Transportation Article 16205.1 covers the administrative process of someone suspected of a DUI. The evidence portion is covered in the court's Article 10309. And the almost identical language says a person may not be compelled to submit to a test. It's also, in addition to being in 16205.1, which is present in House Bill 927, we also wanted to add the court's article, section 10309A, and also add the same language, or as required by a valid warrant, after the word article in 10309A1 little I, because that is the same language as the cross-filed bill, which is Senate Bill 559. So it's not substantive, it's just housekeeping, because we need the court's article to be consistent with the transportation article.
Great, thank you very much. I appreciate it.
Thank you. Delegate Watson, please.
All right, thanks. Quick question. So I'm interested in how the field test goes. I don't quite understand that. So if a person gets pulled over and they're suspected, I don't want to talk about drunk driving. I want to talk about drug driving. But they get pulled over and they get suspected of driving impaired. The officer would have to make a call to get a warrant to compel the person pulled over to submit to a blood test. Is that the way it works?
Thank you for the question, Delegate. I'll take this one. Typically a DUI, the officer has the observations of driving, then has the observations at the window. If they think the person they have reasonable grounds to have them out of the car, they take them out of the car, do the coordination test, which are those field tests you referred to. And typically they start with alcohol because that's more prevalent. So they try to do an intoximeter. As I think Ms. Stimson from MAD said, that apparently a third of Marylanders refused that breathalyzer. So then Chief Judge Morrissey apparently ruled that the officer at that point, because the person refused, the officer could not go to a judge and say, Judge, I want a warrant. I probably cause believe this person's impaired by alcohol or drugs. I'd like a warrant to have them submit a blood sample. The Chief Judge of this court ruled that was not permitted because of the language of the statute. And that would go for drugs as well. Suppose that a drug recognition expert, they blew double zeros on the intoximeter, but they're really acting whacked out. Something's going on. So the drug recognition expert evaluates them and says, from that expert's opinion, they're impaired by, say, opiates or some kind of narcotic drug. And then that drug recognition expert does the same thing. Will you consent to a blood draw? No. Similarly, that drug recognition expert or the arresting officer, according to the Chief Judge of the district court, could not go to a district court judge and ask for a warrant for blood to get a blood sample to determine whether or not the drugs are present in their system because of the language of the statute. So all it is it's clarifying. Our position is that language judges inherently have an ability to issue a warrant to get evidence if there's probable cause, but there is an interpretation by some judges that it's not. This simply clarifies it that yes, officers can go get warrants, notwithstanding that the person refuses to consent to take blood.
I thought this was an issue of what's considered intrusive and what's not. You know, breathalyzer test is obviously you just put your mouth on something and blow. Blood test is something totally different. And I just have a hard time seeing the side of the road, you know, somebody being pulled out of their car, put in the police car, roll your sleeves up. Now the police officer, you know, is going to draw blood, you know, and get a blood sample. Is that how it goes?
No, Delegate, that typically they go through the process that I talked to before. If they consent to give blood, and again, if it's a non-fatal accident, they can consent to give blood, and then the officer takes them to the hospital. A nurse under medical condition draws the blood. If they refuse to consent to do blood, some judges have said, well, even if the officer gets a warrant, you can't have the warrant wouldn't be. The officer would not be able to get a warrant to then take the person to the hospital because they initially, which happens in 1/3 of the time, apparently refuse consent. Remember, warrants are preferred, so that's the preferred method. But with the number of DUIs, unfortunately, it's not practical all of the time for officers to try to get warrants. They try for consent first.
Right. No, I get it. So if I get pulled over and I'm suspected of being drugged, and I absolutely refuse, under no circumstance are you going to get my blood. Are you saying there's a method by which that can be taken?
I would suggest that if you refuse, there's a form, a DR-15, it's an administrative form. If you refuse to give consent, the officer could go then get a warrant, and the warrant could allow him to take the hospital. You still physically could refuse, and the courts could consider that whether or not that's contemptible conduct, that whether or not violated a judge's warrant, which is essentially an order, whether it's contempt, or a jury might be permitted to hear that in your trial if you're charged with drunk driving or drug driving. The jury could and it's permissible whether or not the jury would hold that against you because you're hiding something like drugs, alcohol in their system, or there's a distrust for some reason with the officer that you felt that there's something going on that you didn't want to
I got it. I just thought there was a circumstance where you could pin somebody down and just physically take their blood. Okay, I got it. My last question is really just one for understanding. Can you define for me exigent circumstances?
So exigent circumstances, which has been ruled just because alcohol is evanescent or disappearing evidence in one system or drugs, that people metabolize it goes away. So typically, if there's exigent circumstances that the evidence is going to go away, sometimes officers can act without warrants to seize evidence. But because like this blood kit is so obtrusive that putting a needle in someone's arm, the warrants are preferred. And we have had situations where sometimes because they can't find a judge, they've looked and looked, and a fatal collision involving suspected drug impaired driving, they've looked and looked, they've called all the judges' numbers, they can't get a judge on the line. Sometimes they'll ask the nurse to draw blood anyway, and we would argue exigent circumstances if the person consented or to get the blood. So those would be exigent circumstances. Ideally, you get the warrant and then you have ability. But again, alcohol and drugs go out of one system. So as the time ticks by, the number goes down and the evidence goes away. And again, it's both for inculpatory and exculpatory. We want the most objective evidence for justice. So if the person at the time of driving as close as possible had something in their system and what level it was, we want that evidence to be presented to the fact finder. We don't want to lose that evidence and have it distorted by the loss of time.
I understand. Thank you very much. Thanks for the bill, Delegate Erickson.
Delegate Conaway, please.
Thank you, Mr. Chairman. Thank you, panel, for coming in. I think it's Mr. Cone. Is that, am I saying that correctly? Cone?
Yes, Delegate.
Okay, so how are you going to determine how much marijuana or THC is in somebody's system to make them intoxicated? How do you determine that?
So while there are no per se standards, I would rely on experts. So I would rely on a toxicologist or a pharmacologist to determine what levels there are. Some states like Colorado, which got into the recreational marijuana very early on, have some levels. I think Pennsylvania may have levels, per se levels for nanograms of marijuana or THC in one system. Maryland does not have those. So we would need an expert like a medical doctor, toxicologist, or a pharmacologist to testify. And it's individual, every person has different tolerances, height, weight, and those kinds of things, and how they metabolize substances. So we would need an expert to say whether or not the observed symptoms are consistent or inconsistent with impairment and what the levels are. So you would need some kind of scientific expert.
So you're telling me a person could consent for a blood draw if they are, let's say, high or whatever, but after a certain amount of substance, you can't consent to have sex. Is that right? In other words, on 2 drinks, 3 drinks, I've heard that you can't consent to have sex with someone. Somebody could say, I didn't consent, I was impaired. Now you're coming back and saying, if you had 2, 3 drinks or something where you had some pills in you, you can consent for a blood draw. You know what you're talking about? If you tell somebody on the side of the road that they can consent for a blood draw, does that mean they're going to understand that you're going to take them to the hospital, or do they think that the police is going to take it, or how's that going to work?
So in terms of the alcohol, the statute permits them to consent, and a court would evaluate that ability. So if the court found that someone couldn't give knowing consent, that would affect the admissibility of whether or not it was valid consent and whether or not that evidence should be admitted to court. I'm not going to get into the capacity for the sex offense or rape charges, but in terms of alcohol, currently the bill allows people to consent even if they're suspected of being impaired or under the influence of alcohol or drugs. So currently that allows it. A judge would evaluate that because the judge is the arbiter of what evidence comes into evidence, what evidence stays out of evidence. So the judge would regulate whether or not it was valid consent. And either way, a judge could issue a warrant notwithstanding someone's consent or lack of consent based on probable cause, reasonable belief that this person is driving while impaired by drugs or alcohol to get that blood sample.
Thank you very much.
Thank you. Are there further questions for the panel? Seeing none, we thank you all very much for testifying today. That concludes the testimony for House Bill 927. We thank you all very much. Now we're going to hear House Bill 1084 from Delegate Rose. Delegate Rose is going to be joined by Delegate Shoemaker. He is not going to be testifying. Delegate Shoemaker is here as to assist Delegate Rose with any legal questions that may come up in the consideration of this bill. We're going to go with 3 minutes for Delegate Rose, and then we will hear from those people in opposition. So Delegate Rose, if you're ready for 3 minutes, let's go ahead.
Thank you, Mr. Chair, and thank you, committee, for the opportunity today to introduce House Bill 1084. The intent of this bill is to shield small businesses, private schools, churches, and other nonprofit organizations that have already been hard hit by the COVID-19 pandemic from being further led dry by lawsuits resulting from innocent and minor noncompliance with the hodgepodge of the often confusing and contradictory state and county health orders issued during this pandemic. Currently, a violation of statute, ordinance, or executive order or administrative rule is on its face evidence of negligence. Without this bill, small businesses, private schools, and churches doing their very best to comply with all of the state, county, and local mandates would be at risk of having to pay to defend against these lawsuits for innocent and minor violations of health order issued again during this pandemic. This bill will shield private schools, churches, small businesses, and other nonprofits from expensive and time-consuming litigation by granting them immunity from lawsuits so long as their noncompliance with the myriad public health orders were not willful or due to gross negligence. Further, the bill shifts the burden to the plaintiff to prove that noncompliance was in fact willful or grossly negligent by clear and convincing evidence. Anyone who runs a small business or nonprofit can tell you that the cost of just defending a lawsuit can bleed them dry financially and put them out of business even if they win. Shifting this burden of proof and requiring a higher standard of evidence would discourage the filing of such lawsuits altogether, which is our hope. And I really do thank you for your time and consideration, and I ask for a favorable report on House Bill 1084. And I do appreciate my colleague and my favorite country lawyer to be here to answer any, I am not a lawyer, so he's here to answer any questions that I might not be able to, and I appreciate that. And thank you for that consideration, Mr. Chair.
Is that favorite country lawyer or favorite simple country lawyer? Because
Simple.
I never can get it straight. I've heard it both ways. Questions for Delegate Rose or the simple country lawyer? With due respect. Delegate Cox.
Thank you, Mr. Chair. Well, I would be remiss if I didn't allow our favorite country lawyer to wax eloquent for at least one question. Thank you, Delegate Rose. This is a great bill. Obviously, we do have a lot of concern for our small businesses and our schools. I have a similar teachers protection bill, but I wanted to ask, this is, we're not talking about businesses that weren't watching out for their folks, right? I mean, we're talking to people who just like, for instance, would post, the sign and warn people, but if they don't necessarily police every person in the place and browbeat every person that walks to the door, they can't be sued if they took reasonable steps to warn and to notify people to comply. Is that kind of how this is focused?
You want me to answer that, Delegate Rose?
Sure.
Yeah, so I mean, it's important to note, I mean, this is not a blanket immunity type bill. This is a limited immunity bill. Folks are not shielded from protection in instances where they acted willfully or engaged in gross negligence. And, gross negligence is defined in your fiscal notes. I direct your attention to that. So it's not an outright shield.
Thank you. Appreciate it.
And if I would just add just one small comment, really the main focus of this bill, it's not, not all the big, it's not the big guys. They all stayed open, during this, a lot of the shutdown period. This is really to help protect, the small businesses, your brick and mortar restaurants, churches, nonprofits, who, a lot of them have been hanging on and suffering financially. And this is to provide some protection for them, legally, so that they are not, hanging on by a thread, drug through lawsuits that, they really did not have any intent to harm anyone.
Are there further questions? Okay. Are there further questions for the?
Chair, I have one quick.
Oh, go ahead. Go ahead.
I'm just going to one real quick follow up. Thank you, Mr. Chair. In the business community, do we have support of the small business community for this bill?
I believe they have signed up I believe some of them are either here today or did submit written testimony. We have the Retailers Association, the Restaurant Association, the Maryland Chamber of Commerce are a few that pop to mind. I don't have the full list right in front of me currently.
All right, now, are there further questions for this panel? Seeing none, we thank you both very much.
Thank you, Mr. Chairman.
Thank you so much.
No problem. We'll go to those in opposition now. John Green, David Wildberger, George Tolley, Kelly Donahue for 2 minutes each. Is Mr. Breen here? Mr. Breen? Mr. Wildberger?
Hello.
There we go. For 2 minutes, please.
Good afternoon, Mr. Chairman, Madam Vice Chair, and committee members. This is the fourth or fifth bill that tries to give immunity retroactively. And as with all of the others, some better intention than others. And no matter how well-intentioned, you can't violate the Maryland Constitution. The Maryland Constitution and 180 years of Court of Appeals precedent say that once a cause of action accrues, it becomes a vested right. Now, when does it accrue? It accrues when the harm occurs and you know or should know that you have an action that you should investigate. That's what the statute of limitations says. That's why you have 3 years after the injury, or 5 years in some circumstances. Once a cause of action accrues, it becomes a vested right. Vested rights are protected from retroactive abrogation or impairment by Articles 19 and 24 of the Maryland Constitution Declaration of Rights. It's a case called Dua versus Comcast and a second case called Prince George's versus Longton that both, Dua back 2002, Longton 2011, evaluated this issue extensively. There's 180 years of precedent that says that you simply cannot retroactively take away someone's accrued cause of action. It's black letter law. And I don't think you're going to hear anybody who's going to contend otherwise. Therefore, the bill as written is unconstitutional. There are other problems with the bill, including that it's very vague. It says if you have to comply with guidance. Is that state guidance? Is that federal guidance? Is that local guidance? Is it all of them? What if they're in conflict? And it's not going to limit litigation because all of this is going to be litigated anyway if somebody sues, which they're not going to. And I have other colleagues who are going to cover all of that. My main point to you is this is another bill, and I'm not going to belabor it because you've heard this, I think 4 times now. This is clearly unconstitutional. You cannot retroactively take away a vested cause of action, a vested right. Thank you so much.
Thank you very much, Mr. Wildberger. Thank you very much. We'll go to George Tolley now for 2 minutes.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. I'm George Tolley. I'm here on behalf of the Maryland Association for Justice, urging an unfavorable report on House Bill 1084. The immunity, the problem with that this bill seeks to address really isn't a problem, as it turns out. More than 380,000 Marylanders have been diagnosed with COVID since last March. And according to the COVID-19 litigation tracker relied upon by the Chamber of Commerce, the Chamber of Commerce, there have been a total of 2 COVID transmission related cases filed in Maryland. One of them doesn't even involve somebody getting COVID. It was a fear of COVID case filed in federal court against the University of Maryland by a physician whose immunocompromised status, she alleged, was not adequately accommodated by the hospital. What the bill doesn't do is address what really are the overwhelming number of lawsuits arising out of COVID, which are businesses suing other businesses. Overwhelmingly, that's what Maryland courts are dealing with right now is contract claims, claims that contracts were not fulfilled or that contracts were violated because of COVID or because of or related to COVID, they couldn't be carried out. For some reason, the business community doesn't have any problem with all of those lawsuits and doesn't want to prevent those lawsuits from going forward. What they want to do is prevent ordinary people who are victimized by unreasonably unsafe conduct, to the extent that happens and that they get COVID from it. Those are the folks that they want to freeze out of court. And those are the only folks they want to freeze out of court, which would be wrong. And because of all of that, I ask for an unfavorable report. Thank you very much.
Thank you very much. Kelly Donahue.
Good afternoon. Thank you, Mr. Chairman, Madam Vice Chairman, ladies and gentlemen of the committee. Thank you so much for your time today. My name is Kelly Donahue. I'm an attorney. I'm testifying with the Maryland Association for Justice in opposition of House Bill 1084, and I would ask for an unfavorable report. As you heard from my colleague, George Tolley, this legislation is unnecessary. There is no influx of litigation on behalf of constituents asserting that they have transmitted or received COVID from a small business. It's just not happening. But the crux of what I want to explain today is, we've heard from proponents of the legislation that this bill is necessary to the viability of keeping these businesses in business. This bill is not going to serve that objective. This bill is going to serve the opposite of that objective. The bill does not stop lawsuits from being filed. I don't expect the floodgates to open or for lawsuits to be filed, because these are not good lawsuits to file for many reasons that we can certainly talk about and I can't address in 2 minutes. But the truth of the matter is the bill doesn't stop lawsuits from being filed. So if a lawsuit is to be filed, these businesses will still pay their insurance deductible. And the bill itself will lend itself to protracted litigation and much more expensive litigation than we otherwise would have seen. We will see parties spinning their wheels over what is meant by guidance. Was guidance followed? We will see parties spinning their wheels and spending extensive amounts of money over, was the defendant's conduct negligent? Was it grossly negligent? Was it malicious? None of those things are going to help these businesses. It will hurt them. The system as it is currently written, the tort law system, works. And it's there and it's for a reason. And this immunity legislation does not help that system. It makes it worse, and it makes it worse for these businesses. I think lastly, it's really important to keep in mind, and Delegate Rose mentioned this, we have small businesses, no doubt they've been impacted by COVID. Everybody has been impacted by COVID. One of the overarching common goals we all have is to jumpstart the economy. And immunity legislation, whether it's intentional or not, comes with a message to the public of no accountability. And if we're really serious about jumpstarting the economy, we need to send a message to our citizenry that there is accountability on the behalf of businesses and schools, that their children are going into safe environments, that restaurants, hotels, et cetera, are doing the right thing, for the public to have the confidence to want to go back out and spend their money. So for those reasons, I would ask for an unfavorable report on this bill. Thank you so much for your time.
Thank you. Is John Breen here? John Breen? Let's see him. All right, we're going to take questions. Wait, there he is. John Breen. Please turn the YouTube link off. You need to close that window, turn that off, and then turn on your video.
So for those reasons, I would ask for an unfavorable report on this bill. Thank you so much for your time.
Mr. Breen?
Yes, I'm here. Can you hear me?
You need to turn off the YouTube link in the background. If you did that, you need to turn on your video, please.
Now, can you see and hear me?
We cannot see you, and we can still hear the YouTube link in the background.
Thank you, sir. You're a great coach. I'm Jack Breen. I'm an attorney in Maryland. It's my pleasure to meet you, sir, and I want to thank all the members of your committee and their staff.
You need to close the window that has the YouTube link on it.
Can you hear me?
I can hear you. You have the YouTube link on perhaps a computer somewhere else with the speaker on.
I'll testify without the video. Can you hear me if I eliminate the video?
You're fine with the video. That's not the issue. Just go with it. Just go ahead and testify to the committee and try and ignore what's going on in the background.
Thank you, sir. I'm Jack Bean. I'm an attorney in Maryland. I will support the arguments made by Maryland Association for Justice, and I'll just mention them briefly. While Mr. Breen is figuring this out, for those people who are watching this, a very kind and gentle reminder from our chairman. When you're waiting to testify before the committee, you can listen to us on the YouTube link. But after you're admitted to the Zoom room, you have to close the window, completely close the window on the YouTube link so that you don't get feedback from the YouTube link and it plays in the background when you yourself are testifying in the Zoom. Unfortunately, Mr. Breen has just knocked himself off of the Zoom. So we'll get back to him in a moment, and I don't mean any disrespect to anybody, but we'll take some questions and let him get situated. Delegate Conaway.
Thank you, Mr. Chairman and members of the committee and people came to testify. My question is, on page 2, line 17, it says a public or non-public school. So does this mean if a school, public school, ask the teachers to come back and somehow the teacher catches COVID, then there'll be no civil liability? How does this work?
If I may, Delegate Conaway, that's a very good point. Unlike House Bill 508, which you heard about 3 or 4 weeks ago, this bill doesn't make any distinction. It would prevent, at least as written, it would prevent, I would think, even workers' compensation claims brought by employees who come into these premises to work. The owners and the persons who have the premises that are being protected, they're not liable for any actions or any failures to comply unless they were acting maliciously or with gross negligence. The teachers would not have the benefit of workers' compensation, and the sales clerks and the people working in the warehouses wouldn't have the protections of those laws either, at least according to the bill.
Thank you very much.
Are there further questions for the panel? I think it is safe to say that Mr. Breen was going to say me too. I suspect that Mr. Breen is also going to be coming back, and he is, for House Bill 1106. We will give him another chance on the next bill, with no disrespect to Mr. Breen. Seeing no further questions from the committee, that concludes the testimony on House Bill 1084. And we will now move to Delegate Weibel and House Bill 1106. He is testifying along with Grayson Wiggins. So we'll hear from both of them. 3 minutes from Delegate Weibel, 2 minutes from Mr. Wiggins. And Delegate Weibel, whenever you're ready, we will hear from you for 3 minutes.
Thank you, Chair Clippinger. Can you hear me?
Yes.
Awesome. Good to be with you, Chair Clippinger, Vice Chair Atterbury, and honorable members of the Judiciary Committee. I am pleased to present House Bill 1106. I apologize for prolonging your agony on this subject, but many of us have been approached by many different constituents asking for such relief from potential COVID lawsuits. As I just heard that you heard, there are obviously many differences of opinion in regards to whether or not these lawsuits materialize. For whatever reason, there are many that believe they will. I just ask the committee that you please look favorably upon some sort of COVID liability relief for Marylanders. My bill is a little bit different than the one you just heard in that it basically applies not just to businesses, but it does apply to basically all mail earners, all premises, including your personal residence. It's not restricted to just a business. And then it also is a little bit different in the bill that you just heard, and that if an individual acts in good faith and following health guidelines, they would not be held civilly liable versus the bill that you just heard use the standard of gross negligence or with malice. So again, I just simply ask that you look at some sort of legislation favorable for COVID relief, and whether that's House Bill 1106 or not, that's up to your committee, but I simply ask for a favorable report, and thank you.
Thank you very much. We don't see Mr. Wiggins.
I believe he was held up in our Housing and Real Property Subcommittee, so he may not have been able to make it.
All right, I'm sorry to hear that. We will, I think they may have put something in writing as well, though, so that would be fine. All right, so.
Aaron Greenfield, I think, was going to testify in his place. I don't know if he's in the waiting room.
Is Aaron Greenfield in the waiting room?
I just got a note that he wasn't left into the meeting yet, so.
Okay, we'll let in Aaron Greenfield, please. Testifying on behalf of the Maryland Multi-Housing Association. Mr. Greenfield, please, for 2 minutes. You need to turn on your video, please.
Sorry, Mr. Chairman, my camera.
Well, go ahead, Mr. Greenfield, then. We'll just hear from you, please, for 2 minutes.
My apologies for the confusion. Mr. Chairman, members of the committee, Aaron Greenfield here on behalf of the Maryland Multi-Housing Association in support of House Bill 1106. Based on our interpretation of this bill, the legislation allows lawsuits to go forward, but provides an important defense that may be weighed by the judge. Our members have consistently, since the pandemic did begin, followed multiple orders, did all the right things, and believe that this bill is an important protection. And at the same time, for those bad actors that aren't doing the right things, then this immunity would not apply. For those reasons, we respectfully request a favorable report on House Bill 1106.
Are there questions for the panel? Questions for the panel? Seeing none, we thank you both for testifying today. Appreciate it very much. We'll hear now for the opponents to the legislation. John Breen, David Wildberger, George Tolley, Kelly Donahue. See Mr. Wildberger first, so we'll hear from Mr. Wildberger, please, for 2 minutes.
Good afternoon once again, Mr. Chairman, Madam Vice Chair, members of the committee, David Wildberger, Maryland Association for Justice. Not to belabor the point too much because you've heard these arguments 4 or 5 times now. You can't take away a vested right retroactively. You simply can't do it. You can do it prospectively, but you cannot take it away retrospectively. That is against the Constitution of Maryland, against the Maryland Bill of Rights, and as I say, 180 years of jurisprudence. And anybody's interested in the sites, I'll be happy to come to them. One of the problems with this bill is that, again, it calls for good faith to follow and enforce on the premises all federal. What is all regulations? What is good faith? Good faith, to prove a lack of good faith, you have to prove bad faith. And to prove bad faith, you have to prove an intent. Bad faith is the opposite of good faith. It is not simply bad judgment or negligence. It implies a dishonest purpose or some moral obliquity and a conscious doing of wrong. So under this bill, unless somebody intended to give somebody COVID, they would be immune. I don't think that's what's intended. That quote is from Rite Aid Corporation versus Hagley. I can give you the site. In short, not to take up any more of your time, you've had a long day. This bill is unconstitutional in its retroactive application. And I would urge you to vote it unfavorably. Thank you so much.
Thank you very much. Appreciate coming short of the 2 minutes. We do have another 100 witnesses that we have to hear before we're done tonight. Not kidding. George Tolley.
Thank you, Mr. Chairman, Madam Vice Chair. George Tolley on behalf of the Maryland Association for Justice, asking for an unfavorable report on House Bill 1106. Just to address what the proponents said, the defense requires good faith or gives a good faith defense. And as Mr. Wildberger suggested, even businesses that aren't doing the right thing are going to be able to use this to defend themselves because the plaintiff has to prove such a very high burden. So we're not letting only the good actors off. We're letting everyone off. To anticipate Delegate Conway's question, there is no exception in this bill either for workers' compensation or for employees who get COVID. The cause of action and the civil liability appears to apply to any claims that employees or workers would have. And lastly, just to repeat, or I'm not going to repeat, I'm going to adopt everything I said about 1184, hopefully, that can get into this bill file as well. And thank you all very much. I'm sorry to hear about your long afternoon and evening. Please vote unfavorable. Thank you.
Thank you very much. Kelly Donahue for 2 minutes, please.
Thank you, Mr. Chairman. I'll stay short of 2 minutes as well in the interest of time. Ladies and gentlemen, my name is Kelly Donahue. I'm an attorney. I'm testifying with the Maryland Association for Justice, and I would ask for an unfavorable report on House Bill 1106. I'd like to incorporate my testimony from House Bill 1084 and just briefly comment. One of the things that the proponent raised in support of this legislation was an acknowledgement that this legislation will not stop lawsuits, but that it will provide an important defense. When you contrast this piece of legislation, 11106, it refers to a good faith standard and compliance with health guidelines. Contrast that with 1084, where we talked about negligence versus gross negligence versus malice. And we talked about a completely different standard. We talked about guidance as opposed to health guidelines. The varying terms and the inconsistencies in these very pieces of legislation alone really underscore what I was trying to communicate earlier. They're just going to lend themselves to more expensive litigation. I don't anticipate these lawsuits are going to be filed, but to the extent that they are, these kinds of bills will just cost more time and more money in the litigation process, and that doesn't help anybody. So I would ask for an unfavorable report, and I wish you all the best of luck with your upcoming testimony, and I hope it goes speedy. So thank you so much.
Thank you very much. We'll try him again. John Breen. Mr. Breen. Okay, we're going to try this again. John Breen for 2 minutes.
Can you hear me, sir?
Yes, go ahead.
I apologize. There was a computer behind me that was on in front of the laptop. You were correct.
All right.
I'll be brief. My arguments have been made by the other parties. And I apologize to all the members of the committee and my colleagues who've had to put up with that back beep. I incorporate the arguments about immunity is a bad idea because it serves to protect the wealthy rather than the person who has suffered the injury. These are compensatory claims for injuries suffered by people who may or may not have health insurance, who may have medical bills, hospital bills, unemployment problems, and may have permanency as a consequence. And they should be entitled, as in any other negligence case, to bring that claim to a judge or to a jury. Good faith is a bad standard. And if it is a standard, it's just a standard that should be addressed at the court before the judge and the jury and not be imposed upon them by the legislature here. I think that the application of this standard injures the person who's seeking compensatory damages and invites litigation after the trial. It doesn't make it less occur. And the statute, as I read it, applies to protection to all corporations, not simply the small and the churches and the schools, et cetera. I'll be short, and I thank you for your forgiveness for my computer malfunction here.
That's all right.
I'll be remembered for the wrong reason. I apologize for that.
That's all right. Does anyone have any questions for this panel? All right, seeing none, thank you all very much. That concludes the testimony for House Bill 1106.
Thank you.
As I mentioned in the chat, and I will mention again now, we have 3 bills remaining, which honestly, considering the number of bills we've already taken care of today, is kind of remarkable. However, they have 38, 43, and 21 witnesses. So the plan right now is to take the Vice Chair's bill, House Bill 750, and we will hear this bill, then we will take an hour break, then we will hear the remaining 2. Further, there are a number of people on the panels for each of these 3 bills for whom English is not their first language. We're going to try something for the first time, maybe in the legislature, not sure, but certainly first time in the Judiciary Committee, where, as the committee knows in the past, we've had translators who have translated and translated for the different witnesses in the past who can't speak English. What we have been able to do for today's hearings, however, is they are going to speak, and they're going to speak in their native language, and we're going to put up on the screen the translation of what they are saying so that everyone can read the translation as they are speaking it. So we will not be going back and forth between them and an interpreter, but we will be hearing from them directly, and they won't have to stop and go. We're hoping that this saves a little bit of time, and we're hoping that this makes it a little bit easier for them to testify. If you have questions for people for whom English is not their first language, then that's perfectly fine. Then we'll be going, of course, back to the regular system where there will be some translation and there will be a little bit of a delay. It's fine. All right, with that lengthy and excruciating perhaps explanation, we'll now go to the witnesses on the bill. This is the Vice Chair's bill, Delegate Atterbury. She's going to testify for three minutes. We are going to hear, in order, from Cristobal Gomez Villafranca, Eric Lopez, Paul DeWolf, Lisa Dornell, and Nick Katz. That will be the first panel. Then we will start taking panels from there, and we'll go the best that we can. There will be a translator available, and that will be Gabby Roque. So to that end, let's begin now for 3 minutes with Delegate Atterbury, and then we will go from there. The Vice Chair.
Thank you, Mr. Chair, and good evening, members of the Judiciary Committee. I am here to introduce and ask for your favorable report of House Bill 750, universal representation and right to counsel for immigrant detainees. And I would like to thank the panel for being here and all those that are going to testify in support of the bill that will follow. So this is a very simple bill. What it does is it provides legal representation for those Maryland residents facing deportation. And it applies to Maryland residents and also Maryland residents that are currently located outside of the state, and that would be covered by a stipend. The bill does need to be amended. It has been cross-filed by Senator Hedelman, and since the initial thought behind the bill, it does read Office of the Attorney General, but we have, and you will hear from the public defender, Mr. DeWolf, and we have worked with his office, and they are able to take on the responsibilities under this piece of proposed legislation. So what the Office of the Public Defender would do would coordinate services and host the program, and maybe, depending on their capacity, provide a representation as well. So why do we need representation for immigrant detainees? Because most of these folks are indigent, and they face very serious consequences, including deportation and banishment, permanent separation from their families and children, loss of liberty through detention in jails, and if they face deportation, we're talking death, torture, prosecution, and the like in their particular country of origin. I do want to also mention that an amendment, my office did request an amendment and we're still waiting on it, probably because the office is working on all those policing amendments. But there was an amendment that was worked out by Senator Hedelman with my senator, the chair of Budget and Tax, that would add for fiscal year 2023 and each fiscal year thereafter, the governor shall include in the annual budget bill an appropriation of at least $8 million to the program under the subtitle. And the money would be supplemental, not supplant the funding that is already received by the public defender. And that would be for the program. And with that, Mr. Chair, I will conclude and let the panel proceed.
Now I got muted. We're going to go to the first person to testify, and they'll testify for 2 minutes. And that is a person who will need translation and is near a bird. Paul Gomez Villafranca. And so this will be our first attempt. And the testimony will appear there on the screen.
Say hello.
Hello, how you doing?
That's great. Senor Villafranca, Gomez Villafranca, please begin.
Yes, mi nombre es Cristóbal Gómez Villafranca. Soy residente de Baltimore, Maryland. Como cliente anterior de Clear Collusion, escribo para expresar mi apoyo de la ley HB 0750. Soy padre y proveedor principal de 4 hijos de 19, 17, 13 y 12 años. Adopté a los 2 mayores cuando me casé con mi esposa. Los 4 hijos son ciudadanos estadounidenses, mi esposa también. Somos parte de una iglesia pentecostal. Llevo 7 años yendo a la iglesia, trabajo en la construcción. Estoy tomando tiempo de mi trabajo para poder hablar de la importancia de esta ley. He vivido en los Estados Unidos durante 17 años. Vengo de Honduras, salí de Honduras después del huracán Mitch. Mi ciudad fue destruida por el huracán. Me quedé sin casa, perdí todo mi dinero. Dejé a nuestra comunidad vulnerable y las pandillas comenzaron a amenazarnos. Las pandillas se estaban aprovechando de mí y de mi familia. Fui detenido por ICE en noviembre del 2019. Estuve detenido durante 2 meses. Fue una experiencia terrible. Me estaban esperando fuera de mi casa. Habían recibido mi información del DMV. Mi esposa y mis hijas estaban ahí y estaban llorando mientras me obligaban a tirarme al suelo y me llevaron. Ser detenido fue muy pesado para mí, mi familia, mis hijas. Estaban teniendo dificultades en la escuela. Mi esposa estaba deprimida. Me dolió el corazón cuando venían a visitarme. Me veían encerrado, lloraban todo el tiempo. Mi familia estaba buscando un abogado y nuestra comunidad en la iglesia nos estaban ayudando. Un abogado que encontramos por nuestra cuenta nos rechazó y nos dijo que nuestro caso no valía la pena seguirlo. Pero los abogados de Clear Collusion no me rechazaron. La abogada asumió mi caso. Sentí que podía respirar de nuevo porque sabía que alguien había ahí para ayudarme. No sé qué habría pasado a mí y a mi familia si no tuviera un abogado. ICE me siguió presionando para que firmase mis documentos de deportación, pero les dije que no podía abandonar a mi familia. Cuando estás encerrado no te dicen nada sobre qué está pasando en tu caso. Ni siquiera sabía lo que era una visa U. Había estado trabajando con otra organización que se suponía que estaba manejando mi caso de inmigración. Nunca me respondieron, nunca hicieron nada de mi caso. Durante 5 años perdí miles de dólares con ellos. No había más esperanza para mí. hasta que encontré a mi abogada. Ahora había alguien que conocía las leyes y sabía cómo pelear mi caso en la corte. La gente de mi comunidad no tiene la experiencia, ni siquiera sabemos cómo hablar con el juez. Les pido que consideren lo
Senor
importante.
Gomez, please, por favor. He needs to finish up, please.
Finish. Finish.
Okay, finish.
All right, we see the rest of his testimony. I don't mean to be rude, but we're going to try and keep people to 2 minutes during this time. We'll go now to Eric Lopez, please.
Eric Lopez, adelante.
Thank you, Chair, Vice Chair, members of the Judiciary Committee. Cristobal's story is not singular. This isn't a rare exception that Cristobal is talking about in terms of the experience that detained immigrants have in this immigration system. It is a far too common scenario, and it illustrates exactly why HB 750 must be passed in the state of Maryland. It is because of what is at stake. Cristobal lost his liberty. He faced potential permanent banishment from his home, separation from his 4 U.S. citizen children, his U.S. citizen wife, his community, his religious community, his employment. These are all the things that were at stake when someone, and many like Cristobal, find themselves detained by ICE and ICE custody. Marylanders here in Maryland and residents of this state deserve the opportunity to have legal representation before their immigration proceedings. Immigration law is incredibly complex. It has been compared to bankruptcy law and its complexities. Immigration attorneys themselves struggle to understand the labyrinth of immigration law. And in immigration custody, it finds themselves in the precarious position of having to navigate a complex labyrinth of laws in a foreign language, far away from one's family and where access to counsel is limited. So why implement this statewide? Well, it's because we already have 2 examples here in Maryland, in Baltimore City and Prince George's County, that are beacons of hope for our immigrant residents and our immigrant Marylanders, in that we have successful legal representation programs, such as the one that HB 750 proposes statewide, at the local level. These programs are no longer pilot programs. They're well established and they have proven successful track records. You may be aware that unrepresented immigrants have almost a 0% chance of obtaining a successful outcome at trial in their cases. With the assistance of legal representation through these programs, we have seen here in Baltimore City and Prince George's County a success rate at trial over the course of the entire span of the years of the programs in excess of 70%. Now, when we're looking at cases that are successful at trial over the last year, we're talking about a success rate of about 100%. This has consequences for families like Cristobal's. And
Mr. Lopez, if you please would begin to wrap up.
The Office of the Public Defender is perfectly suited with its infrastructure and its relationship with immigration nonprofits and community organizations with referrals. HB 750 is also a racial justice bill. Please pass it. Thank you so much, and I'm happy to answer any questions you may have.
Thank you very much. We'll go now to the Public Defender, Paul DeWolf, for 2 minutes, please.
Thank you, Mr. Chairman, members of the committee. As indicated, my name is Paul DeWolf. I'm the Public Defender for Maryland. The Office of the Public Defender is honored to be designated as coordinator of the Maryland Right to Counsel in Immigration Proceedings program established by House Bill 750. We strongly support the bill. This program is urgently needed to protect vulnerable indigent Maryland residents and their families. An estimated 600 Maryland children per year are at substantial risk of permanent separation from their parents because of ICE's enforcement action against those parents. Many ICE detainees had decades of productive work history and peaceful family life in Maryland. In terms of the right to counsel, the Vera Institute of Justice reports it is nearly impossible to win deportation cases without the assistance of counsel. Only 5% of cases were won between 2007 and 2012. They did so without an attorney. 90% of successful cases were represented. An appointed lawyer to out-state detainees would serve only indigent Maryland who are not otherwise represented by counsel. It's important to note that this program would not assist detainees who are able to hire private counsel. To provide high-quality representation, OPD, acting as coordinator, will assign indigent detainees to designated organizations whose staff has the expertise and the demonstrated capacity to provide high-quality legal representation to these quite vulnerable individuals. Now, OPD is the appropriate entity to be the coordinator of the program. We have a client-focused infrastructure that is long established and functioning throughout Maryland, including every part of the state where ICE detains immigrants. Similar programs operate quite successfully in other parts of the country. Offices throughout, including Atlanta, New York, Alameda County, California, and other locations.
Mr. DeWolf.
Our immigration division already works collaboratively with these organizations. So for the reasons stated here and laid out in our written testimony, we strongly urge a favorable report on House Bill 750. Thank you very much.
Thank you very much. Lisa Dornell now, please, for 2 minutes.
Good afternoon, Mr. Chairman, Madam Vice Chair, and members of the committee. I am Lisa Dornell. I'm a retired United States immigration judge who served for 24 years, during which time I presided over hundreds of cases. And I saw firsthand how, without legal representation, non-citizens like Mr. Gomez, who you just heard from, face the prospect of deportation and a possibly permanent separation from their Maryland families and communities. As an immigration judge, I was acutely aware of the imbalance in court proceedings where non-citizens were unrepresented and had to face as an opponent the trained and skilled lawyers from the Department of Homeland Security. It was a situation that felt as jarring as it did unfair, particularly given, as Mr. Lopez explained, the complexity of our immigration laws. While as a judge, I was able to advise unrepresented non-citizens of apparent relief from deportation, but the law doesn't permit judges to advocate. That's not the appropriate role for an independent arbiter. There simply is no adequate substitute for appointed legal counsel, because you heard the testimony of Mr. Gomez. Legal counsel makes a difference. Immigration judges are in a unique position to assess who is eligible to remain in the United States or not. But judges can't make decisions on applications and arguments that are not presented because people are unrepresented. Appointed legal counsel would ensure that all pertinent facts are presented so that every case can be heard fairly and fully. House Bill 750 represents an opportunity to enhance the promises of due process of law. It presents an opportunity to mitigate the effects of over-policing and prosecution of Black and brown people who end up in immigration court proceedings at a disproportionate rate. And the bill offers protection to Maryland family members who are United States citizens who get left behind when non-citizen husbands and fathers and mothers and wives are deported. I urge you to support this bill, and I thank you very much for the opportunity to be heard.
Thank you very much. Nick Katz, please, for 2 minutes.
Thank you very much, Chair, and especially Vice Chair Atterbury for sponsoring this important piece of legislation. My name is Nicholas Katz. I'm the legal director at CASA. CASA is the largest membership-based immigrant rights organization in the Mid-Atlantic region with more than 90,000 members. And I'm happy to testify today in strong support of House Bill 750. Every year, CASA conducts legal consultations with hundreds of Marylanders who have been impacted by immigration detention, including many who are detained here in Maryland, as well as many more who are detained out of the state. Sadly, CASA does not have the resources to provide representation to even a tiny fraction of these individuals, meaning that they have to fight their cases alone from behind bars in most cases. The majority of these individuals end up being deported, even if they have a valid claim to relief, because they cannot articulate it. As you've already heard from Immigration Judge Dornell and others, the complexity of our immigration system, as well as language and cultural barriers, make it almost impossible to win your case without the assistance of an attorney. House Bill 750 helps to correct this imbalance in several ways, including by providing access to counsel to these individuals, crucially, but it also provides for community support, for organizations in the community to go and do know your rights presentations, to educate individuals about how they can access counsel, to ensure the connection with the attorneys and the support services for families and communities impacted by detention. Providing individuals who are denied their liberty with access to counsel is a matter of fundamental fairness and comports with the due process principles that form the foundation of our justice system. Beyond being morally correct, however, it's providing representation to these individuals is good public policy. Representation alone is not enough to undo the decades of systemic oppression faced by immigrants in the United States. Immigration Judge Darnell mentioned the disproportionate impact on Black and Brown communities. There's more that has to be done, including passing the Trust Act and dignity not detention, which we'll discuss later today. But this is an important step in defending immigrant Marylanders, and we urge a favorable report on House Bill 750. Thank you very much, Chair.
Thank you. We're now going to take questions for the committee. Again, if you have a question, in this case for, I think it was Mr. Gomez. I apologize if I've got that. No, that's correct. From Mr. Gomez, we do have a Spanish language interpreter. You should, however, direct your question clearly to Mr. Gomez so that we know, so that the Spanish language interpreter can know that they have to pass that question on. We have questions from delegates Moon, Fisher, and Williams. We'll start with Delegate Moon.
Thank you, Mr. Chair. Just briefly, this is a question for Mr. Lopez, I think, was talking about representation programs in Baltimore and Prince George's. And I guess I'm curious what happened as a result of those programs, and also how does that work with the bill? Do those just become the designated programs, I guess, contemplated in the bill?
So with respect to your second question, the bill does take into account that there are these programs in existence and that have been here, right? And so the way that it does that in terms of the statutory language is it would take the funds that that jurisdiction would otherwise get from the statewide program, and it would receive those funds for that program, assuming it's substantially similar in terms of the scope of representation, and they are. In this context. So those programs would continue if HB 750 were passed statewide. In terms of what happened to these programs, they're still in effect. The Prince George's County program is actually now, with the help of the Immigrant Justice Court and an infusion from that program, now actually representing true universal representation in that jurisdiction, meaning every single income eligible resident of Prince George's County is afforded a free legal representation through this partnership with the CARE Coalition, IJCs, the Immigrant Justice Court, and the county itself. Baltimore City as well continues to operate and funds detained deportation defense program that has been in effect since 2017. And these programs are still operating. The CARE Coalition is still representing individuals from those jurisdictions. We still work with our partners, some of whom are here on the call with us, such as CASA, for example, to be mindful of community referrals, right? And situations where families need to seek an attorney, right? And we all work as a network here, as well as the Office of the Public Defender, to identify these individuals and provide legal representation.
All right. Just as a note here before I go to further questions, the next panel of 5 will be Baxt, Lazar, Anobil, Silver, and Guerrero. Then we will go with the remaining 6 Spanish speakers: Miranda, Guevara, Rivas, Maldonado, Juarez, and Morgan Sanchez. Just giving that as a, oh, and Jose Amaya. So we'll hear from them, not the next panel, the panel after that. Just giving people a sense and giving that heads up for the translation people as well.
All right, now Delegate Fisher, then Williams, then Grammer. Delegate Fisher.
Thank you, Mr. Chair, and thank you, Vice Chair Atterbury, for bringing this important legislation, as you do with so many other topics. I wanted to direct my question to Judge Dornell. I wanted you to sort of help us. Some of us have not been in an immigration court or been an attorney or a party in any of those cases. Could you speak a little bit to more specific examples on how legal representation can help, what it actually looks like, and what you've experienced in your courtroom on those outcomes, specifically for us to get a sense for our residents that would be utilizing a program such as this?
Sure, I can give you some pretty good examples. I mean, there have been people who have appeared before me who have not been on my docket, and it was very puzzling. And I asked the court staff who these people were. I asked the people why they were before me, and one lady explained to me that God had sent her to me. And I'm thinking to myself, I don't have enough cases. Now God is sending me cases. So what do you do when God sends you cases? I called Catholic Charities. Unfortunately, Catholic Charities was able to send someone over to assist this person. Subsequently, there were strict prohibitions for ethical reasons that against judges picking up the phone and calling for counsel. I was recently on a panel with the American Bar Association, and there was a former prosecutor who is now a volunteer to assist people in detention on the southern border. And she described the case that she volunteered for. It was the case of a gentleman who had filled out his application by himself. He was not an English speaker, so his application was incomplete. And it simply explained that he couldn't return to his country because he had been beaten multiple times by the police. She interviewed him, she sat down with him, had private conversations with him. She reached out to his family members abroad and asked them for affidavits to support his claim. Now, this man had gotten the only advice he could get, which was from the other detainees who told him, tell the judge you were beaten. The lawyer got an affidavit from her client's father, who explained, my son has repeatedly been beaten by the police. My son is gay, and in my country, if you're gay, they will kill you. People who aren't represented have no idea what information is important to present to the judge. They don't know what witnesses to call. They have no access to expert witnesses who could make the difference between their cases being granted or denied. They don't know what the court rules are. And so many times the documents that they submit are rejected by the clerk's office before their information even gets before the judge. It's just a completely unlevel playing field, and justice requires that the playing field be leveled by providing counsel to these people.
Mr. Chair, would you indulge me with a quick follow-up?
Sure.
This might be hard for you, Judge, but in a regular docket for in your everyday when you're on the bench, how many folks would you say were unrepresented that you saw on a jail? If you could give us an estimate from what you recall.
It really depends on the day, on the docket. When I was handling detained dockets, it could be, that 95% of the docket, didn't have a lawyer. They were all picked up in the same ICE raid. And what would happen? The cases would be postponed so that they could find a lawyer. Or, some people would say, look, my wife has to pay the rent. My wife is telling me the utilities are going to be shut off. I just want to sign for my deportation. And then you would ask him, well, how long have you been here? What are your family ties? And it was a weird position to be in as a judge, telling somebody, you can't give up, because you might have an opportunity to stay here with your United States citizen children and with your family members. Representation makes a difference. And let me just add this. I say this, in full disclosure of my background, I started as a prosecutor. I started as an INS trial attorney. Back in the day, INS attorneys were under the Department of Justice, and that was always my mantra, to do justice. And before the attorneys were moved over to the Department of Homeland Security, I could ask them, they would oppose, of course, they would say this person is deportable. We oppose this application. And I would ask them, what does justice require? And they would have to stop and think. When they got moved over to DHS, the priorities became a little bit different. And I'm not saying that securing the homeland is unimportant. I'm just saying with the shift in priorities, it became more and more difficult to have a conversation with everyone in the courtroom about what justice requires.
All right, thank you very much. We'll go to Delegate Williams, then Delegate Grammer now. Delegate Williams.
Yes, thank you, Mr. Chair. My question, I guess, is probably for Mr. Katz, but whoever else can also answer the question. Mr. Katz, in your testimony, you had mentioned that this bill, in addition to providing representation, would also allow for community education as well as the representation. And I was wondering if you could elaborate on that a little bit more, and also kind of talk about why the community education piece is also as important as the representation piece, maybe even if not more important.
Absolutely. Thank you so much for that question, Delegate, and others absolutely should weigh in. I mean, I will say that, you know, at CASA, that's a foundational part of our mission is community education and trying to educate folks who really don't have any experience with our system about what their rights are. Because if you don't know your rights, it's easy to have those rights violated, and folks just don't understand what rights they actually do have, and all too often are going to be put in a position, you know, like Judge Dornell mentioned, where they're agreeing to their own deportation because they don't know that they have a right not to tell ICE where they're from or to fight their case and seek asylum. So I think, you know, a component of this bill that would allow for community education to educate people about their rights, to really let communities know how they can, you know, prepare themselves, seek affirmative relief if they're eligible, what to do if a loved one is detained, and try to restrict the pipeline of people going into detention, right? Because the more community education you have, the less you're going to need lawyers, hopefully, because the less people that are going to be put into the deportation machine and detention in the first place. So I think, you know, that this is something that's just crucial to CASA's mission and to making this process work effectively. I think the final point I would make on that is just, you know, as we see increasingly ICE detaining people in other jurisdictions outside Maryland, and we certainly support ending immigration detention in Maryland, connecting families who are reporting to an organization like CASA that their loved one has been detained with lawyers is going to be vital, because those people who are detained in Georgia or Pennsylvania or further afield won't necessarily know about their right to access counsel. So having, you know, that type of education and connection to the community as a part of this program, I think is crucial. But I don't know if other panelists have additional thoughts. Thank you for the question.
You're welcome. Anyone else?
And I think with that in mind, I think it's important to note the importance of HB 750. That's something that Nick made me think about, is the fact that our Maryland residents get transferred across state, right? That ICE literally makes family members disappear without any sort of ability to track them down, other than relying on a network of legal service providers and organization community referrals. And that is a critical part of this bill that takes that into account and that is responsive to that reality.
Right. Mr. Chair, if I can ask a follow-up question.
Yes.
And so I guess the question from your experience, either Mr. Lopez or Mr. Katz, like most of the individuals that you all represent, ultimately, are they just here, or are they here, but also trying to at the same time navigate a very complex system in terms of trying to obtain a green card, obtain actual citizenship? Has that been kind of generally your experience?
Yeah, absolutely. So the clients where we are successful in outcomes, which is more often than not, and I posted in the chat just some statistics from our Prince George's County program and Baltimore City program to highlight that. But of those successful outcomes where people do have viable means of obtaining lawful status, an attorney is invaluable in securing that, right? Because one, like as Judge Dornell mentioned, the judges, when someone is without representation, can only advise someone about an apparent form of relief, but they can't do the legal screening for them, right? And that is a drastic limitation for someone who is unrepresented. So your question specifically about the lawful status at the outcome of the end of proceedings, well, representation is significant because getting someone out of ICE custody comes with a form of lawful protection to remain lawfully in the United States. And that can be in the form of a green card, that could be in the form of asylee status or some other humanitarian protection, but those lead to are pathways in themselves to citizenship. And the immigration laws are incredibly stringent and strict and harsh against immigrants as the statute is written. And all of those limitations apply to everyone who's detained, and they apply to those who are undetained as well, non-detained as well. And I say this just to bring back into context that giving individuals attorneys is not giving them some sort of benefit that is a plus or a bonus. To the contrary, it is doing the absolute minimum to secure their basic fundamental rights are protected.
And if I could just add to that momentarily, having an advocate can also expedite proceedings. It leads to efficiency because sometimes for an unrepresented person, having a lawyer explain what the judge just told him, there is no application for you to make. Hearing it from your own advocate who took the time to talk to you and gain your confidence and explain to you the big picture, people are willing to finish up their cases, to take orders when there is realistically no relief available to them.
All right, we're going now to questions from Delegate Grammer, then Delegate Griffith.
Thank you, Mr. Chair. I guess I have a question for the bill sponsor. So the other week we heard a bill regarding the earned income tax credit and the use on people who are here on various statuses of immigration. And I brought up an amendment because I felt there was a hypocrisy in our public policy that we didn't take care of people who were here on fixed incomes legally, who literally get no support. And hearing some of the bills this session, I feel a little bit the same way about this one. Several weeks ago, we heard a bill about making it illegal to question youth before they had legal representation, and that we should consider providing youth who are here legally additional services so that they weren't forced into divulging information without representation. And I think probably a lot of people here would support that. But with this bill, we're again putting the taxpayer on the hook for, and I sympathize with a lot of the statements that have been made. Immigration hasn't been dealt with federally, so the states are left to deal with this issue, and no one wants to see people separated, especially if the person in question is subject to abuse. But to be frank, a lot of these folks are here illegally. So I guess my question is maybe a philosophical one. Why is it fair to again put the taxpayer on the hook here, especially when we have questions about providing resources to people who are here potentially in violation of the law, when we even have Marylanders who could use additional resources for defense?
Well, so I do think that's a philosophical question that we probably just have a difference of opinion on, and I'll answer, and then anyone on the panel can feel free to answer. But these are Marylanders. The bill is specific to residents of Maryland and individuals who are residents of Maryland but who are being detained out of state. And so they're Marylanders. They're contributing to our society. They're working. They're raising their families. We just heard the story of the gentleman who talked about his children. He was working, and living here. So these, in my view, these are Marylanders. So we should take care of them. And as an attorney myself, one of the reasons I wanted to sponsor this bill is because I do believe in a fundamental right to have an attorney represent you so that you are aware, as the judge mentioned, what's going on in the process.
Does it bring up a question about priorities, which have been mentioned?
I think everything is priorities. That's why we're here. This is the General Assembly. We're going to hear priorities. There's mental health. There's going to be right to counsel for eviction. Delegate Bartlett had one that you mentioned related to juveniles. It's all about priorities, and it's all about us trying to manage that because there's so much need and there are so many priorities. So that's why we're here.
And therein lies the point. Are our priorities straight if we're not providing resources to youth who don't have representation when we are providing resources to people whose very legal residency is in question. Isn't that a
Well, as of right now, we're not providing representation to any of those folks, which I suggest is wrong. I think we should be providing representation to those youth, and that or they shouldn't be interrogated. But that's a whole separate bill. And I do think we need to be providing representation to this population. So I do think, I mean, I'm not going to have a philosophical debate when we've got 100 witnesses signed up. I just think we have a difference of opinion on it, which, you know, is fine.
Thank you for your answers, Madam Vice Chair.
Thanks.
Delegate Griffith.
Thank you, Mr. Chair. And this is a question for anybody on the panel. This question really, for me, trying to unpack the jurisdiction on this. And I'm gonna try to be as short as laying out my question as possible. So would this apply to immigrants that we can establish that are residents of Maryland? Would this have individuals that are established who are in Maryland, who are going through court in Maryland, who have been established to be a resident of somewhere outside of Maryland? I know one of the issues that we've been unpacking and we've been discovering is in some cases where some folks would establish residency in the state of Maryland to get a driver's license, but actually physically reside outside the state who are undocumented. So how do we positively identify that somebody is physically living in the state of Maryland and beyond just a mailing address? Because I believe now, like driver's license, you can get a driver's license with a PO box, right? So, and is it just they've been apprehended in the state of Maryland, so they're going through Maryland courts, therefore they're due this service, or do they have to be an actual resident of the state of Maryland to be able to do this? That's what I hope my question's clear. If it's not, I can try to clarify what my question is, but do you get at what I'm trying to understand on this question?
Yeah, so thank you, Delegate Griffith. So the programs that we can point to where we've already encountered the logistics and tackling the issue of residency and jurisdiction, right? Because funding was really specifically intended for residents of Baltimore City or Prince George's County. And over the last 3-4 years, this is something that has been very manageable and has been implemented as a process and a system that's efficient in terms of a legal service provider or organization screening for residency. These are very manageable logistical issues that can be very easily handled and addressed, especially through an institution like the Office of Public Defender, assuming that the bill passes and other resources are allocated to the budget to fund the detained work through the coordinator. But just to answer your concern about residency, that is not a hurdle that is going to present itself in terms of an obstacle to implement this kind of program. We've already seen it be successful in operations for the last 3-4 years in Prince George's County and Baltimore City. And lastly, I think just to respond to the concerns about prioritization, these Marylanders here who are non-US citizens, they pay a great amount of money in taxes, right? And the cost of deporting Marylanders on small businesses is extensive. There is data that we can point to and estimated costs of what a local economy loses by deporting its residents. The Center for American Progress has some of these studies, and I think it's $17 million a year that are borne in turnover costs by employers having to replace workers who have been deported from the United States. So in terms of prioritization, the investment in defending Marylanders and keeping them here of $8 million a year is in comparison to what it's costing the state to deport these residents here. It makes common fiscal sense to keep these residents here in Maryland, to keep them employed, to keep them being primary income providers for their families. And Delegate Griffith, just your concern about the jurisdictional elements of it. Marylanders are prioritized under the language of this bill for resources, and the identification of who is and who isn't a Marylander, that is very manageable.
Quick question. No, I have two, Mr. Chair, I have two follow-ups because you unpacked one thing there. You mentioned that Marylanders are prioritized. So this isn't exclusive to Marylanders. Mr. Lopez.
Yeah, I mean, the bill is
program. We could be potentially paying for individuals that are, I'm just, talking about your last comment. You're saying Marylanders are prioritized, but this would extend the service to folks that are not Marylanders?
This bill and its amendments intends to represent detained Marylanders specifically, right? So in terms of prioritizing Marylanders, we're talking about folks who are residents of Maryland. There was a comment made earlier about shouldn't we prioritizing Marylanders? And to Delegate Atterbury's point, these non-citizen immigrants here in Maryland are Marylanders, right? They are absolutely residents.
No. I'm not pushing back on that point. What I'm pushing back on is, would we be paying for these services for non-resident aliens? I'm sorry, I'm trying to respect the terminology, that are not Marylanders.
So to that point and to that concern, this bill would fund those who have connections to Maryland, right? ICE transfers people all over the country. Typically, the only people who are detained within Maryland who are not actually previously Maryland residents are those who somehow had ties to Maryland, so much so to where ICE would transfer them here to begin with. And
so that expands
a very small portion of the population.
But that expands the scope way beyond the boundaries of Maryland, and that could blow up that $8 million physical note significantly if we're handling, defense for these folks for the Mid-Atlantic region, for example, right? I mean that significantly increases that physical note. And one last question, is there any way to share any data for the Prince George's County and Baltimore programs for residents who benefited from this program that were not residents of those two jurisdictions? Could you please share that information with me? Because I'd like to get a sense to be able to look at.
Yeah, so those.
I just don't want Maryland taxpayers paying for services for folks that aren't even Maryland residents.
So Maryland operates 3 different ICE detainee jails in the states, right? So they're implicated in that way. Now, to your question or concern about data of Baltimore City residents and Prince George's County residents who received services who weren't members of these communities, that just doesn't happen. That is not part of the way that program has operated, and it's simply a matter of those screening protocols and processes actually being effective. But I think Nick Katz here from CASA can also answer some of your concerns here, Delegate Griffith.
I'm very conscious of time, Chair, so I want to be super quick. I think we sort of want to field a little bit. The bill prioritizes Maryland residents. Individuals who are in immigration detention in Maryland could be represented, but only after Maryland residents, right? And so that's, the $8 million fiscal note in the amendment is what's in the budget number, and that's what we estimate would be needed to cover Maryland residents. That's who comes first. Other individuals who may be detained in Maryland, with connections to the state, could only be represented if there was additional funding allocated that would go beyond that. So I think, to your concerns, that's who's going to be helped by this bill, are residents of Maryland.
Well, but how do we stage that? If we run out of $8 million in March, we have to add more money to this, and the physical note's an estimation. And if we're already potentially, in how law works, if we're potentially including these folks, in practice, we probably are including these folks. So if someone gets detained in Minnesota, right, and they get placed in an ICE facility here in Maryland, they would be eligible for this?
I think delegate, I mean,
Is that a yes or no question?
well, I don't know if Mr. DeWolf wants to weigh in because he'd be coordinating the program and has a lot of experience with how to balance services. He may be better situated to answer that question.
Delegate Griffin, these individuals are not represented at all right now. The $8 million is an estimate that the coalition came up with based upon their current experience. As a head of the Public Defender's Office, an underfunded agency, we represent indigent. By the way, I think it's important to note that these are Maryland resident in ICE detention that are indigent, that they can't afford a counsel.
But
so we already have.
That's not, Mr. DeWolf, that's not what we've unpacked. And I'm not even pushing back on Maryland taxpayer dollars going towards Maryland. I'm not pushing back on that at all. But we're talking about people that from our other states that are not Maryland residents and are only tied to the state of Maryland is that ICE put them in a detention facility in Maryland. They're eligible for these services. And I think I'm not sure Maryland residents should be paying for the legal defense of a California resident.
Well, I'll refer back to Mr. Katz, but my understanding is that the priority is for the representation of people that have been screened to be residents of Maryland in ICE detention and indigent. That's my understanding of how the bill is intended and how it's written. And with respect to the $8 million, when that runs out, there are no other funds.
Well, I've taken up too much of the committee's time. Thank you very much for your answer. I really do appreciate it.
I'm sorry.
That's correct. It would absolutely be Maryland residents. It contemplates an estimated number of detainees who are Maryland residents, both in state and out of states, right? And that is approximately 530. It's in the preamble of the bill. And those are the people who would benefit specifically from this infusion of money to this right to counsel.
All right, committee Delegate Cox is going to ask a question and then we're going to move off of this panel and move to the next panel. The vice chair will be sitting in for me for a period of time. Delegate Cox, for your question, you want to step away?
Thank you, Mr. Chair. Thank you, Mr. Chair. Can you hear me?
Yeah.
Okay, thank you. And I wanted to follow up on what Delegate Griffith was just asking, and from a different angle. On page 3, it actually indicates that an individual can be a covered individual must be represented who is detained in Maryland or is a Maryland resident. And my question is, what residency test are you using? Are you using a domicile test? And can an individual, just as any other person, establish their residency after the fact under this bill? Because the language is a Maryland resident, not was. So in other words, this could include everyone this could include all immigrants in the entire country. All they have to do is change their residency after they get picked up to Maryland, correct? I would direct.
I would ask Mr. Lopez to explain his screening process, because I think as the program develops and as we coordinate the program, we will be screening for Maryland residents in ICE detention that are indigent.
Thank you, Mr. DeWolf. Yeah, absolutely. So, I mean, there are different ways of tackling this, right? And one of the ways that has been effective is simply finding out where that person's last place of residence was before ICE custody, getting confirmation from there. There's usually follow-up with individuals' family members, community members, whatever context they might have, and just confirming that that person actually resided within the jurisdiction in question. It's not vague, it's not ambiguous. We've had to, in our current programs, actually turn away individuals who lived across the street from the Baltimore City line or the Prince George's County line, for example. And that is something that we've had to experience. And that's why a statewide system is just much more fair and equitable in terms of offering legal representation here in Maryland.
Well, I could follow you on this bill if it said was a Maryland resident, you know, when the individual was picked up by ICE, but that's not what it actually says. It says is. So my question question was specific as to if you have anybody picked up, could they then change their residency to Maryland while they're in ICE custody? This bill appears to then require Maryland to pay for their representation. Is that your reading?
No, not my understanding of the intent of the bill. So if we certainly accept that amendment.
Okay, thank you so much.
Any other questions for this panel? I should mention, but most of you probably know this because most of you are on this, but this is supported, this legislation, by the Maryland Legislative Latino Caucus. I just didn't get the letter in time to upload it, but my office will send that around to everybody. So thank you, panel, for being here, and we will move on to the next group of folks. Eleni Bast, Corey Lazar, Jojo, Anna Bill, Joanna Silver, and Lorena Guerrero. And I see folks are pretty much in. So we will start with Ms. Bass, and you will have 2 minutes.
Thank you, Vice Chair. Good afternoon, Chair, Vice Chair, and members of the House Judiciary Committee. My name is Eleni Baxt, and I am a senior attorney with the Maryland Universal Representation Team at the Capital Area Immigrants' Rights Coalition, or CARE Coalition. I am also a resident of Baltimore County, Maryland, and the daughter of 2 immigrants myself. I'm speaking today to ask for your support on HB 750, the Right to Counsel in Immigration Proceedings Bill. Through my work at the CARE Coalition, I provide free legal representation to residents of Baltimore City and Prince George's County who are detained in immigration detention centers in Maryland and Virginia. Unfortunately, because immigrants, even those in detention, are not guaranteed an attorney, majority are forced to represent themselves. I have sat in the immigration courts and watched countless unrepresented men and women, many of whom have fled their home countries seeking safety, some of whom are all of 18 or 19 years old, others with severe health issues, many with sobbing spouses and children on the courtroom benches, stare in complete shock, confusion, and fear at the immigration judge as she attempts to explain some of the most complex legal processes to them, generally through an interpreter and multiple layers of technology. All too often, when the judge asks how people want to proceed, their only reply is, "I need a lawyer." Detained immigrants face such great challenges in navigating their legal proceedings. Not only the stress and fear of being detained, but the loss of liberty and free movement makes it more difficult for them to gather evidence, prepare applications, or speak to those with information. As attorneys, we sometimes spend hundreds of hours preparing these cases. These challenges, along with the dire consequences resulting from removal proceedings, are why universal representation for all detained Maryland residents is so desperately needed. When detained immigrants don't have counsel, it not only prolongs detention and prolongs legal cases, but also leads to unjust outcomes, including separation from Maryland families and possible deportation to countries where they face great danger. Through this bill, the state of Maryland is showing it supports all Maryland residents and their families. Through this bill, we can ensure that all Marylanders are guaranteed dignity and due process in legal proceedings that have so much at stake. I urge a favorable report on HB 750. Thank you.
Corey Lazar for 2 minutes, please.
Hi, good afternoon, Chairman, Vice Chair, and members of the committee. I'm Corey Lazar, testifying on behalf of the Vera Institute of Justice's SAFE Initiative in strong favor of House Bill 750. Since 2017, I've been working with Baltimore and Prince George's County as they established and later expanded 2 of the first universal representation programs in the SAFE Initiative and in the country. We have lots of speakers in favor today, so I just want to reiterate 3 important points. These representation programs are important to their communities and successful. They're stopping unnecessary deportations and keeping families together. Statistically, detention without representation all but guarantees deportation. In contrast, people represented have a real chance at due process, freedom from detention, and a 10-fold increased likelihood of winning lawful status. These programs are popular They poll extremely well nationwide, and locally, more than 70% of people polled in Baltimore and Prince George's County support government-funded attorneys for immigrants facing deportation. And finally, the awareness of the need for universal representation is growing. This year, amidst the pandemic, New York, New Jersey, Illinois, and Harris County, Texas have all started or expanded representation programs. Maryland has a critical opportunity to continue leading the growing movement for universal representation and pave the way for federal change. I urge the committee to report out House Bill 750 favorably. Thank you.
Thank you. Jojo Anobil?
Good afternoon. My name is Jojo Anobil. I'm the Executive Director of Immigrant Justice Corps. I'm privileged to appear before you today. Since 2014, IJC's fellowship program has developed and tested a unique model for mobilizing young lawyers and college graduates to provide free quality representation to immigrants facing deportation. 3 years ago, we partnered with CARE Coalition to provide universal legal assistance to detained Maryland residents facing deportation. We chose to invest fellows in Maryland because of the vibrant immigrant communities, the strength of its legal services providers, and countless supporting immigrant rights. In 3 years, together with CARE, CASA, VERA, we have built a formidable foundation for universal representation for detained Maryland residents. Detention for civil immigration violation without counsel is cruel and unjust. Deportation is a severe penalty that separates families and results in the loss of all that makes life worth living. We enthusiastically support HB 750 because it is the final step in our collective investment to have the state of Maryland mandate and guarantee counsel for every detained immigrant resident. Not just counsel, but competent counsel, the best counsel that money cannot buy. Our experience backed by data indicates that having counsel advances fairness and dignity in a system that otherwise sets immigrants up to fail, levels the playing ground so everyone in this adversarial system has equal access to justice, brings efficiency and effectiveness. Please, together, let's give voice to the voiceless immigrants, be a champion for justice, and ensure that all residents of Maryland live in the light and not in the shadows. Thank you so much for giving us this opportunity.
Thank you. Joanna Silver for 2 minutes, please.
Good afternoon. My name is Joanna Silver and I live in Silver Spring. I am testifying in support of HB 750 on behalf of Tacoma Park Mobilization, an advocacy organization with over 2,000 members. While I'm here today as a community activist, I work professionally as a federal public defender, where I represent people charged with illegally re-entering the United States after deportation. The vast majority of my illegal re-entry clients did not have an attorney during their deportation proceeding. I review transcripts and recordings of their immigration hearings as part of my case preparation. What I have seen in these reviews ranges from disturbing to shocking. The body of law immigrants must navigate is so complex that as a criminal lawyer, I often retain immigration attorneys as experts, so I can understand the records I am reviewing and the defenses that could have been raised had my client been represented. While most think of a court proceeding when they think about deportation, a significant percentage of my clients were deported through a process involving only paperwork filed by ICE officers. It is almost impossible to identify and understand the small number of defenses available in these cases without a lawyer. As someone who works in a system in which there is a guarantee to both counsel and due process, the absence of counsel and the mockery of due process that I see in immigration court is hard to process, especially because the consequences are often more severe than those faced by my clients in criminal cases. In contrast, I've also seen what can happen when my clients have representation in deportation proceedings that take place after I've worked with them. Not only has representation clearly benefited these individuals and their communities, but I've also seen high-quality legal representation result in changes in case law that have benefited the entire immigration system. Finally, as a resident of Montgomery County, I am particularly committed to the establishment of a statewide guarantee to the right to counsel, because unlike Prince George's County and Baltimore City, Montgomery County still does not have a funding mechanism that ensures representation for its detained immigrants. For all of these reasons, I ask you to reach a favorable report on HB 750.
Thank you. Lorena Ortega.
Good afternoon, Chair, Vice Chair, and members of the House Judiciary Committee. My name is Lorena Ortega Guerrero, speaking in support of HB 0750. I'm an Immigrant Justice Corps Community Fellow, and I help defend residents of Prince George's County from deportation with the attorneys of the CARE Coalition. Every day, I hear of past persecution and the pain inflicted by ICE detention on our clients and families as they face permanent separation. They share their confusion about the laws that are defining their lives, but also the relief they feel knowing that they do not have to face it alone. This does not surprise me. Even our most experienced attorneys struggle to make sense of our complicated immigration laws. Yet, we expect people in detention to navigate these systems on their own, often in a language they do not understand, while experiencing one of the most difficult moments of their lives. I approach my work with a personal understanding of how trying these experiences can be. Both of my parents were placed in deportation proceedings when I was 16. My family had no idea what to do because we thought we only had one option, deportation, and no one at the Department of Homeland Security was telling us otherwise. I thought that any day I would have to choose between living thousands of miles away from my parents or leaving the only life I'd ever known in the United States, a decision that too many children in Maryland often have to ponder. Thankfully, my family found an attorney who charged us only what we could afford and helped us build our case. My parents are now on their path to citizenship, and I am speaking to you here today, fully aware that that would not be the case had we not found an attorney. Too often, people are deported and separated from their families, not because their cases lack merit, but because they could not afford an attorney to advocate for them. The difference between life and death, between a family united and a family torn apart, should not be a person's ability to pay. With the PG County Project, we work every day to help detained individuals exercise their rights, but I often think about the many other Marylanders who are left out of this program. We cannot abandon them and their families. Thank you.
Thank you. Are there any questions for this panel? I see Delegate Griffith has a question.
Thank you, Madam Chair, and thank you for the folks on the panel being here today. Appreciate the fact that you're supplying defense to those who need it, and especially those who are donating your time. I know as an attorney, your time is your trade, and so I appreciate and respect that. Just a quick question. One thing I think unites all of us as Marylanders is how much we don't like to pay taxes. And I think one thing we've talked about a great deal this session is many of these folks are taxpayers. So could any of you speak to any of your clients and how they would feel in a situation where Maryland tax dollars, their tax dollars, would be going to pay for the defense of potentially folks that are not Maryland residents? And furthermore, with these dollars, if these dollars were to run out because they were spent on non-Maryland residents, and they would be potentially left out of the resources for their right to counsel.
So I'm just going to say that your question goes to someone else's state of mind and what someone else thinks.
You're correct. I guess this would be the question for any of the members on the panel. How would you feel about that?
I can share from my perspective, both as an attorney and a Maryland resident who pays taxes. Several of our current and former clients are testifying in support of this bill today, indicating that they have a generosity of spirit here. They want what they, benefited from to be passed on to others, and they want it to expand. And our clients are Maryland residents. All of my clients are residents of Prince George's County, of Baltimore City, and they want to use their taxpayer dollars to support this bill. They believe it is important to them, and that's why you're hearing from so many of them today and in written testimony. As a Maryland resident myself who pays taxes in this state, I also agree that this is an important use of our taxpayer dollars, because if we want to say we want to ensure due process for all Marylanders, then that includes the immigrant residents throughout Maryland.
But would you rather these tax dollars go towards Maryland residents or folks from other states?
Well, I believe that this bill does.
Knowing we have a finite amount of money.
Sure, I believe that this bill does prioritize Maryland residents, and the amount that is included in the bill is accounting for Maryland residents.
It prioritizes, but not exclusive.
It's for Maryland residents. So I'm pulling it up now, but it's Maryland residents. I think someone earlier misspoke, but it's Maryland residents and a Maryland resident who is being detained out of state. But you wanted to say something?
Yeah, I just wanted to say that we seem to be coming from a point that immigrants jury can select their forum when they are being placed in removal proceedings. You don't. No one gets arrested in Minnesota and decides that I want to go to Maryland because Maryland provides a right to counsel. It's based on your residence. Apart from that, in immigration proceedings, you need family members, you need support of your family in those proceedings. No one is going to get into proceedings in Maryland and have their family members fly over from Alaska to Maryland. It's probably a very small number of people who you would find and classify as non-residents of Maryland. In most cases, the people you're seeing are residents of Maryland, have lived in Maryland, or have some connection to Maryland as at the time they are placed in proceedings.
Well, I mean, I think, again, the language in this matters, most of the people you mentioned, and then also some connection to Maryland.
So
right?
The bill specifically says, Delegate Griffith, on page 3, lines 4 through 7, that the bill, a covered individual is defined under the bill as an individual who is detained in immigration detention in Maryland or in another state and is a Maryland resident.
So, but somebody who's detained in Maryland is not necessarily a Maryland resident?
I think the majority of folks detained in Maryland, yes, some folks do move around, but the majority of people who are detained in Maryland are Maryland residents. And the previous panel discussed a screening process that they do at the detention facilities to determine if the individual actually lives in Maryland.
So, but would some of the people who are in detention facilities in Maryland who would benefit from this would not be Maryland residents?
I don't know that.
All right. No, I have no more questions. Thank you very much, Madam Chair. I appreciate it. Thank you for the panel for being here today.
I don't see any other questions. So thank you, panel, for being here today. Committee, we're going to call in a next set of individuals who do require a translator. So like previously, their testimony will be on the screen as they testify. And so let me call those people in. Marvin Dubon, Miranda, Patricia Banos Guevara, Jose Amaya, Maria Rivas, Jose Malandando, and Fausto Herrera. I think is all we're calling it right now.
Hello?
Hi, can you just put yourself on mute real quick? We're letting everybody in.
Entonces, vamos a esperar hasta que todos entran. Por ahorita, póngase en mute. Cuando llegamos tu nombre, vas a poder testificar.
Thank you. So we will start with Jose Amaya, and Dylan will put his testimony up on the screen. Dylan says folks need to, Gabby, if you can let folks know, some people need to connect to the audio, but just go on mute. I don't think everybody's on audio.
Sure thing. Entonces, si usted se está conectado, pero todavía no se ha conectado su audio, por favor, busca donde dice call in using internet audio. Yo creo que José, usted todavía no tienes audio. ¿Ya lo conectaste?
Sí, ¿ya me escuchan?
Sí, listo. Ok, so hasta que te llamamos, por ahorita póngase en mute.
I see Jose Amaya's just is saying he's connecting to audio, but he's not connecting, so I'm not sure. So he was first, so I'll move to, Dylan, you want me to move to someone else first here? Okay, so we will go with Marvin first, and he will have 2 minutes, so he can begin.
Adelante, Marvin.
Mi nombre es José Aldin Maldonado y soy residente de Baltimore. Yo fui cliente de Case Collection y estoy aquí para expresar mi apoyo a la ley HB 750. Fui detenido en diciembre del 2019 por ICE y tenía mucho miedo que me fueran a deportar. Tengo mis hijos conmigo en Estados Unidos que necesitan. Yo trabajo mucho para ellos. Creo que las personas que están en una detención necesitan mucha ayuda. Yo trabajo mucho para ellos. Yo fui a una corte y estaba solo. No tenía a nadie. Tenía mucho miedo. No sabía hablar inglés. Y pues cuando regresé a la detención, encontré el número de Case Collection y empecé a hablar. Y llamé y luego me contacté con mi abogada, Eleni, que estaba pasando. Ella me dio mucho ánimo y me dio apoyo. Con la ayuda de Dios y la ayuda de un abogado que es Collection, yo pude ganarme asilo en la detención. Y pues la verdad, ella fue de mucha ayuda para mí.
Marvin also added that thanks to the lawyer that he was able to get, he was able to process his asylum case.
Okay, thank you. Next, we will have Jose Amaya when he's ready for 2 minutes.
Jose Amaya, adelante. José, te escuchamos.
José Amaya, José Maldonado.
José Amaya.
I see him.
No. Yo soy Marvin Dubón.
I believe that the wrong person spoke. Marvin, who was supposed to testify, isn't testifying. Jose testified.
Oh, okay, so it's Marvin's. Okay.
Yeah.
Okay, sorry. Okay, go ahead.
Adelante, Marvin.
Buenas tardes, mi nombre es Marvin Dubón Miranda y soy residente de Baltimore, Maryland, y estoy aquí para apoyar a la ley HB 0750. Yo nací en El Salvador, huí de la violencia en mi país y amenazas de organizaciones criminales. He vivido en los Estados Unidos por 12 años, tengo un hijo de 14 años, estoy casado, trabajo como pintor, usualmente tengo turnos de noche. Estuve detenido durante 11 meses, fue una experiencia terrible para mí. Me dolió mucho estar separado de mi hijo. También fue difícil para mi esposa porque sufre de enfermedades crónicas. Soy su único apoyo y depende mucho de mí debido a su condición médica. Está muy enferma y no puede trabajar. Me dolió mucho estar separado de ellos porque también fue durante el tiempo donde comenzó toda esta pandemia. Estuve casi un año y donde tuve mucho miedo al ser deportado cualquier día y ser separado de mi familia. Cuando empecé mi caso con migración, no entendía lo que estaba pasando conmigo, ni igual cuando fui por primera vez ante un juez, fui solo y fue para mí muy difícil explicarme o entender porque mi inglés no es muy bueno, no hablo 100% inglés y fue muy difícil para mí explicarme ante el juez. Un mes después califiqué para representación legal bajo el programa de Baltimore 6 Cities. Cuando tuve mi audiencia, mi abogada me defendió ante el juez. Ella sabía qué decir y qué hacer. Ahora comprendía cómo las leyes se aplicaban a mí. La abogada me ayudó a expresar mi historia. Pude luchar mi caso y sé que tan importante es tener la ayuda de un abogado. Así cada día no estaba solo y sabía que no podía ser deportado fácilmente con la ayuda de un abogado. Tener un abogado que te defienda frente a un juez es muy importante. Las personas no deben ser separados de sus familias por no tener acceso a un abogado. Les pido, por favor, apoyen esta ley y Dios bendiga a las personas de Cal Coalition.
Gracias, Marvin. Marvin added that also before the pandemic started, when he was deported, he was the only person supporting his wife who has chronic health conditions. And he wants to say, God bless the people of CARE.
Thank you. Patricia, for 2 minutes. Oh, she's shaking her head no. Something's wrong with her audio, maybe? Okay. Let's move on to Maria Rivas.
María, ¿estás aquí?
Sí, aquí estoy.
Adelante.
Good afternoon, delegates. My name is Maria Rivas and I live in Glenarden in Prince George County, Maryland. Legal representation is the reason why my brother is still here in the United States with me and safe today. 2 summers ago, on an early morning in June, my youngest brother, Kevin, was stopped by ICE on his way to work. He was in the car with his brother, Douglas, who ICE was pursuing an immigration violation. Kevin was undocumented and with guns drawn, ICE dragged my brothers away. Their car was left in the middle of the road with the key still in the ignition, and it was not until the next day that I was told that my brother had been detained. That stop landed my brothers behind bars in Frederick and then Howard County Jail for Kevin. Both are jails where they detain immigrants on behalf of ICE. Kevin was in detention for a grueling 6 months where he experienced some of the worst experiences one can imagine. He has shared many of times on his own advocacy, his devastating accounts of walking barefoot in detention after being denied requests for new shoes, going days without toilet paper, and weeks without seeing a medic after making a request. I remember the heartache of barely being able to communicate with my brother because of all the language and technology barriers in the detention centers. It was among one of the hardest moments my family has faced. Eventually, in November that same year, Kevin was released when he won his immigration case. He was able to work with a lawyer, and with their help, he was granted withholding of removal order, which gives him the right to stay in the U.S. indefinitely. He received this because back in our home country, El Salvador, our town was controlled and terrorized by gang members. Kevin had no choice but to flee here to the United States because his life was at risk. He came here seeking refuge, not knowing how ICE detainment and deportation agenda will affect him.
Thank you, Maria. I'm going to have to ask you to wrap up.
Now, okay, so thanks to, he could not have been granted relief if he didn't have a lawyer through CARE Coalitions. As you can see, my brother's story, legal representation can completely change your outcome in life. So many people like my brother are detained in house horrible conditions without access or money to afford a lawyer. We will never have true justice until everyone has a lawyer to help them navigate and understand the justice system. Please pass House Bill 750. Thank you, delegation.
Thank you. Patricia?
Patricia, ¿te puedes conectar? Patricia, ahora sí. Adelante.
Buenas tardes, presidente Clippinger y miembros del Comité Judicial de la Cámara de Representantes. Mi nombre es Patricia Baños Guevara y soy residente de Baltimore, Maryland. Mi esposo fue cliente de Kyle y estoy aquí en apoyo de HB 0750. Mi esposo y yo llevamos 6 años juntos. Mi marido trabaja muy duro. Yo dependo de él porque no puedo trabajar por mi salud. Tuve tuberculosis y meningitis y me quedé con un pie malo y un corazón débil. También estoy recibiendo tratamiento por una enfermedad renal terminal. Recibo diálisis casi todos los días y es muy pesado. Mi esposo fue detenido por ICE durante 11 meses. Fue un momento terrible en mi vida. Yo estaba muy enferma y él era la única persona que me apoyaba. Fue durante el COVID, entonces ni lo podía ver. Tenía tanto miedo que lo deportaran a El Salvador y que le pasara algo. No sabía qué hacer porque no tenía el dinero para conseguirle un abogado. Gracias a Dios pudimos tener representación gratis. Nuestra abogada trabajó muy duro en nuestro caso. La abogada me mantuvo informada sobre cómo podía ayudarlo. Ella siempre estuvo de nuestro lado. Sin un abogado, mi marido hubiera sido deportado. El juez no hubiera sabido lo importante que era para él quedarse. No hubiera entendido nuestras vidas. Esta es una necesidad. Esta ley va a ayudar a mantener a las familias unidas. Gracias.
Thank you very much. Next, Jose Maldonado.
So Jose went when we called
yeah.
for Marvin.
Okay, right. Okay. So Fausto.
Señor Fausto,
Sí.
adelante.
I saw him on here. His face just went off. It was on. Oh, his audio's not connected. I'm being told.
Fausto, ¿te puedes conectar tu audio? Puedes tocar el micrófono y con ese micrófono te va a dar la opción de decir conectar vía el internet y eso te debería dejar escuchar todo. So I know that if someone's not connected to the audio, they can't hear us either. So
okay.
Maybe someone on the outside is helping him connect.
Okay, so. I think that was, oh, here he is, he's back. Fausto, are you connected? I see his face. Okay, I think Jose Amaya then.
Jose Amaya, ¿estás listo? José, ¿sí?
Sí,
Adelante.
sí. Buenas tardes, mi nombre es José Amaya. Soy residente de Hyattsville, Maryland. Yo fui cliente de CARE y estoy aquí para hablar en apoyo a HB 0750. Trabajo en construcción, tengo 2 hijos y vivo en Maryland por 5 años. Vine de El Salvador por la violencia y la corrupción en mi país. Huimos de organizaciones criminales y los amenazaban y tenía miedo de mi vida, la mía y con mis hijos. En el 2008 fui detenido por ICE en una detención por 6 meses. Fue una experiencia muy difícil para mí. No podía estar con mis hijos y hacer mi trabajo como padre y protegernos. No podía pagar un abogado porque tenía que usar mi poco dinero que tenía para mantener a mis hijos. No entendía lo que estaba pasando con mi caso. Pensé que me iban a deportar. Había perdido la esperanza. Me dieron representación legal gratis con el programa de Prince George. Mi abogado me mostró cómo las leyes me protegían y pude pelear mi caso. Gané y regresé con mi familia. Las leyes de inmigración están establecidas para deportar a la gente sin abogados. Una persona detenida será deportada porque no entiende las leyes en la detención. Te tratan como si no eres nada. Es imposible entender tu caso. No es justo que las personas sean separadas de sus familias porque no pueden pagar un abogado. Estoy muy agradecido porque puedo trabajar por un futuro mejor para mí y mis hijos. Ojalá todos los inmigrantes detenidos en Maryland tuvieran la oportunidad. Gracias.
Thank you very much. And I think that is the panel, unless Fausto was able to connect. Committee, are there any questions for the panel? Okay, seeing none, thank you all very much for being here today.
Muchas gracias a todos.
Next, we have Carla Mendoza, Claudia Cubas, Francisco Flores, Vanessa Reyes. Let's see how many people you bring in, Dylan. Susanti. Okay, so we will start with Carla Mendoza and everyone will have 2 minutes. So Ms. Mendoza, you can go when you're ready.
Hi, everyone. I was really hoping you could get a break before my testimony, but I'll go ahead and make it quick. My name is Carla Mendoza, and I'm speaking in support of HB 750. I'm an IJC fellow working with Maryland residents in immigration detention. I would like to share my experience working with immigrant families. I remember once a client apologizing for her story being a problem. Confused, I responded, "It's not your story nor you that is the problem, it's the system that's the problem." At 20 years old, this was my attempt at making this individual feel safe, secure, protected, and free, some of our most sacred American legal commitments. This was my attempt at explaining to the client that even if the law was not necessarily on her side, I was, and I firmly believed in her individual human rights. I believed in her right to a fair immigration process that did not re-traumatize her, but rather reaffirmed her strength and freedom to pursue a life free from persecution. I believed and still believe all people's right to adequate representation and their right to be represented in court by a legal advocate that embodies empathy, humility, and cultural competence. At the time, I was working with separated families in America's largest detention center during the zero tolerance policy. Now, as a fellow at CARE Coalition, I have witnessed the power of access to legal representation and due process, save the lives of countless people. With funding from Baltimore City and PG County's Universal Representation Program, I have witnessed attorneys help reunite families. I have witnessed self-empowered clients share their story, in a courtroom. I have witnessed our legal system serve justice to peoples before the court. While opposition has stated that this bill is totally unfair to every Marylander, totally ignores the rule of law, I would argue that this bill does the exact opposite. This bill prioritizes two of our most important rights: the right to a fair trial, the right to an attorney. This bill prioritizes Marylanders' core values. It does not dictate who we should prioritize, but what we should prioritize. I'll end now since I started crying. Thank you.
Thank you, Ms. Mendoza. Now, Francisco Flores for 2 minutes, please.
Thank you. Chair, Madam Vice Chair, committee members, my name is Francisco Flores, and I urge a favorable report on HB 750. I am a graduating law student at Maryland Carey Law, and more importantly, I am the son of immigrants. My parents fled from El Salvador in the late 80s. My parents did not speak English. They had no formal education and can only get low-paying jobs. To stay in the US, they needed nonprofit legal representation. They would have never been able to afford a private attorney. My parents were lucky to find nonprofit legal representation and remain in the United States. If my parents had not obtained an attorney, they would have not been able to stay in the US, and I would not be here where I am today. My family's experience shaped my future. I'm paying back the assistance my family received. In 2013, I started working in the immigration law field. Since that time, I've witnessed families struggle to afford an attorney. I've watched families sell their only car or use rent money to pay for lawyers. They had to pay for a private attorney as nonprofit organizations had extensive lists and could not guarantee a lawyer for their case. The immigration justice system is complex and adversarial. Without an attorney, people cannot defend themselves against deportation. Recently, I represented a young man from Honduras who faces torture and death if deported. Even though the outcome of his case is still unknown, our client told us after trial that we were superheroes in suits. He told us that whether he won or lost his case, through our advocacy, he saw that there was value in his life. Even the guard who watched the trial could tell that having a lawyer made an enormous difference. The guard told our client that he had observed countless immigration trials without lawyers, and he could not get over the enormous impact a lawyer's involvement had made in the presentation of the case. Providing lawyers to non-citizen Maryland residents is an investment in the future. I am that future. Just like me, those who benefit from this bill will seek to give back to their community. And for these reasons, we urge a favorable report on HB 750. Thank you for your time.
Thank you very much. And it's my understanding that Claudia Cubas is signed up to testify in favor, but she is not in the waiting room. So we will move on to Vanessa Reyes. Great name. My name is Vanessa. So 2 minutes, Ms. Reyes.
Chair, Vice Chair, and committee members. My name is Vanessa Reyes, and I'm a student attorney at Maryland Carey Law Immigration Clinic, and I urge a favorable report of HB 750. I would like to share a story that made me realize how important having a lawyer is to non-citizens. I volunteered to help detained migrant women file claims for asylum. I spoke with countless women who told me their stories about why they were seeking asylum. The first client on my list was Sarah. At 20, Sarah fled Honduras after being abused for years by MS-13. I met with Sarah to prepare her to tell her story to the asylum officers. As we were wrapping up, she began to cry. I worried I had pushed her too hard, but she told me that her tears were not of sadness, but of joy. Joy of feeling recognized and respected and not dismissed as some faceless criminal. She expressed how thankful she was for my help and how I was the first person to make her feel safe since the moment she left her country. It gives me hope. Me da esperanza, she said in Spanish, to know that there are people who look like me fighting for me. It was then that I realized how much my representation mattered. My status as the daughter of Salvadoran immigrants and as someone who was willing and able to help with her case was enough to give her hope to continue fighting. Sarah was one of many that expressed the importance of having legal representation. I encountered multiple women who could not read or write, let alone understand the legal documents handed to them. Some of these women described feeling physically ill thinking about going to court to defend themselves. It wasn't until they met with a lawyer where they began to feel a sense of relief, knowing their lawyer understood what actions needed to be taken. They knew they had no other chance at protection without the proper help of an attorney to help them navigate our complex immigration system. I support HB 750 because this bill would guarantee individuals such as Sarah the best chance to fight their case in immigration court and finally reach the safety and protection they have fought so hard to obtain. Thank you.
Thank you. And that was perfect timing. Susanti, next for 2 minutes, please.
Thank you, Chair Clippinger and members of the House Judiciary Committee. I'm Susanti Fallingstead from Rockville, testifying in support of House Bill 750 for Maryland Against ICE Detention, a statewide coalition of over 60 organizations and 200,000 individuals striving to stop immigration detention and deportation. In criminal court, everyone, is guaranteed an attorney to represent them, no matter how heinous the crime. Yet in 2019, 77% of immigrants had no representation in immigration court and possibly face worse consequences than those in criminal court. Imagine facing a court without someone to guide you. You've heard some of them talk today, particularly given the consequences. Those with an attorney are 3.5 times more likely to get bond, leaving the rest to face detention and possible COVID. Someone with an attorney is 10 times more likely to stay in the US, while those without face deportation to a country they may have fled because of violence, or they may not have been to for decades, leaving behind families that include US citizens without financial support. While some jurisdictions in Maryland already provide representation, individuals with some past convictions are excluded in some areas. They should also be provided an attorney, with a judge determining if an immigrant's past record and life circumstances warrant deportation. House Bill 750 ensures each immigrant gets representation so their case can be assessed appropriately. Maryland Against ICE Detention urges a favorable report on this and the following 2 bills being considered today. Thank you.
Thank you very much. And it's my understanding Claudia, who is in, so let's just give her a second so she can testify. And Claudia Cubas, you have 2 minutes and you can go ahead.
Thank you so much, Vice Chair Atterbury, and I apologize for my delay, as I was told initially that I would not be testifying, but I am here. My name is Claudia Cubas, and I am the Litigation Director of the Capital Area Immigrant Rights Coalition. I have been an immigration attorney for all of my professional legal career. In fact, I went to the University of Maryland to become a lawyer. I lived in Baltimore for a good portion of my law school, and then I lived in Prince George's County. I still have several family members who live in Maryland, including various family members and immigrant friends who do not have status. The reason why I'm here today is to support the bill. There needs to be representation for immigrants. Let me explain to you why from the perspective of an immigration lawyer and also an immigrant myself. I have, in every year that I've been an attorney, which is over the last 10 years, I have sat in immigration court hearings where people whose language is not English have to understand what an immigration court process is. And this may be their first time that they go to a court because they've never been one before. I've had to sit in and watch people be given a form that is completely in English, that has questions that are legal questions, which may go beyond their education, be told that they have to complete this form in a language that they do not even speak well, let alone write well, and then be told to submit it in a specific way and be told to prepare their case to go before a trial judge, also in front of a trial attorney who is going to be opposing them. That is not a fair, just manner. The situation is stacked against them. While the immigration court system itself may be a much more fair and due process way, the way that the person goes before an immigration judge and puts their case forward is stacked against them because they have to learn how to write English, how to speak English, how to submit evidence, how to talk to a lawyer, how to talk to a trial judge, even know how to navigate an immigration court system and learn that as they go. There is a better way, and this bill provides that avenue. And I can tell you that Maryland will see the benefits of it because these are people that are already in our communities. I've had clients who I didn't even realize lived in my neighborhood. There was a client of mine who lived in Prince George's County, who I did not even know until after the fact, who I represented, I helped to keep from removal. And later on, when I stumbled upon him in my neighborhood, after he actually safeguarded me, helped me from being attacked in my neighborhood. These are the members of our community and they give back. It is time for us to give to them too so that they can continue to give back. But they can't do that if they're going to be in a situation where they're always alone, they're always having to understand what is going on and not really even know how to go about doing so.
Thank you.
So,
thank you. I'm going to have to, I let you go over your time because I was just going to ask you, did you have anything else to say? Are there any questions for this panel? Okay, seeing none, thank you all very much for being here today in support of the bill. Next, we are going to call in Tiffin Lovler, Maria Colin, Maureen Sweeney, Daishi Miguel Tanaka, Hamza Ewing, and Joe Spielberger. So we'll let them all come in. Just to share while we're all waiting, I'm sending my kids messages on Alexa because they're all losing their minds upstairs. Okay. So everyone will have 2 minutes and we will start with Tiffin. And when you're ready, you can go ahead and begin, please. Tiffin Lovler, Tapia? Yeah, you can go when you're ready, begin. You have 2 minutes, please.
Okay. Hello. Thank you, Chairman, Vice Chair, and committee members. My name is Tiffin Lovler Tapia, and I live in Baltimore City in District 46. I am providing this testimony on behalf of Jews United for Justice in favor of House Bill 750. Our Jewish tradition teaches that it is our responsibility to welcome migrants since we share a common story with them. We Jews have had to flee our homes to escape violence and to find a better future somewhere else many times in our history. This includes my family. Their journey started in the early 20th century when they emigrated from Eastern Europe. They were escaping the battles of World War I in Russia and the pogroms, the persecution of Jews in Poland. They trekked across Europe until they reached the coast of Germany to board the ships that would take them to their new homes. My family endured this journey in hopes of obtaining a better and safe future. Today, the purpose for moving have not changed. Many immigrants are escaping difficult and dangerous situations and hope to get a fair chance at achieving a better future here in the US. Unfortunately, the United States does not always live up to its ideals. This is why I support a right to counsel in immigration hearing. Joining the national movement for a right to counsel in immigration court will be consistent with Maryland's own tradition of welcoming immigrants. Over a century ago, Locust Point opened its doors to more than 1 million newcomers. Today, a large number of immigrants continue to make Maryland their home and continue greatly to our local economy and culture. It is up to us to help them succeed here, and we can do that by ensuring their right to counsel in immigration court. For all of these reasons, JFJ respectfully urges a favorable report on House Bill 750. Thank you.
Thank you very much. Next for 2 minutes, Maria Colon.
Good evening. My name is Maria Colon, and I am a Baltimore County resident. I am a supervising attorney at the Esperanza Center, a program of Catholic Charities of Baltimore. The Esperanza Center is a comprehensive immigrant community center located in East Baltimore and Fells Point. Our staff and volunteers provide services and referrals, ESL education, healthcare, and free or low-cost immigration legal services to thousands of Maryland immigrants each year, and we support HB 750. I've represented clients in removal proceedings, and I would like to share 2 stories from neighbors from our communities whose lives have been changed by our representation and deportation proceedings. I represented an unaccompanied minor child who was granted special immigrant juvenile status, but due to the complexity of immigration proceedings, the Department of Homeland Security detained him and moved him all the way across the country, to be exact, over 2,700 miles away, even after we won an appeal before the Board of Immigration Appeals. He struggled. He definitely struggled after being separated from his legal representative, his support system, and his family. Imagine being a teenager in this intimidating situation. Unfortunately, I could not continue to represent him because our representation is limited to Maryland residents. During our last conversation, he told me, I feel pressured by ICE to sign a deportation order. And I think I will do it even if they kill me in Guatemala. I can't take this anymore. Yo no puedo con esto. And frequently, very frequently, almost every day, I think about his case because this whole situation was avoidable. I also represented a minor who fled Honduras because she was sexually abused by her father. Fortunately, in her case, an immigration court allowed her to stay in the United States away from her abuser who still lives in her country and where the government was unwilling to protect her. These two clients would have normally not afforded legal representation because their household income was below poverty guidelines. And there are thousands of other undocumented Maryland residents that pay taxes but can't afford legal representation. Both of these clients that I mentioned.
I'm gonna have to ask you to wrap up.
Okay, both of these clients were funded by VERA and by the Baltimore City Pilot Program. And for all of the Maryland residents that can't afford legal representation, and for all of the families that have been separated, I urge you to support this.
Thank you. Maureen Sweeney now, please, for 2 minutes.
Good afternoon. My name is Maureen Sweeney. I'm a law professor and the director of the Immigration Clinic at the Maryland Carey Law School. I urge a favorable report on HB 750. I've been practicing immigration law for over 25 years and running the Immigration Clinic since 2004. I know from my own experience and from national and local studies that legal representation can make all the difference in an immigration case. The law is complex and technical, and it isn't any surprise that people need help to navigate it. Our clinic represented a woman who survived decades of brutal domestic violence in her country, but because she was so traumatized by that history, when she was asked by officials why she had come to the United States, she said it was to work. What she didn't say was that the reason she had to work and support herself without assistance was because she had fled and was in hiding from her abusive husband. We were able to ask her the right questions and get her the opportunity to present her valid claim in court. Our client at least had a chance because she had a lawyer. The simple fact of having a lawyer does not guarantee that an immigrant will avoid deportation, but it does give them a fair shot. The judge, of course, can still decide whether the person deserves to be protected under US law, whether they represent a danger and should be deported, or whether factors such as family hardship or genuine rehabilitation weigh in favor of relief. Lawyers can also make the system more efficient by moving cases more quickly and by presenting complex cases to the higher courts, which clarifies interpretations of the law. My clinic argued the case Martinez versus Sessions at the Federal Court of Appeals, which clarified how the federal immigration law gets applied to Maryland statutes. Because of this case, immigration officers and judges in Maryland can now operate with greater efficiency in properly applying the immigration law. Giving lawyers to poor detained Marylanders helps the whole system function more efficiently, more effectively, and more justly. For these reasons, we urge a favorable report on HB 750. Thank you.
Thank you. Next, Daishi Miguel Tanaka for 2 minutes.
Thank you, Chair and members of the committee. My name is Daishi Miguel Tanaka with Asian Americans Advancing Justice, AAJC. Our mission is to advance the civil and human rights of Asian Americans and to build and promote a fair and equitable society for all. We express our strong support for HB 750. Quality legal representation is the minimum requirement for due process in our complicated immigration system, especially for people being deprived of their liberty in immigration detention. Look, Maryland is home to over 415,000 Asian Americans, making up 7% of the population. Around 266,000 of them are immigrants. And although undocumented immigrants may often be associated with only Latino communities, there are around 35,000 undocumented Asian immigrants residents living in Maryland. And as of 2018, there were nearly 5,000 Asian immigrants in detention. The majority of them were from India, China, Bangladesh, Nepal, Iraq, Vietnam, and Pakistan. So the need for representation extends to all communities of color. Detained people include asylum seekers who are seeking protection, And many of these people were also long-term community members in this country. In 2018, about 43% of Vietnamese Americans detained have lived here for over 2 decades. And for Laotian and Cambodian Americans, the number is staggering at 86% and 75%. Like you and me, these are people with deep ties to this country, with families. So imagine having a family member in detention, not knowing when you'll get to see them again. And imagine knowing now that if your loved one has a lawyer, they would double their likelihood of winning their case and finally coming home. The answer is simple. Legal representation would change lives and determine whether families stay together. And you have a choice. We urge you to support HB 750. Thank you.
Thank you. Your timing was literally 2 minutes on the dot. Next, Hamza Ewing for 2 minutes, please.
Good afternoon, Mr. Chairman, Madam Vice Chair, and distinguished members of the House Judiciary Committee. On behalf of the Council on American Islamic Relations, I want to thank you for this opportunity to testify in support of House Bill 750, entitled Office of the Attorney General, the Right to Counsel and Immigration Proceedings Coordinator. The Council on American Islamic Relations is in fact America's largest Muslim civil rights and advocacy organization. The United States Immigration Detention Program, operated by ICE, is the largest of its kind in the world. The majority of individuals detained by ICE are not afforded the right to legal counsel for their proceedings. This is a violation of basic civil liberties. All ICE detainees should be afforded due process to ensure fair and impartial treatment. Oftentimes, detainees do not understand the complex intricacies of our justice system. Their judgment and ability to articulate their circumstances can be inhibited by language, culture barriers, stress, circumstances, and fear. This bill will ensure whatever their personal predicament and response, that they can speak to a lawyer who is familiar with their case. It also aims to educate minorities who have been directly affected by detention on their legal rights. This bill fixes critical oversights and will seek to provide individuals with legal counsel when necessary and requested. We support this bill because it seeks to provide basic rights, and we believe it will help level the playing field for immigrants and communities of colors who have been disproportionately harmed by cruel and inhumane immigration policies in our country. Therefore, we respectfully urge your vote in favor of House Bill 750. And once again, we thank you for your consideration.
Thank you very much. And last but not least, Joe Spielberger for 2 minutes, please.
Good afternoon, Vice Chair Atterbury, committee members, and Legislative Secretary Whitney Duck. I'm Joe Spielberger, Public Policy Counsel for the ACLU of Maryland, here in support of HB 750. And thank you to Vice Chair Atterbury for sponsoring this very important bill. At the ACLU of Maryland, our priority is fighting to protect the constitutional rights of all people in Maryland without distinction or exception. Although deportation triggers such a strong liberty interest, access to counsel and access to effective counsel is only a privilege for the few instead of a guaranteed right for all. These cases have been described as death penalty cases adjudicated in traffic court settings. As you've heard already, despite the very high stakes, dire consequences, and the legal and procedural complexity of these cases, most people represent themselves and fail to obtain relief that otherwise would be afforded to them. And thus our immigration system operates only as a conveyor belt of mass deportations rather than a reliable system that upholds due process and access to justice. So this bill helps to create that reliable system, a system that one day Maryland can hopefully be proud of, that ensures the constitutional protections for all its residents and fulfills the fundamental American promise of equal rights for all. So on behalf of the ACLU of Maryland, we are proud to support this bill, and we urge a favorable report on HB 750.
Thank you very much. And I see that there's one question, Delegate Aricam.
Thank you, Madam Chair. This question is for Mr. Ewing.
Okay.
Yeah, I'm just waiting for him to get his audio on. So you mentioned that you feel that the immigration policy in America is, totally unacceptable, that it's cruel. Could you name a country whose immigration policy you think is more just?
Name a country.
Somebody who's more fair towards immigrants than America.
Well, I strongly believe that the United States has immigration policies that are pretty strong and advocate for minorities, but I do believe that we can advocate for better than what we already have. And so that was kind of the point that I was trying to make, is that we can reach for more than what we currently have right now.
Okay, but there's no examples you can give me of places that do a better job of it.
As of right now, fortunately, no.
Okay, thank you very much.
You're welcome.
Any other questions from the committee members? Seeing none, thank you all very much for being here. Next, we have 2 favorables left. It's my understanding Reverend Kobe Little is not in the waiting room. And we have Rena Shaw. And then just 2 unfavorables after that committee. And then okay, so Rena Shaw is not here. So we have the 2 unfavorables, 3 unfavorables. Shari Rendell, Brad Botwin, and Amy Wakehoff. Okay, 1 second, let me find my. Okay, so I don't see Cherie Rendell.
I'm here.
Oh,
I'm
I
ready.
can see you. Okay, yeah, I'm looking at you. Okay, so you can start and you'll have 2 minutes.
Vice Chair Atterbury and other distinguished members of the committee, thank you for allowing me to testify before you today. My name is Sherry Rendell. I'm the Director of State and Local Engagement at the Federation for American Immigration Reform. FAIR is a nonprofit, nonpartisan organization of concerned individuals that believe our immigration laws must be reformed to serve our nation's interests. Founded in 1979, FAIR has 3 million members nationwide and approximately 12,300 in Maryland. I am testifying today to express my strong opposition to HB 750. HB 750 provides taxpayers funded legal representation to illegal aliens, which undermines federal law. Federal law expressly prohibits governments from funding legal representation of aliens in removal proceedings. Aliens who wish to be represented by legal counsel are free to do so, but the federal law specifies it must be done at no cost to taxpayers. Many who support the right of illegal aliens to be given free legal representation in removal proceedings compare deportation to criminal prosecutions. In a criminal prosecution, the 6th Amendment to the US Constitution guarantees the accused the right to have the assistance of counsel for his or her defense, including at the taxpayer expense. However, immigration proceedings, including those for removal, are civil and not criminal and do not trigger this right to counsel. In fact, the Supreme Court has ruled that deportation is not a punishment, but rather a civil administrative proceeding whereby somebody residing illegally in the United States is returned to their homeland. Moreover, providing counsel at taxpayer expense to those illegally in the country is patently unfair. Taxpayer-funded legal representation is generally unavailable to citizens or legal immigrants who have civil proceedings such as foreclosures, evictions, divorce, child custody battles, and even non-criminal administrative disputes with the government, such as disputes over taxes, licensing, or zoning. Providing this representation to illegal aliens is misguided and patently unfair to the citizens and legal residents who are required to pay out of pocket for their own civil proceedings. Additionally, this bill uses taxpayer funding to support and advance a politicized agenda. Instead of directing resources to the needs of the community as a whole, it's promoting welfare rights for those who are here in this country illegally, those who are violating our federal law simply by their very presence in the United States.
Ms. Rendell, I'll have to ask you to wrap up, please.
The bottom line is HB 750 tells Maryland residents that certain segments of our population are more important than others and entitled to special privileges. For this, FAIR urges an unfavorable report on HB 750. Thank you for your time.
Thank you. Next, Brad Botwin for 2 minutes, please.
Great. My name is Brad Botwin, and I'm the director of Help Save Maryland. I'm here today to express my serious concerns with HB 750, a politically motivated bill promoting lawlessness and state sanctuary introduced for the sole benefit of Maryland's growing illegal alien population and their local enablers. The idea of having Maryland citizens, Black, brown, and white, paying the bills of illegal aliens trying to stay in the U.S. via the Office of the Attorney General, to me, is frankly criminal. The bill has many outrageous sections, but my favorites include, quote, if the individual is a Maryland resident who is detained outside the state and the AG coordinator cannot get them legal representation, then the coordinator shall give the individual a stipend to subsidize their legal representation costs. The AG coordinator must also designate community groups, CASA, CARE, others, to educate individuals and families impacted by immigration detention by hosting Know Your Rights workshops, distributing written information, assisting communities in the formation and maintenance of neighborhood defense committees. Defense committees? The $8 million promised in this bill is just a down payment on the future tens of millions that will be demanded down the road. The law provides legal representation, as we've heard, for criminal prosecutions only. Most immigration proceedings, as others testified today, are civil and do not trigger free representation. The Supreme Court has ruled that deportation is not a punishment, but rather a civil administrative procedure whereby an illegal alien is returned to their homeland. Providing taxpayer-funded legal representation is unfair because it is unavailable to legal immigrants or citizens, again, Black, brown, white, or Asian, who are required to pay out of their own pockets for any civil legal proceedings. Aliens who wish to be represented by legal proceedings are free to do so on their own nickel, especially those that are working in Maryland illegally, by the way.
Mr. Botwin, I'll have to ask you
Blacks, browns,
Mr. Botwin, I have to ask you to wrap up, please.
Yes. In closing, jeopardizing the safety and well-being of Maryland citizens, similar to what is happening in sanctuary cities around the country, is just wrong. I ask the committee to not pass this bill.
Thank you. Amy Wyckoff for 2 minutes, please.
My name is Amy Wyckoff, and I have lived in Montgomery County for over 33 years. Thank you for giving me the opportunity to provide testimony on HB 70. This bill would set up a full-time, taxpayer-funded office to provide legal representation to illegal aliens facing deportation. This legislation is in direct contravention to federal law, which only allows illegal aliens to retain counsel at their own expense or pro bono. While federal law provides legal representation for criminal prosecutions, deportation is a civil administrative procedure. This bill is therefore unfair to citizens and legal immigrants who must pay out of pocket for civil legal issues such as foreclosures and eviction proceedings. In a time of budget cutting during the pandemic, it is astounding that the Maryland legislature would even consider this outlay on behalf of illegal aliens. Additional costs in this bill would be incurred due to the requirement for extensive educational efforts to make sure illegal aliens know that this free legal aid is available to them. Illegal aliens residing in Maryland who are in another state when facing deportation will also receive this financial aid. The legislation even provides, quote, a stipend to a designated community group to facilitate coordination between out-of-state legal representation and the covered individual's family members, unquote. In conclusion, House Bill 750 is an affront to the rights and pocketbooks of Maryland citizens and legal residents. Thank you for this opportunity to testify.
Thank you very much. Are there any questions from the committee? Delegate McComas? You're on mute, Delegate.
You may not know, but I'm kind of curious because if we provide healthcare, lawyers, we have nonprofit groups that assist. My question is what I'm worried about is that we're going to just be kind of like, come to Maryland, the land of pleasant living. We take care of all your problems. And do we have any idea? I mean, am I correct in that assumption? That this is just another welcome to Maryland sign? We'll carry all your problems. If anybody cares to respond to that. By giving the right to count.
Yeah. Sherry, go ahead.
Delegate, I can provide the committee with the costs of illegal immigration to the state of Maryland. We do have those numbers. With respect to your question, anytime you provide benefits, it's a magnet towards other illegal aliens coming into the state. So to answer your question, the answer is yes.
Could you provide us with some documentation? Because I think you guys have studied this quite a bit.
We do. We have a cost study from 2017, and we are actually in the process of updating it at this point. But I will provide you the 2017 study.
Would you please make sure you provide it to the whole committee?
Absolutely.
Okay, thank you very much. Thank you, Chair.
Thank you. Delegate Bartlett.
Oh, I think.
Yes, Amy Wyckoff, do you want to respond?
Yes, if you just look at what happened in Montgomery County, starting in 2014 with our sanctuary policies, we put out the welcome mat for illegal aliens to come, and we had big increases in gang activity. In 2019, we had a series of heinous sex crimes against women and children, and those are mostly women and children who may be legal immigrants in the same communities where the illegal aliens are residing. So providing a welcome mat to illegal aliens hurts all Marylanders. Thank you.
Well, Ms. Wyckoff, I don't mean to be flippant, but if you could provide the committee with the actual documentation, because I know through the press what you're saying is correct, but because we get so much information, sometimes it doesn't register. So I think if you could do that, that would be wonderful, or maybe get something from the crime statistics of your county. That would be very helpful. But I know there's been some horrific things go on in Montgomery County.
Yes, I'll work with Sherry to provide that to you.
Okay, and all the members of the committee. Thank you very much.
So if I could just jump in real quick, Delegate McComas, I think a good analogy to this would be when in-state tuition was first allowed in the state for illegal immigrants, in-state college tuition. I testified there. Of course, CASA was there, and we were told only dozens of kids would qualify for this. Now we have thousands of kids receiving in-state college tuition subsidized by Maryland taxpayers. The stats on that, in fact, if you go back to the original law, was supposed to be tracked by each university and college, and also tracked and reported to Annapolis. So, we can get those stats, should be available, and we should use those to see the trajectory from basically nothing to tens of millions and more dollars each year spent on subsidizing college education for non-citizens.
Would it be possible you could get that for the committee too, together?
We can try. I mean, it's
I don't
supposed
mean
to
be sloughing off work, but we're inundated. And so anything that you can help to get in front of little faces would be helpful.
We will try to track it. It's supposed to be on the websites of the different universities, how many students are receiving in-state. But we'll have to see if we can get that. I'm sure it's not being reported.
I truly appreciate that. Thank you.
Delegate Bartlett.
Thank you, Madam Chair. My question is for Mr. Boatwin. And I wanted to know, is there a way to distinguish a taxpayer's dollar coming from an undocumented immigrant and a Caucasian, white-skinned American, or anyone else?
Well, if you, I'm unmuted. If you had access to their job and their statistics, clearly, do they have a social security number, or do they have an ITIN number? Are they participating? Is the company participating in E-Verify, which would let you know if they're illegal or not. So there are many ways to track the differences
No,
between
actually, I'm
Black,
asking a
white,
different
Asian,
question.
and others.
I appreciate your answer, but that's not what I'm asking. What I'm asking is, when I give you $1, or when you give me $1, and give it to the state, is there a way for me to tell whether or not that dollar of that taxpayer came from you or anyone who is not a documented person in the United States?
That's a pretty broad question, but I can go to online, and I live in Montgomery County. I can go look at any particular school, and I can see the undocumented population in the school system that I'm paying for 17 grand plus.
I asked you this question, Mr. Boatwin, because you were mentioning about taxpayers, and I wanted you to make sure that because it seemed that you were saying that individuals with respect to this bill would be using taxpayer dollars. Is that correct?
Of course, you're using taxpayer dollars. It's going to be
Right.
appropriated.
So my question is, if you are an individual who pays into the tax system, you are entitled to the benefits that come with the state tax dollars. Would you agree?
They are entitled to be deported because they are working illegally.
So they should pay for their deportation. That's what you're saying. Okay.
They shouldn't be working.
Excuse me?
They should not be working.
So one more quick question to you, Mr. Boatwin. Should the employers also receive either criminal charges or somehow be held within the system, not a fine, but criminally charged, and this is for Mr. Boatwin, be criminally charged for having any workers who are undocumented?
The simple answer is yes. However, that is a federal case, although the state of Maryland could actually go in.
Of course, a state of Maryland could easily do it.
My only
concern is I hear it from one side and one side only, because I know that there are many undocumented individuals who work and who pay their taxes based on the testimony we heard earlier today. And they've lived here for several years. They've had generations who have lived here. So I can't even count the amount of tax dollars they might have put into the system. And I don't hear anything about also doing something to their employers, because if they're paying tax dollars, somebody is employing them, right? So
yes.
So what do you think we should do with their employers?
So the best thing would be Maryland should mandate E-Verify, which is an electronic system from Homeland Security, and it should screen all employees. And if those employees come up when you punch in their phony social security number that they are not legally allowed to work here, and they still allow those people to work in their facility, those employers should be fined and the workers should be obviously deported because they're using false information.
Thank you. I appreciate your testimony, Mr. Bowen.
Delegate Erican.
Thank you, Madam Chair. My question is also for Mr. Boatwin, who
actually Botwin.
Botwin, yeah, sorry about that, sir. Botwin. I think he answered the last questions really well, and perhaps maybe Sherry might have the answers to this as well. Is there any concrete data that you all have about the actual amount of money that people are likely to have actually earned and the actual amount of money that they actually contribute in taxes? Is there any data on that?
So let me jump in here.
That's sure.
FAIR has done a cost study which talks about the amount of taxes they have paid versus how much benefits they have received from the state. So we will be providing that. That was what the the delegate requested previously.
Yeah,
And
that would be really important because in the industry that I work in outside of this job, I do a lot of this kind of tax stuff. And I can say, at least in my personal experience, it's usually cash industries, as I'm sure many of you know. People usually own their own businesses. And oftentimes, not only do they not pay hardly any corporate taxes or personal income taxes, but sometimes they don't even remit the sales tax that belongs to our state to the state. It is an endemic problem, I've found. And so it really gets tiring, I'm sure, as you can agree, Mr. Botwin, to hear people say that these people are paying their taxes, that they're taxpayers over and over again and used to shame us. Wouldn't you say that that gets very tiring when it is in fact highly unlikely that it's actually true?
Yeah, if they would bring in their stubs and share them with the committee, I'm sure that would be great in their tax forms. I also noticed that almost every person testifying today with the translator was either severely ill or their wife was severely ill, another drain on our society. So again, there is a way to come in. There was one fellow who testified that he was Jewish from Eastern Europe. That's where actually my family came from in the early 1900s. Okay?
Mine as well.
Yes, we came by boat. We came here legally, and we didn't have any services. Okay, and everybody worked, and everyone pulled the money, and everyone went to school. Then the whole next generation had college educations.
And no one wanted to hire us because no one wanted to hire Jews back then.
Well, that's another.
Yeah. I have one last question. Would you support, as Congressman Harris and myself does, expanding temporary work visas and ways for people to come here and do the jobs that they're doing illegally right now in a legal manner if they cannot find US citizens willing to do these jobs, like working on farms, sometimes very hard. The crab industry struggles a lot. Do you support those types of visa programs that offer legal immigrants to come here?
Yes, in fact, the gardening service that I use in my home does just that. So they bring in people every year and they go home every year at the end of the season. And that's why I hire them. And I pay a little bit more, but because they're using the system and the process, that's why I use them. And you'll ask me the name and I don't know the name off the top of my head.
No, that's okay. I
definitely sent it to you.
I very much appreciate your sentiments on that. And I agree with you. Thank you very much.
So that concludes the testimony on House Bill 750. We are going to go on a break, committee, until 7:15, and we will return. We have 2 more pieces of legislation. Please remember to mute yourself and to turn your video off. And we'll see you at 7:15. Thank you. 7:25. 7:25, guys. 7:25.
Members of the committee should begin to return. We will be beginning in 2 minutes. Members of the committee should begin to return, coming back in 2 minutes. And as a reminder, we are still live streaming. If staff would turn my video back on, I would greatly appreciate it. Okay. Members of the committee, if you'd please come back to the room, turn on your cameras. We are going to begin the hearing momentarily. We are waiting now for Delegate Juanita Fisher, who will be presenting the next bill, House Bill 304. We're waiting for her. So we'll give her a moment to come back.
Kurt, you're upside down.
Delegate Anderson, haven't seen that. You're upside down, Delegate Anderson.
How did that happen?
I haven't any idea how that happened, but we're all intrigued by how that happened.
I don't know how this happened, man.
Does your computer allow you to flip it upside, like backwards, open all the way? Oh, now you're sideways.
There we go. There we go.
There you go.
I'm a genius.
You are.
Yes.
I was about to say, because I was not going to be able to focus seeing you upside down. I'm glad you fixed it.
Some people say that sitting through these hearings can be roughly the equivalent of being,
Pretty much.
I don't think so, but some people say that.
Hey, can you guys do me a favor and can somebody kick
Delegate
that-
Shetty, we can hear you.
Yeah, I know. Can somebody else kick the Delegate Shetty account out? Because I left my laptop on it at the
Oh, that was done. There are not 2 Delegate Shettys. All right. We have Delegate Juanita Fisher. We are going to go ahead and get started at 7:27 on the 3rd of March. The second part of our House Judiciary hearings today. And this is House Bill. We have 2 bills remaining. House Bill 304 with Delegate Juanita Fisher. We'll also hear from Nick Katz, Maria Perez, Jorge Benitez Perez, Antonio Duval, and Daryl McSwain. On my list, Maria Perez is a person who speaks Spanish primarily, and so we'll be doing our translation with Ms. Perez here in a moment. But we will go ahead and begin with Delegate Fisher, please, for 3 minutes. Delegate Fisher.
Thank you, Mr. Chair. Thank you, committee. I know it's been
been a long day. For the record, my name is Delegate Wanika Fisher, and I'm here to present to you all HB 304, Participation in Federal Immigration Enforcement, which has known as the Maryland Trust Act. You have seen this bill before in different iterations. For the last 7 years, there's been some amazing House sponsors before, like Delegate Moon, and I'm excited to present this here today. And my Senate crossfile is the chairman of JPR, Will Smith. I put in my written testimony a lot of what I think when it comes to the public safety measure. And if I have enough time in my 3 minutes, I will try to address that. But something I wanted to give you on this bill, and you'll hear it through the stories, is really my story and the story of the people that I serve. So a lot of you may or may not know, I'm a first-generation American. I was blessed to be born in the United States. My family immigrated here from Nigeria and South Africa, and I'm a mixed status family. There are members of my family that are not US citizens. And there are members of my family that fear reporting crimes, that fear going to get a protective or a peace order, that would not come to testify in court if they were a victim in a crime because of our participation with ICE. And I would tell you that the district and that I represent, and the stories you're going to hear, I am blessed to represent. I always say we're tiny but mighty. We're small geographically, but we are mighty in our numbers and in our experience. And I represent one of the most diverse districts in the entire state of Maryland, in which my community is Black, is brown, it's white, it's every shade. But what we all have is that our neighbors, our immigrant neighbors, are living in fear and need trust in law enforcement. Over this session and year, there's been a lot of talk about police reform, so many issues. And for me, I would say it is so important that our communities feel safe to interact with law enforcement so that we can see justice. And the Maryland Trust Act will, as you hear, as it's laid out in its points, will be able to do that for our community and not just make our immigrant neighbors and friends feel safer in Maryland, but will actually make all of us safer, because you cannot prosecute a case if no one's there to testify, if no witness is showing up. And for me, the Maryland Trust Act will do that. The stories you're going to hear, a lot of them are my constituents that are going to be on this call. I cannot tell you how near and dear and important this legislation is, not just for me, but for my community. So I just hope that you all have a listening ear, a respectful tone in your questions, and give this bill the justice that it deserves. Thank you.
Thank you very much. Here's what we'll do. We'll talk, going to hear from Nick Katz next for 2 minutes. I will alert the translator that we will hear from Maria Perez last. So it will go Nick Katz, Jorge Benitez Perez, Antonio Duvall, Daryl McSwain, and then William Garcia. So let's go ahead with Nick Katz, please.
Thank you, Chair Clippinger, Vice Chair Atterbury, and thank you so much, Delegate Fisher, for sponsoring this bill and for that powerful introduction. I thank you all for the opportunity to testify today in support of House Bill 304, known as the Trust Act. As Delegate Fisher laid out, the bill has a simple purpose: to ensure that immigrant Marylanders feel safe going to work, accessing services, calling the police, or otherwise engaging in everyday activities without fear of being put into the deportation system. For the last 8 years, the Trust Act has been the #1 priority of CASA's members. We have more than 90,000 members in the state, and this is what they have chosen as their primary bill to support each year because it impacts their families. They see their families torn apart by the broken immigration system with unnecessary collaboration from our state. This must end. You'll hear directly from impacted members about the devastation this has brought upon their families. These stories are why Delegate Fisher introduced the bill, to ensure that we protect the members of our community, your constituents, from needlessly being entangled in a broken immigration deportation system. More than a dozen jurisdictions in Maryland, including some of the largest, Prince George's County, Montgomery County, Baltimore City, have passed trust policies, and they're working. But these policies aren't enough. They don't protect our members from state police. They don't protect our members when they cross county lines. They don't stop jurisdictions from entering into 287G programs. Only you can do that through this bill. You'll hear arguments from the other side that this bill will allow violent criminals to go free. This is not true. This bill does nothing to alter the criminal justice system. Someone commits a crime, they can be arrested, detained, and prosecuted for it. In fact, as Delegate Fisher pointed out, this bill helps support the criminal justice system by ensuring that defendants are presented for court, victims feel safe testifying, justice can be achieved. Even under more favorable administration at the federal level, ICE will continue to do what it is tasked to do. It's going to round up and deport members of our community. So Maryland can't change federal immigration law, but we can and we must choose not to aid these efforts. CASA strongly supports HB 304, urges a favorable report. Thank you for your time and attention today.
All right, thank you very much. We're going to hear now from Jorge Benitez Perez, please.
All right, good evening, delegates. My name is Jorge Benitez Perez. I am a DACA recipient and a resident of Prince George's County. In 2018, I feared the worst would happen to my mother. A Prince George's police officer arrested her and turned her over to ICE. The ICE agent questioned my mother after she was transferred to him. He let her go because he noticed that in her many years of being here, 16 to be exact, she had not committed a single crime. He let her go under the condition she report to ICE in Baltimore, and she complied. After her second report to ICE in November of 2018, a different agent had set my mother's deportation to January of 2019. I arrived home from school and my mom handed me a paper. It was her check-in sheet, and it said, bring passport and airplane ticket to leave the country. This devastated me. It was my mother, my only parent, the person who has always been there for me no matter how hard things get. And for my mother who was undocumented and the woman, things were very hard. I was 19 at the time, first year in community college. I did not know much about politics, so I started doing research. And that's where I found out I have 2 senators and a representative. And I reached out to all of them in a desperate plea for help with my mother's deportation. I also reached out to State Attorney Brian Frosch's office, not knowing what his role was, but because he had attorney in his title, I figured he'd be helped. I heard back from offices of Senator Van Hollen and the state attorney, both giving me words of encouragement and their commitment to have my back. After finding a good attorney, my mother's deportation was placed on a temporary pause. And since 2018, my mother's well-being in this country has been in limbo. I had to drop out of school and work full-time in order to have savings in case the worst happens. On the 18th of this month of March, I will finally know what a judge will rule, whether my mom stays in this country or she goes back to the country she escaped from and the country where her abuser is. We are optimistic and hoping for the best. And while this has happened, we have not sat back with our hands crossed. Along with CASA, my mother and I have fought hard for the unanimous 11-0 vote here in Prince George's County to turn it into a sanctuary county. Just as we are here today fighting for our state of Maryland to give immigrants the dignity and respect we all deserve. We are not criminals, gang members, or the villains we are painted to be. We are human like all of you. It has been 3 years since that horrible incident with the police. 3 years in which a trust act could have been passed in Maryland.
Mr. Benitez Perez, if you'd begin to wrap up, please.
All right, we saw how horrible the last 4 years were. Who says it can't happen again? The time for a trust act is now. Please vote in favor of the trust act. Thank you.
Thank you very much. We're going to go to Daryl McSwain, please. And this will be the last person to testify before we go to the person who needs translation. Daryl McSwain.
All right. Well, thank you, Mr. Chairman and members of the committee. I'm Chief Daryl McSwain, the Maryland National Capital Park Police. And for your information, the full Maryland National Capital Park and Planning Commission statement position is in the record for your review. As a public safety official for over 32 years, I express my support of House Bill 304 for 4 primary reasons. First of all, it prevents members of the public from suffering in silence out of a fear of calling the police for help, thinking that they will be reported to federal authorities by us. Too many remain in silence, and allow themselves to suffer domestic abuse, extortion, sexual assault, etc., while others go without critical medical care or school. Secondly, immigration is a federal law. It should be handled by the federal government. Third, it protects community members from discrimination based upon their immigration status while accessing critical services. And fourth, a uniform state law will reduce confusion within the public and between various law enforcement agencies by providing one standard. Thank you for the opportunity to speak in favor of such a humane and important public safety matter.
Thank you very much. Now, if staff would please prepare quickly, we will hear from Maria Perez. Maria Perez, who I know was on the call a moment ago. And are you there, Ms. Perez?
Sí. Adelante,
Okay.
María. Buenas noches, delegado, mi nombre es María. Gracias por la oportunidad de dejarme hablar ahora. Quizás ustedes conocen a mi hijo Jorge, porque él es el que está luchando por mí desde el día que la policía me pasó a oficiales de migración por una violación de tráfico. Primero, comparto con ustedes que yo tengo 16 años de vivir aquí. Como muchas madres solteras, he trabajado duro para que mis hijos tengan una oportunidad de ser exitosos en este país. Me fui de mi país, El Salvador, para escapar de una relación tóxica donde era una víctima de violencia doméstica. Y el 31 de mayo del 2018 pensé que iba a regresar a esa misma situación. Ese día fue cuando fui parada por exceso de velocidad por un policía del condado. Yo pensé que iba a recibir una multa, pero no. En lugar me pusieron esposas, me llevaron a una estación de gasolinera y me entregaron a un agente de migración. No cometí ningún acto criminal, pero me hicieron sentir como que si yo era una criminal. La policía de Prince George ha pedido disculpas por haberme entregado a ICE, pero ese error de ese agente policía me puede costar mi familia. Ese error me puso en proceso de deportación. Ahora puedo ser separada de mis hijos. Mis hijos que solo conocen este país y hacen parte de esta comunidad. El 18 de este mes, la corte que va a decidir si me quedo en este país con mis hijos o si me deportan para el país que escapé, para una mejor vida a mis hijos. Para terminar, les pido que por favor pasen el acto de confianza. Este acto asegura que ninguna familia más tiene que sufrir por la separación de su familia. Y más que todo, asegura que nuestros policías no actúen como agentes de migración. Necesitamos reparar la relación entre comunidad y policía porque es tanta deportación ha causado por los policías que perdamos a nuestras confianza en ellos. Han pasado 3 años desde mi encuentro con la policía. El tiempo para el acto de confianza es ahora. Por favor, les pido con el corazón en la mano que nos ayuden. Mis hijos no pueden quedar solos, no me pueden separar de lo más valioso que yo tengo, por lo que yo lucho. Por
Señora
favor,
Perez.
no pido nada más.
Gracias.
María.
Gracias. Are there questions for this panel?
I just wanted to add
Please.
that Maria added to her testimony at the end there, if for all of the legislators to put their hand over their heart, that she's not asking for anything more but the opportunity to stay here and continue to fight for the things that are most valuable for her, which is her children, and that she's very proud to be here testifying with her son Jorge today.
Thank you very, very much. Are there questions for this panel? Seeing no questions for this panel, we greatly appreciate hearing from you this evening, and thank you for your testimony. Thank you very much. What I believe I would like to do, well, I'm not sure the best way to do this. I'm going to call a group of people who are not indicated on my list as needing Spanish language translation to give Ms. Roque the opportunity to begin to organize the other people who do need Spanish language translation. So if I name anybody on this next group that needs Spanish language interpreting, please just let me know. Jose Gutierrez, Flor Garay, Jasmine DeCola, Ben McShane, Kai Hagen, Joanna Silver, Joe Spielberger. The next panel will be people who will require Spanish translation. Jose Gutierrez, please.
Yes, I'm here.
That's great. Could we see you on video, please?
Yes, 1 second.
Okay. All right. It'll be 2 minutes when we get you on the screen. There we go. 2 minutes, please, Mr. Gutierrez. Can you hear me, Mr. Gutierrez?
Yes, I can hear you.
Go right ahead. 2 minutes.
Okay, so my name is Jose Gutierrez, and I am a Frederick County resident. I am in support of this bill because our families are vulnerable with ICE being present in our communities. The risk that we face daily have a negative impact in our families. So I have a family member who was arrested by the sheriff department in Frederick County and was turning into ICE. He was not a criminal. He was a hardworking man. He attended church. He actually taught Sunday class, and he was an exemplary person, and he was deported. Our families were negatively impacted by ICE, and that's why I am supporting this bill. In Frederick County, there's a lot of fear because the sheriff is profiling people, and we can see this in the most recent case that we had of Sara Medrano, that she was racially profiled, and we can see that by the result. And we just want ICE out of our state, out of our community, so we can feel safe. I just want to say thank you for letting me testify.
Thank you very much. We'll hear now from Flor Garay. Okay, Flor Garay not in the waiting room. Neither is Jasmine DeCola or Kai Hagen. We'll go then to Ben McShane, please.
Kai Hagen is here.
Oh, I'm sorry, Kai Hagen is here. That's fine. We'll go ahead and take testimony now then for 2 minutes.
For me?
Yes, Kai Hagen, go ahead.
Okay, I'll try to be quick then. Thank you all for allowing me to be here. I am Kai Hagen. I'm a county council member in Frederick County at large. I'm here to support the Trust Act, which would end our county's contract and prohibit future ones. Rather than repeat a lot of the excellent information you have already heard on this issue and we'll hear from others, I want to offer a different perspective. I was one of 5 county commissioners in Frederick County when the then first term sheriff Chuck Jenkins signed the initial agreement to participate in the 287G program. Our experience with the county during the years since has been considerably different than we were led to believe 13 years ago, when very little was known about the program, honestly, anywhere. And contrary to what the sheriff endlessly repeats, our community is not safer because of our participation in 287G. Today, we are a county replete with enough personal stories continuing over a long period of time to make it abundantly clear that despite the blanket denials, racial profile has been going on in our county and will continue to do so. And you have heard a lot and know a lot, I'm sure, about how the ways in which that affects the community that I don't have time for today. Our sheriff has very clearly stated that there isn't any systemic racism in the law enforcement and justice systems, not just in Frederick County, but anywhere in the country. And he said this recently. This is the man who is responsible for applying 287G in our community. In that light, I think it is relevant to note that this is the same man who has said that law enforcement has been sold a bill of goods by the governor and that he's not enforcing any of these silly COVID rules. He says that COVID-19 is going to prove to be the biggest fraud ever. He insisted that and continues to. Pardon?
I'm sorry, please. We can't interrupt the testimony, please. Mr. Hayes, continue.
Okay, thank you. You know, all this is on video as well, and in multiple different instances and meetings. He said COVID is going to prove to be the biggest fraud ever. He's insisted that President Trump was cheated out of the election and Biden is not a legitimate president. He has suggested that liberals don't want to enforce anything.
Mr. Hagan, however, you're reaching the end of your 2 minutes, and if you would like to sum up with your testimony on this legislation, I would appreciate it.
Okay, and my point is that this is the person who is enforcing and has been from the beginning, who signed the agreement in Frederick County and has contributed to a lot of the problems around racial profiling and other concerns in the community that have led me and many others, a growing number of people in our community, to support this legislation and anything.
Thank you very much.
Thank you very much.
Thank you very much. I understand now that Flor Garay is in the waiting room and to be able to join us.
Yes, I'm here.
That's great. Could we have you please turn on your video?
Turn on my video?
Yes, please.
1 second. All right.
Great.
Okay. Great.
Go ahead, 2 minutes.
Okay, my name is Flor de Maria Garay. I live in Frederick, Maryland in District 3A. I'm submitting testimony in support of HB 304, the Trust Act, to prevent local enforcement from partnering with ICE and rebuild relationships between law enforcement and the immigrant community. As you know, immigrants in Maryland have been targeted by unjust federal immigration enforcement with the assistance of state and local enforcement officers who are deputized through 287G program. From the beginning, 287G programs have led to countless stories of racial profiling and discrimination, harassment, and illegal stops, arrest, and detainment. The impact of these unjust policies is not just felt by individuals, but threaten entire communities. When Maryland families and residents live in fear of interacting with police, it makes everyone unsafe. My mother had a scary experience while driving in Frederick County. She was pulled over by a city police officer for allegedly missing a stop sign. The city police officer inquired about my mother's immigration status. He explicitly asked if she was a US citizen. She was lucky to be carrying her passport card in her wallet, something she never thought she would have to show to a police officer. The city police officer was aggravated that my mother was able to prove her legal status, that he almost ripped off a part of the warning that he issued her. What happened to my mother is not uncommon in Frederick County. The anti-immigrant rhetoric by the Sheriff Jenkins has exacerbated the pattern and practice by police that deliberately discriminates against immigrants of color. My mother and I attended the 2018 Frederick County annual hearing on 287G. My mother had not testified yet when Sheriff Jenkins explicitly denied that these violations were taking place. My mother was disappointed to hear that the sheriff that is supposed to protect our communities was implying that our experiences with discrimination and racial profiling by police was a lie. My mother, while very scared, walked up to the podium to share her experience and let the Sheriff Jenkins know that this is a problem in Frederick County. It's been more than 3 years since that public hearing occurred, and we have not seen any change in the way policing take place in Frederick. If anything, what we have seen is more cases of racial profiling and violation of our civil rights. Sheriff Jenkins can no longer deny what happened to Sara Medrano nor Roxana Orellano Santos. An apology from Jenkins is not enough.
Ms. Garay, please, if you would wrap up your comments.
We need this legislative body to look at this issue with great sense of urgency. For years now, Marylanders from across the state have testified in the General Assembly why our state should not continue to partner with ICE. We can no longer deny that immigrants have the right to feel safe and welcome in Maryland, and their constitutional rights and dignity are protected. Now is the time to pass the Trust Act, so Maryland fully acknowledges the humanity of our fellow immigrants, neighbors, and keeps all of our communities safe.
Thank you very much. All right, Alderman Ben McShane, please. Alderman McShane, need to unmute yourself. Holding on to let Alderman McShane unmute himself, please. Well, I don't think we've lost him. Alderman McShane? All right, we're going to come back to Alderman McShane. We'll go to Joanna Silver, please.
Thank you. My name is Joanna Silver, and I live in District 18 in Silver Spring. I am testifying in support of HB 304. While I offer my testimony in my personal capacity, I would like to share a few observations from my work as a federal public defender about the ICE detainer aspect of HB 304. The most populous jurisdictions in Maryland already have policies prohibiting corrections officials from holding someone on an ICE detainer without a judicial warrant. As a result, I have represented many people for the crime of illegal reentry who were released from a local detention center, either pre-trial or after completing a sentence, and who were then arrested by ICE in the community. I have repeatedly seen ICE demonstrate that it does not need the assistance of our local governments to take people out of our communities. These arrests are easy for ICE because immigrants charged with or convicted of crimes usually have the same strong ties to our community as US citizens. They are usually arrested at their homes, with their families, or on their way to work. I have represented people arrested by ICE while they were under the supervision of one of our criminal courts, and they are almost always complying with that supervision at the time of their arrest. In addition, it is easy for ICE to get a judicial warrant if there is probable cause to believe someone has committed a criminal immigration offense. ICE and a US attorney can present a criminal complaint to a federal magistrate who can issue a warrant. There is a duty US attorney and a duty magistrate judge on call at both federal courthouses in Maryland every day. Similarly, the US attorney can convene a grand jury to obtain an indictment, which can also be the basis of a judicial warrant. If ICE has probable cause to believe someone violated a criminal law, it can get a judicial warrant. If it does not, it should not be permitted to circumvent the Fourth Amendment by asking a local law enforcement or corrections officer to detain someone. For this reason, I urge you to support HB 304.
Thank you very much. We're going to go to Joe Spielberger, please. Joe Spielberger for 2 minutes.
Good evening, Chair Clippinger, Vice Chair Atterbury, and committee members. Again, I'm Joe Spielberger here representing the ACLU of Maryland in support of HB 304. I want to lift up again the story of Sara Medrano in Frederick County, who was targeted simply because of her race and illegally detained for ICE, which is just one example of the type of racial profiling and abusive police practices that have infested 287G programs from the very beginning. When Sheriff Jenkins testified last session that they didn't have any of these issues in Frederick County, he was in negotiation settlements in a lawsuit filed on behalf of Ms. Medrano and the RISE Coalition. And earlier this year, Sheriff Jenkins was forced to issue a formal apology for wrongful detainment and the fear that his deputies caused when they racially profiled Ms. Medrano. You'll hear from some members of law enforcement who say that their agencies don't care about people's immigration status during minor incidents and police encounters, but they certainly cared about Sarah Medrano's immigration status that day, just like they care about the status of so many others here testifying tonight. You'll also hear a lot about crime, but let it sink in what it means when communities are afraid to report actual crimes because to them, law enforcement is the bigger threat. And it's this reality that makes a mockery of public safety. Vice Chair Atterbury, you often speak quite movingly about your own children and wanting the absolute very best for them. And I think as you and many members of this committee know, this is the whole point of this bill, to protect and strengthen families who call Maryland home. Maryland is not afraid of immigrants. Maryland depends on immigrants. And our attitude towards immigration reflects our very faith in the American ideal itself. So I trust that this bill will receive a favorable vote. But what the ACLU asks of this committee is that you prioritize this bill and show Maryland's immigrant community the same faith, dedication, and trust that they have shown to all of us. Thank you.
All right, let's try this again. Alderman Ben McShane.
Thank you, Mr. Chairman and committee members for having me here this evening. My name is Ben McShane, member of the Frederick City Board of Aldermen, and I'm here in favor of this bill. You have received written testimony from myself and my colleagues on the board, as well as from our city's mayor, Michael O'Connor. My colleagues and I have worked diligently over the last number of years to build a more inclusive and welcoming community here in Frederick, Maryland. We have overhauled our hiring processes, our contracting and procurement procedures. We've expanded our community outreach and communications department to become more culturally and linguistically competent, cognizant of the fact that Frederick boasts a widely diverse community, a growing immigrant community, and those citizens need to be reached by our community members, need to be reached by their local government. For us to continue the work of building the community that our residents deserve, we need trust in that community. And unfortunately, we do not have that right now. Many, many members of our city live in fear of local government. They live in fear of law enforcement. They live in fear of the illegal detentions that you've heard referenced today by other speakers. You've heard about the lawsuits, you've heard about settlements. Our residents know that they need to avoid contact with local law enforcement and with, unfortunately, local government. They've lived in fear too long of deportations and of local law enforcement doing the job of federal immigration. I ask you to please support this bill to help us build a community in Frederick, Maryland that our residents deserve. Para mis residentes, estoy aquí por ti. Siempre estamos juntos. Thank you, everyone.
If you would please translate the last portion, I'd appreciate it.
To my residents, I'm here for you. I'm here with you. We are always together.
Thank you very much. All right, I think we have everybody now. So that's fine. We will go ahead and take questions for the panel. Are there questions for the panel? Delegate Cox.
Thank you, Mr. Chair, and good to see you, Councilman Hagan. How are you today?
I'm fine, thank you.
I wanted to ask you, did you vote to authorize an audit of Sheriff Jenkins about the ICE program?
I supported, yes, I voted for a limited audit. It was much more limited in scope than I wanted to. It was a response to concerns in the community, and it was, as I said, limited in scope.
And that was about, that cost about $20,000, correct?
Yes.
And in fact,
slightly more.
And in fact, the audit showed that the program had not done anything wrong. The sheriff had not done anything wrong in the performance of the ICE duties in Frederick, correct?
Well, the audit was primarily a fairly narrowly cast review of the cost of the program within the department. It wasn't looking at all of these other issues. Most of the testimony that we're receiving tonight, for example, is about issues and concerns that have absolutely nothing to do with the audit or its scope.
And in light of the testimony tonight that we've heard, isn't it true that the sheriff through the ICE program has removed about 1,700 dangerous violent criminals from Frederick County?
Well, that is very much the subject of some disagreement and interpretation. The question is, one, what would have happened to the same criminals if there was no ICE program, which is often ignored? And two, a lot of people are referred to as dangerous criminals who are not.
Okay, so there were snipers that were removed from Frederick County, correct?
There were the two snipers years back were caught in Frederick County. That is correct. And there is nothing about ICE that made that more likely to happen.
And there were 112 MS-13 gang members. These are the gang, this MS-13 is the gang that actually cuts people's hearts out. They were removed from Frederick County through this program as well, correct?
Gang members that would also go through the normal judicial and court law enforcement and judicial system, be prosecuted, jailed, etc. Yes.
Okay. Thank you, Mr. Chair. And good to see you again, Councilman.
My pleasure. I hope you have a good day.
Thank you very much. Are there further questions for this panel? All right, seeing none, we thank you all very much. We're going to a Spanish-speaking panel. And I am going to, for staff, I'm basically going directly down the list. I believe that there are 6, double checking. I see 6 who are signed up to testify who are Spanish speaking and for whom we have translation. So with that, Desi Benitez, Glenda Gonzalez, Margarita Gallegos, Flor Quintanilla, Fabiola Lorenzo, William Garcia. I think that's it, actually. Yes, and that's it. So we're going to ask them to join us. We do again have the help of a translator, Gabby Roque. I'd like to begin. I'm going to try and stick to the order here so it's a little easier for staff. So do we see, we just need a moment here. I'm going to start hopefully with with Desi Benitez. But we need just a moment. So hang on one moment and we will figure this out.
Buenas noches, mi nombre es Daisy López.
Un momento, 1 minute, 1 second, just 1 second. Gabby can do that actually.
You said it perfectly right.
I'm still learning, but that's fine. Okay, we are ready to go and we'll put up her testimony. Daisy Benitez.
Ahora sí, adelante.
Gracias. Hola, muy buenas noches. Mi nombre es Daisy López. Gracias a todos los presentes por permitirnos hablar este día. Soy miembro de RAIS, Coalición Pro Inmigrantes, donde he aprendido mucho y doy gracias por todo el conocimiento que he tenido hasta ahorita y todo el apoyo. Estoy aquí porque estoy a favor de la ley 304. Ya basta de estar con miedo, temor, ya que nuestra comunidad, hay muchas familias que han sido afectadas con la separación de familia por la 287G, que ha causado temor hacia los policías y alguaciles, porque nuestra comunidad no quiere denunciar por temor, por miedo, y esto afecta a nuestros hijos, a nuestros jóvenes, ya que el perfil racial se ha aumentado. Y queremos hablar en nombre de toda nuestra comunidad que ya basta la 287G y que pueda ser aprobado la ley 304. Y también el dinero de los contribuyentes. Muchos somos contribuyentes en este país y se malgasta en la 287G. El caso como Sara Medrano es uno de los muchos casos que pasan en nuestra comunidad a diario. Estoy a favor de la ley 304 y ya decimos ya un hasta aquí, un basta, porque termine las violaciones hacia nuestros derechos. Muchas gracias por escucharnos y de corazón se los pido por nuestras familias que han sido afectadas, nuestros amigos y nuestra comunidad, que esta ley 304 pueda ser aprobada para que podamos tener nuestros derechos como comunidad, como representantes. Gracias.
Gracias. All right, we're going to go to Glenda Gonzalez now, please.
So Daisy also added a little bit at the end there, just saying that many immigrants like herself are also taxpayers and they don't want their tax money to be funding activities of ICE. And she says that she asked from her heart that all of the legislators pass this legislation for friends and her family.
All right. I think Glenda Gonzalez also is a Spanish-speaking witness. I think I see Glenda Gonzalez. If we could have her remarks put on the screen, please, by staff.
Buenas noches. Mi nombre es Glenda González. Vivo en Frederick y soy integrante del comité Levántate. Y como hispana estoy apoyando a que se apruebe la ley de confianza y se termine el temor que hay entre la comunidad inmigrante, trabajadora, que venimos a este país para un mejor futuro para nuestros hijos y se nos quite y se nos deje de etiquetar como criminales, pues la mayoría de nosotros venimos a trabajar y contribuimos a un mejor desarrollo local y estatal. El temor que vivimos todos los días al dirigirnos a nuestros trabajos o incluso ir caminando a dejar a nuestros hijos a la escuela, ese temor es real y pedimos que ese temor termine a la ley de confianza. Buenas noches.
Gracias. Thank you. We will now go to Margarita Gallegos, please.
Gracias, buenas noches. Mi nombre es Margarita Gallegos. Vivo en Frederick, Maryland.
Go ahead.
Thank you. Quiero agradecer esta oportunidad de escuchar nuestras voces. Yo estoy acá en favor de la ley de la confianza 304. En estos 5 años que he vivido en Frederick, he vivido con mis amigos, vecinos y familiares tantos casos de abuso y perfil racial. Amo ser correcta y amo lo correcto. Un año atrás tuve la dicha de conocer la coalición Raíz Levántate y poco a poco me he ido involucrando más y he podido aprender tanto sobre mis derechos y ayudar a tantas personas de una mejor manera. Por casos como el de mi amiga Beatriz, que sufrió tanto porque su esposo fue arrestado mientras era un copiloto que se dirigía a su trabajo. Y por no presentar un ID, él fue tomado preso por meses, tuvo que pagar una fianza de mucho dinero. Meses después él salió, pero quedó muy endeudado junto con su esposa. Aún tienen esas deudas. Y por casos también como mi primo Misael, que mientras él se conducía de un estado para otro, él era también copiloto y fue parado por la policía por no presentar un ID. Él fue preso y fue deportado a su país sin ninguna oportunidad. El caso de Sara Medrano, quien tuvo la oportunidad de ser representado por Rice, es solo uno de los miles de casos. Ella se apoyó en la coalición y su caso fue sacado a luz. El abuso cometido a ella fue aceptado por el sheriff pero el 99% de los casos nunca son demandados por temor. He luchado junto a la coalición contra la 287G por años sin ninguna...
Señora
nada
Gallegos,
favorable.
we need you to wrap up, please.
Ahora estoy aquí en favor de la 287G. Estoy apoyando la 287G. Creo firmemente que esta ley nos va a ayudar. Thank you.
Gracias. We'll go now to Flor Quintanilla.
Buenas noches. Mi nombre es Flor Quintanilla y vivo en la ciudad de Frederick, Maryland, donde tenemos el programa de la 287G. Vengo a presentar mi apoyo a la ley HB 304, que es la ley de confianza, para evitar que la policía local se asocie con ICE. Con la ley de confianza se podrá reconstruir la relación entre la policía y la comunidad inmigrante. En mi caso personal, vivo con el temor de que a través de un perfil racial o cualquier forma de detención ilegal se me haga hacia mi persona y pueda aplicar la 287G a mí. He escuchado muchas historias acerca de la 287G y en mi persona le tengo mucho temor a esa ley. Entonces, ¿cómo sabemos? Los inmigrantes en Maryland han sido el objeto de las autoridades federales de inmigración a través de perfiles raciales. Ese es el miedo de todita la comunidad inmigrante. Esta noche venimos a alzar nuestra voz y darle un voto de apoyo a la ley de confianza. Les pedimos a cada uno de ustedes que piensen en nuestras familias, que voten a favor de la ley de confianza, para que nosotros podamos recobrar esa confianza, que nosotros podamos como comunidad sentirnos en casa y así poder contribuir mucho más hacia con ustedes, a tener mucho acercamiento hacia las autoridades. Si es que, por favor, les agradecería que esta noche votáramos a favor de la ley de confianza. Buenas noches.
Gracias. We'll
And
now
just
go,
adding, oops,
go ahead
sorry.
briefly. Go ahead.
Just adding that she said that if immigrants could trust the police also, there would be a lot more ways they would be able to contribute and continue to support Maryland.
Thank you. All right, I understand that, I'm not sure if Fabiola Lorenzo needs a Spanish language interpreter, but it was marked down on my list as needing one. So Fabiola, are you there?
Fabiola, ¿estás aquí?
We do not see her in the waiting room, so let's go ahead to William Garcia, who is here.
Ok, vamos a continuar con William. William, adelante.
He has to take himself off mute. I don't know that in Spanish.
Tienes que quitar el mute.
Hola, buenas tardes. Mi nombre es William García Trejo. Estoy feliz por estar proponiendo la ley de confianza, la ley para no trabajar con ICE sin necesidad, porque no quiero que a las demás personas les pase lo que a mí me pasó. El domingo 27 de septiembre de 2020, la policía del condado de Harvard me detuvo por hablar por teléfono celular y me llevó a la cárcel de Harvard como resultado de no presentarme a la corte del condado de Montgomery por conducir sin licencia, corte a la cual yo me presenté y fue un error del sistema. Al día siguiente, lunes 28 de septiembre, el juez me dio una fianza de $400, la cual debía de pagar y quedar luego en libertad. Pero un trabajador del centro de detención del condado de Harvard me dijo que tenía que quedarme 48 horas hasta que ahí viniera a recogerme. Mi madre pagó mi fianza para liberarme a las 4 de la tarde, pero no me dejaron salir. Estuve en la cárcel toda la noche después de haber pagado la fianza. No tenía ninguna orden de arresto ni detención de ICE en mi récord. A la mañana siguiente, el 29 de septiembre, ICE me recogió y me llevó a la oficina principal en Baltimore. Me puso un monitor en el tobillo y me liberó con una orden de presentarme a corte y seguir todas las restricciones de ICE. El mismo agente de ICE en su oficina en Baltimore me preguntó a mí por qué estaba ahí, porque no tenía nada de migración en mi récord. Cuando ICE estaba recogiéndome en el centro de detención de Howard, los demás oficiales de Howard y pasó a otras personas con migración. Tengo miedo de estar deportado, de regresar a mi país por la delincuencia que se vive allá. Yo tengo una hija en este país, tengo una esposa, mi familia está acá, mi familia que depende de mí. Yo no quisiera que a nadie más le pasara lo que a mí me está pasando, porque lo que me está pasando es algo que no le deseo a nadie. Vivir con este grillete, eso ha afectado tanto mi vida porque no puedo llevar una vida normal. Mi vida ha dado un gran giro después de todo esto que me pasó y todo por un error de un oficial. Quisiera
So
que...
I want to make clear that William is explaining here, and it's not in his testimony, that he did go to his court case, and it was an error that it was marked that he did not show up.
I'm going to also have to ask him to wrap up because his 2 minutes has expired.
Últimos comentarios, por favor, William.
Que por favor aprueben la ley para que esto no le pase a nadie más. Porque no quiero que sigan separando familia. Así como la unión con mi hija y mi familia está en un hilo. Ahora, por favor, aprueben la ley. Gracias.
He said the unity of his family is hanging on by a thread, and he asked that you all please support this legislation.
All right. Thank you very much for your testimony here this evening. That concludes this panel. Are there questions for this panel? Seeing no questions, muchas gracias to everyone. And thank you all very much for your testimony this evening. All right, we're going to move to our next panel here. I'm going to go to Hugh Trong, David Bass, Giovanni Isalula. I did not say that name correct. Regan Vaughn, Zach, I can't get anything right all of a sudden, Zach Mansher, Mega Lama. We will hear from them, and then I think that will leave that. Let's just keep going. Daishi Miguel Tanaka, Hamza Ewing, Zachary Berger, and Reverend Kobe Little. And that will clear the rest of the favorable testimony, and I think it will keep us moving here. So we'll go to Hugh Trong. There you are.
Good evening, and thank you for your time. My name is Hugh Trong. I am many things, such as a Baltimore City homeowner and a member of Baltimore Asian Resistance and Solidarity. Today, I'm here as a PG County-born daughter of Vietnamese refugees who left Vietnam on crowded fishing boats in the middle of the night. As refugees in the 1980s, they had a smoother path to naturalization than other immigrants. My sister, who was 9 when she arrived, graduated from Western High School, then UMBC, and became an optometrist. I too graduated from UMBC and later earned a master's from Harvard. The difference between my family and our undocumented neighbors speaking today is simply their country of origin. My family was lucky. The US so regretted the war that we could enter the country with relative ease. Other families from other nations are not less deserving nor have less potential. I know this body can't change immigration policy. You can at least ensure that our undocumented neighbors can seek help from government agencies and law enforcement, particularly in the pandemic, and trust that they will not be turned over to ICE for it. My undocumented neighbors in the city have this protection. It's a shame that it ends when they enter the county. Delegates, thank you for your time. I strongly urge you to support this bill.
Thank you very much. David Bass, please.
Thank you.
2 minutes.
Good evening. My name is David Bass, and I'm a resident of Frederick County and a member of the Board of Education. In my role on the Board of Ed, I think deeply about educational equity. We can move toward educational equity when we create equal access to resources. This idea of equal access is essential in all parts of civic life. Access to law enforcement is in fact a public resource, one that is systemically denied to immigrant communities through the chilling effect of 287G. Strong communities are not created through racial profiling and threats of deportation. When local law enforcement partner with ICE, the effects for our students are devastating. Student mental health and student achievement suffer when our local law enforcement threatens to separate families. Our society need not function in this way. Passing the Trust Act is a step in repairing the relationship between immigrants and law enforcement. We have an opportunity to create stronger communities where people are not racially profiled and where children do not face the fear of being separated from their parents because of a traffic stop or other similar interaction with law enforcement. The well-being of so many of our students is at stake in this legislation. I urge you to pass the Trust Act. Thank you.
Thank you very much. We'll go now to Giovanni Isaiula. Maybe. I hope I didn't mess that up too badly.
It's Isaula, but it's fine. Hello.
Sorry.
My name is Giovanni, and I'm 15 years old. I'm a freshman at Polytechnic Institute in Baltimore City. I live in District 46, Chairman Klippinger. I am one of your constituents. I'm here today to urge legislators to pass the Trust Act for Marylanders like me, whose parents may not have a regular status in this country. 2 years ago, my mom's car was stolen and we decided to call the police. But instead of helping us, the police called ICE and treated my mom like a criminal. When ICE arrived, my mom was able to run back inside our house. But after that incident, ICE was always looking for her. One day, my mom's car broke down on the highway when she was going to work, and a state trooper detained my mom on the road for 2 hours until ICE came to detain her. I was really confused with everything that was happening because I thought that police officers would help us instead of detaining my mom. When I found out my mom was detained, I didn't know how to process what was happening, and my older sister put me into therapy. I wasn't really affected in school because I wanted to persevere and make my mom proud and show her that no matter what, I was still going to reach my goals. The hardest part about my mom being detained was seeing her inside the jail like she was a criminal, because I know that she is not. I also had to learn how to start taking care of myself since my mom used to cook for us, and she was the person who was always there for me. After my mom was deported, I felt like I was totally separated from her, and I thought about how sad she was going to be away from us. Some of you might know my mom and her story. Her name is Nora. She called in from El Salvador to support these bills since she got deported. I want to ask the legislators to put themselves in my shoes and imagine what it would be like to be separated from your family. There are many children in Maryland who are afraid of losing their parents because of ICE. You have the power to make sure that doesn't happen when they call the police by passing the Trust Act now. Thank you for listening to my story.
Thank you very much. Regan Vaughn.
Good afternoon, Mr. Chairman and members of the committee. My name is Regan Vaughn. I'm the Director of Advocacy for Catholic Charities of Baltimore. Catholic Charities serves vulnerable Marylanders through over 80 programs at over 300 sites throughout Maryland. And our experience working with various populations throughout the state is that communities thrive when there are positive relationships between the community and the police. While this is a universal truth in all of our programs, it's particularly true at the Esperanza Center, which is located in Fells Point. For over 60 years, the Esperanza Center has been working with the immigrant community in Baltimore City and the surrounding jurisdictions. And at our legal services, we provide legal services for asylees and refugees, as well as survivors of domestic violence, sexual assault, human trafficking, and other crimes. It takes incredible courage for immigrant survivors to come forward and report these crimes. When they do so, as you've heard tonight, they put themselves and their families at risk in order to help keep our streets safer. When fear of law enforcement keeps lines of communication and reporting closed, Maryland becomes more dangerous for all of us. For all of the reasons you've heard tonight, we ask that you please issue a favorable report for the Trust Act. Thank you.
Thank you. Go now to Zach Mancher.
My name is Zach Mancher. I live in Silver Spring in District 18. This testimony is in support of HB 304 and on behalf of Jews United for Justice. I am a lawyer, a public servant, and the grandson of immigrants. This bill is in line with my Jewish value of tikkun olam, repairing the world. I believe that this tenet applies not just to individuals, but to the government as well. By preventing law enforcement from working with ICE and other federal agencies, HB 304 protects immigrants from coercion so that community members can call on police without being harassed. It gives my neighbors the protection of the laws, giving them safety in their homes, jobs, and lives. Further, it allows individuals to fully participate in society without fear. My great-grandmother emigrated to the United States in 1939 with my 4-year-old grandfather in tow. Once here, she worked 6 days a week in a sweatshop, plus nights at a pizza place in order to provide for her family. When they needed it, they could and did rely on public service and public benefits without fear of coercion. It is because they were able to live, go to school, and participate in society that my grandfather was able to prosper and give his family a better life than what he had growing up and set up future generations for success. While HB 304 will not solve all of the problems in our immigration system, it does take a step towards repairing the world. It gives immigrants a chance to live without the fear of every interaction with government services or law enforcement. It is because of freedoms like these that immigrants like my grandparents and great-grandparents were able to be successful, build lives for their family, and embody the American dream. JUFJ respectfully urges a favorable report for HB 304.
All right, Daishi Miguel Tanaka, please.
Thank you, Chairman and members of the committee. My name is Daishi Miguel Tanaka with Asian Americans Advancing Justice, AAJC, here again to express our support for HB 304. Before I begin, I just want to, tell the Latinx, Asian, white brothers and sisters here bravely sharing their stories tonight that I, really hear you. I feel you. It's a real honor to be in this fight with you. As mentioned before, Maryland is home to around 266,000 Asian immigrants, and 35,000 of these community members are undocumented. And as you've heard, communities are safer when there's trust and cooperation between local law enforcement and residents. And, recently we've seen terrible, disgusting acts of violence against our Asian American elders across the country, from being stabbed multiple times to being pushed to the ground. And the fact shows that in the last year, we've seen a huge spike in hate incidents against Asian Americans, likely due to the former president's statements regarding the COVID pandemic. And this legislation is important so that our communities can seek help if they ever find themselves victims of crimes without the fear of knowing that local police works with ICE. If we can come to see together tonight that immigrant residents are community members, this isn't just an immigration issue, this is a matter of public safety. Now I myself grew up in this country undocumented since I was 6 years old with my Filipino Japanese family. My dad was an undocumented 50-year-old man who commuted 4 hours each day to and from work to provide for me. And, because my dad was undocumented, I hope that if anything happened to him, God forbid, you can call 911 and that police would be there to help him, not deport him. And I share this because we all have loved ones that we think about when they leave the home, and that will do anything to make sure that they're safe. There are 35,000 Asian brothers and sisters in Maryland right now that may be living with this daily fear due to immigration status. So now more than ever, it is critical that Maryland takes steps to cultivate trust between communities and law enforcement. And I thank you for listening this late at night on this important bill, and really urge you to support it.
Thank you very much. Hamza Ewing, please.
Good evening, Mr. Chairman, Madam Vice Chair, and distinguished members of the House Judiciary Committee. On behalf of the Council of American Islamic Relations, I want to thank you again for this opportunity to testify in support of House Bill 304, otherwise known as the Trust Act. The Council on American Islamic Relations, as you know, is America's largest Muslim civil rights and advocacy organization. The United States Immigration Detention Program operated by ICE is the largest of its kind in the world. Individuals in the ICE detention center are deprived of basic liberty, access to a lawyer, and access to loved ones. According to the Cato Institute, 21 people have died while in ICE custody in 2020 alone. ICE detention facilities sometimes endanger lives and reinforce a system of oppression counter to the democratic principles within our country. ICE has contracts with many local governments that it uses to operate its detention centers, including 3 here in Maryland and Howard, Frederick, and Worcester counties. This bill would signal to immigration authorities that our state does not support their inhumane policies. Prohibiting state agencies from enforcing federal immigration laws would inspire trust in law enforcement, help improve public safety for families across Maryland by improving reporting of crimes, and encourage vulnerable families to apply for social services. Passing this measure would send a clear message that the state of Maryland chooses to stand on the right side of history. We respectfully urge a favorable report on House Bill 304, and we thank you for your consideration. And if I could have just a couple seconds, I wanted to touch on a question that Delegate Lauren asked me the previous bill, and I was unable to answer it because I feared that I would misspeak. And I first want to give credit to our state delegates, and we understand that you are here because of your love and pride for the country, just like why we're all here for that same exact reason. But after doing a little bit of research, United States is in fact ranked number 6 in regards to how welcoming they are to immigrants, and Canada is number 1. And
Mr. Ewing,
with that, I just conclude. Thank you again for giving me the opportunity to testify. And
thank you.
Thank you.
Zachary Berger, please.
Honorable Chairman and members of the committee, as the primary care doctor for undocumented Spanish-speaking immigrants in Baltimore at the Esperanza Center, which was just mentioned, I have seen too many avoid the hospital. There are many reasons why people don't go to the emergency room or to a hospital-based COVID testing center. There is, of course, the waiting period and time off work. But more than once, I have heard from my patients that they are reluctant to go out of concern that ICE is lying in wait for them to deport them on their visit to the hospital. Now, such incidents have not been reported in Maryland, but they're unlikely to be reported because immigrants do not feel secure. Furthermore, our public officials and agencies have not yet defended them against rapacious and uncaring branches of government who enforce arbitrary laws against those who come here for safety and security. For my patients who have escaped murderous regimes seeking a better life for themselves and their loved ones, to be deterred from visiting a hospital, especially in time of pandemic, because ICE might deport them, is nothing but soulless cruelty. I thus support this act and request that you give a favorable report to this act to cut off cooperation with ICE and limit their actions in sensitive locations like hospitals for the benefit of my patients. Thank you very much.
Thank you. The Reverend Kobe Little, please.
Good afternoon, Mr. Chairman. Good evening, Good evening, Madam Vice Chair and members of the committee. I'm Reverend Kobe Little. I represent the Maryland State Conference of the NAACP, and I'm here this evening to testify in support of House Bill 16, Dignity Not Detention, House Bill 750, Right to Counsel, and this bill, House Bill 304, the Trust Act. Listen, when we hear the words big lie, we think about the election lies. But there's another big lie that we ought to be aware of. And that big lie is that immigrants are a problem, that immigrants are enemies, that immigrants are an unnecessary burden to our society. That's a lie. And another part of that lie is that we need to be protected against immigrants. And therefore, we need the full weight of the federal government, and we need our police to cooperate with ICE and the federal government to remove immigrants from our communities. That's ludicrous. In fact, immigrants are our friends, our neighbors, our co-workers, our family members. They are people that we care about. And what we've already heard from testimony this evening, delegates, is that cooperating with ICE, having police departments cooperate with ICE, creates public health problems, it creates family separation, it creates harassment, and it makes us all less safe because immigrant families don't feel safe reporting when they're victimized by crime or victimized by ruthless, discriminatory landlords or any number of other things. So now that we've exposed the lie, it's pretty clear that there's nothing left to do but to pass the Trust Act. Trust is much better than lies. Thank you. God bless you and have a good evening.
Thank you very much. Are there questions for this panel? Questions for the panel? Seeing none, we thank you all very much for testifying. That concludes the testimony from those people in favor of the legislation. We're now going to move to those people who are opposed to the legislation. On the list is Todd Wyville from the Frederick County Sheriff's Office, but we do not see anyone in the waiting room. Sherry Rendell, Brad Botwin, Amy Wyckoff. If we could have them in, that would be fine. All of them have been admitted. Sherry Rendell.
Good evening. My name is Sherry Rendell. I'm the Director of State and Local Engagement at the Federation for American Immigration Reform. FAIR is a nonprofit, nonpartisan organization of concerned individuals who believe that our immigration laws must be reformed to serve our nation's interests. We were founded in 1979. We have 3 million members nationwide and 12,300 in Maryland. I am testifying this evening to express FAIR's strong opposition to House Bill 304. We oppose reckless lawlessness of sanctuary policies that would be imposed by this bill. HB 304 expresses that state and local officials should have no real involvement in immigration enforcement or detention matters. In practical terms, this bill will not only forbid local sheriffs from cooperating with federal agents in enforcing immigration laws, but more importantly, would prevent them from alerting U.S. Immigration and Customs Enforcement if they become aware of a suspected criminal in their custody at their local jail. After Montgomery County expanded its sanctuary policies, it experienced an illegal crime wave that was directly tied to its sanctuary policies. In just over a month, 8 illegal aliens were charged with committing sex crimes in Montgomery County. This is similar to what happened to California. California's sanctuary policies have led to more crimes and more innocent victims. In Orange County, California, 2 years after the state passed its sanctuary law, the Orange County Sheriff's Office was forced to release more than 1,300 aliens with ICE detainers back onto the street. More than 400 of those aliens were rearrested with charges including rape, assault with a deadly weapon, child sex offenses, domestic violence, and driving under the influence. HB 304 claims it will allow officials to comply with immigration detainer requests if they're accompanied by judicial warrants. However, this is simply not possible since these warrants do not exist. The Immigration and Nationality Act provides authority for immigration officers to detain individuals. However, there is no provision whatsoever for judicial warrants or other court orders in this federal statute. If judicial warrants were required, it would place an untenable workload upon
Ms.
districts.
Randall,
Yes, sir.
you would please wrap up.
Okay. I have one more point. Many jurisdictions are bullied into adopting sanctuary policies by advocates who claim that honoring or complying immigration detainers would be unconstitutional as a violation of the Fourth Amendment. However, these are just written requests on behalf of the Department of Homeland Security to another law enforcement agency to hold an individual based on an inquiry. Simply put, detainers constitute a reasonable request for state local assistance in effectuating a civil arrest.
Ms. Randolph, please, this is it.
Sure, thank you. I want to thank the delegates for the opportunity to present my testimony, and I would recommend that you issue an unfavorable report for each.
Thank you very much. Brad Botwin, please. Mr. Botwin. All right, we're going to go to Amy Wyckoff, and I'll keep an eye out for Mr. Botwin. Amy Wyckoff, please.
My name is Amy Wyckoff, and I have lived in Montgomery County for over 33 years. Thank you for giving me the opportunity to provide testimony on HB 304. This bill would turn Maryland into one of the most egregious sanctuary states in the country.
Hello?
This bill would prevent cooperation and information sharing between local officials and federal immigration authorities. One of the lessons of 9/11 was the detrimental effect this lack of cooperation has on national security. A number of the hijackers were illegal aliens who had subverted our immigration laws. HB 304 would prohibit agreements such as the 287 program, which provides a safe method of detaining criminal illegal aliens in local jails until ICE officers can secure the individuals for deportation. Sanctuary policies conflict with federal law. Sanctuary policies also insult legal immigrants who respect our laws and patiently waited for years and paid thousands of dollars to come to the United States the right way. Finally, states that implement sanctuary policies become a magnet for more illegal immigration, which in turn results in higher costs of living, reduced job availability, lower wages, and higher crime costs. In the summer of 2019, shortly after Montgomery County expanded its sanctuary policies, a series of heinous sex crimes perpetrated by illegal aliens against women and children shocked the nation. All of these crimes were 100% preventable. Time and time again, criminal illegal aliens are released back into the public instead of handed over to ICE. Once free, these criminals continue to commit crimes. Not surprisingly, most of these new crimes are perpetrated back in the communities in which these illegal aliens reside, immigrant communities. The only beneficiaries of these laws are the criminals. The number one priority of government is to keep its citizens safe. HB 304 would do just the opposite. Thank you for this opportunity to testify.
Thank you very much. I'm going to see if Mr. Botwin is able to join us. He was having difficulty with the connection. Brad Botwin. Mr. Botwin. All right, he's coming back into the room from the waiting room. So we'll just give him another moment. All right, Brad Botwin. Mr. Botwin. All right. We appear to be having technical difficulties with Mr. Botwin. I will take questions for this panel. We'll see if we can figure that out in the meantime. Are there questions for this panel? All right, seeing none, we've got Mr. Botwin maybe one last time here. Mr. Botwin?
Okay, can you hear me?
Yes, for 2 minutes, go ahead.
All right, sorry.
It's okay.
My name is Brad Botwin. I'm the director of helpsavemaryland.org. I'm here today to express my serious concerns with HB 304, a politically motivated bill. Can you hear me?
Yes, go.
Hello, I'm here today to express my serious concerns with HB 304, promoting sanctuary state in Maryland.
We can hear you. We could hear you.
Well, Mr. Chairman, I think if you can hear me, can anyone else hear me besides the chair?
Yes, everyone can hear you.
All right. This is this is the 8th time. Promoting sanctuary in Maryland. This is the 8th time since 2014 this elected body has subjected the citizens of Maryland
So I think what's happening is your live stream is on in the background, and that's what's distracting you from giving your testimony. You have to close out your live stream in order to be able to testify here on Zoom. I think the best thing you can do is just to make your remarks, keep going, and try to ignore everything else.
Okay, sorry. All right, specifically, HB 304 will interfere with federal law enforcement actions to remove illegal alien criminals from our jails, schools, hospitals, courthouses, and most importantly, our communities. It will require Maryland counties that are partnered with ICE to end their successful force multiplier correction facility cooperation. We as taxpaying citizens are at a loss as to how passage of this bill will enhance public health and safety and the quality of life for all Maryland residents. Sanctuary jurisdictions endanger law-abiding citizens and legal immigrants who are subject to increasing levels of crime, murder, rape, sexual assault, prostitution, MS-13 gang violence by brazen, often repeat offenders abusing their sanctuary status. My own Montgomery is a perfect example of sanctuary policy gone wrong. This committee is well aware of the carnage that took place in 2019 when 12 young girls, 15 and under, were assaulted and raped by illegal aliens. Finally, I continue to be shocked that legislators representing Maryland's Black communities readily co-sponsor toxic legislation like HB 304. The brunt of crime, decline in public schools, social services, healthcare, and the loss of employment opportunities falls most heavily on your Black and legal Hispanic constituents. HB 304, amnesty, and sanctuary are not priorities for Marylanders struggling with COVID-19 and high unemployment. Please table this bill and focus on promoting Maryland's economy and job opportunities for all citizens and legal immigrants. Thank you.
Thank you very much. Are there questions now for this panel? All right. Seeing no questions for the panel, thank you all very much for your testimony today and for putting up with your challenges getting on Mr. Botwin. That concludes the testimony for House Bill 304, and we thank you all very much for being with us here this evening. We're going to move now to House Bill 16. Delegate Vaughn Stewart. Delegate Stewart is going to be joined by Ana Benitez, who will need Spanish language interpreting, Lucia Curiel, Mark Fleming, Joanna Silver. They'll be on the first panel. And then for staff, I think we will do the remaining Spanish-speaking people on the second panel. But just as the heads up for the interpreter, we're going to go directly into the remaining Spanish-speaking people, including Jose Hernandez, Pedro Ordeña, and Laura Arroyo. but I will add some other people to that panel as well. So with that, Delegate Stewart, you have 3 minutes. Go ahead. Everybody else will get 2.
Great. Good evening, Mr. Chair, Madam Vice Chair, colleagues of the Judiciary Committee. For the record, I'm Delegate Vaughn Stewart, and this is HB 16, the Dignity Not Detention Act. In 2019, my constituent, a Rockville resident named Jose Ricardo Villota Canales, was helping his uncle cut down a dead tree when he was approached by police from DNR. The officer fined Mr. Villota $320 for the unlicensed removal of a tree. After discovering that ICE had filed a detainer against him, the agents then held him until federal agents could arrive. Mr. Villota was shackled and sent to the ICE detention center in Frederick County, and he stayed there for 3 months. To be certain, this was an especially absurd and depraved case, and yet for ICE, absurd depravity is the norm. Indeed, since we adjourned early last session, ICE has only ramped up its campaign of terror. COVID ravaged detention centers across the country, with total deaths in ICE custody tripling. And in 2020, ICE detention centers played host to quote unquote systemic sexual assault, widespread medical neglect, and even forced sterilization. Closer to home, DHS cited Howard County's detention center for numerous legal violations, including excessive strip searches. Maryland need not be complicit in ICE's depravity. That's why I've introduced this bill again. It would prohibit local governments from signing contracts with ICE or with private prison companies for the purpose of immigrant detention. And it would also phase out Maryland's existing 3 detention centers. HB 16 quite simply will keep our neighbors and our constituents safe from the heinous conditions in these detention centers. And it will also send a message. Maryland is better than refusing to provide folks with their medication. Maryland is better than serving food with worms in it. Maryland is better than excessive strip searches. Maryland is better than systemic sexual assault. Maryland is better than forced hysterectomies. Maryland and its people are better than ICE and its detention centers. I urge a favorable report.
All right, thank you very much. The next people to testify will all get 2 minutes. And the first person who's going to testify is Ana Benitez, who I understand needs Spanish language translation. We have her remarks and we will put them on the screen. Ms. Benitez.
Actually, it would be her daughter speaking in her place, and her daughter can speak English. Narida,
Okay.
¿estás ahí?
That's just fine. All right, if you would turn on your video, we'd appreciate it.
Can you hear me?
We can hear you. If you can turn on your video, we would like that very much.
I'm not sure if you can see me.
That's good. You're fine. For 2 minutes, go right ahead and testify.
Okay, so I'm Ana Benitez's daughter. My name is Narita Roblo Garcia, and I am 19 years old. I am a Marylander, and my dad is at risk of being deported. He was detained by Baltimore County Police on the night of December 24, 2019. He was held in Towson jail for 2 months, and then ICE agents transferred him to Virginia, where he was held until 2 days ago. He came to this country fleeing the violence. His father and cousins were killed by gang members in Honduras. Those same gang members attacked my dad and threatened to kill him before he fled to the United States. Due to lack of money, we could not keep a lawyer and were only able to pay him 3 months. I was found obligated to leave my classes and start working so I could help my mom out, but it's still not enough to pay rent and food. Now we fear being evicted from the apartment we live in. My 4 brothers and I have been very affected by being separated from my dad. Even inside of the detention center, he was infected with COVID-19, affecting his wealth. He told us he did not receive the necessary medical attention. He asked to be taken to the hospital and they never did. I ask you to please approve this legislation because my father would not be about to be deported if the police had not collaborated with ICE, and also if he had a lawyer from the beginning. I beg you, don't let more families experience this nightmare. Thank you.
Thank you very much. We'll hear now from Lucia Curiel, please.
Hi,
Good evening, and thank you for the opportunity to testify today in support of HB 16, the Dignity Not Detention Act. My name is Lucia Curiel. I'm a proud immigrant from Argentina, living in Chairman Clippinger's district. I'm also an immigration attorney at CASA. And I'm here today because our members at CASA, who lead our organization, have decided once again to include this as a top legislative priority. Thousands of our members have been personally harmed by immigration detention, either through their own personal experience or that of a loved one. You've heard from a tiny, tiny fraction of them today, earlier in the day. Thousands more live with the constant fear that they could be detained at any moment. When considering this bill, we hope that you will consider and listen most closely to the people that are personally impacted by immigration detention. Opponents will try to argue that immigration detention is important for public safety reasons, but the opposite is true. First of all, the majority of people in ICE detention, even under ICE's own standards, are not classified as any kind of threat. ICE detention is also civil. ICE does not have the authority to detain anybody for a criminal offense. The practice of ICE detention is a source of trauma and generates distrust in government institutions, including the police, which undermine public safety. Other opponents will argue that it's better for Maryland to have an immigration detention here rather than, because the alternative is for people to be in detention centers in less friendly jurisdictions. And while we are sensitive to this argument, what we really want you to hear and understand is what our members know and understand, which is that less beds means less ICE detention, and that is what we should strive for. You will hear today, continue to hear from today, from members about what immigration detention is truly like in Maryland. We hope that you'll understand what we know to be true.
Ms.
That immigration
Curiel?
detention is a destructive practice that carries tremendous costs, and Maryland should end it within our borders. Thank you.
Thank you very much. Mark Fleming, please, for 2 minutes.
Yes, thank you, Chairman. My name is Mark Fleming. I'm the Associate Director of Litigation at the National Immigrant Justice Center, and I'm here in support of HB 16. I'd like to spend my brief time here talking about how HB 16 maps onto similar legislation that has been enacted in other states. In recent years, the states of California, Illinois, and Washington have all passed legislation comparable to HB 16. In each of those states, limit their state and local units of government from entering into contracts for civil immigration detention or from helping to facilitate private prison companies to operate civil immigration detention in their states. It's well established at this point in court decisions from across the country that states have constitutional authority to decide whether and under what circumstances its state and local units of government participate in immigration enforcement, including detention. Indeed, neither the federal government nor any other party has challenged any of these other states' immigration detention laws that are similar to HB 16. The Dignity Not Detention Act is necessary now more than ever. ICE has quietly been in pursuit of substantial new detention space in Maryland since at least April of 2019. In response to ICE inquiries, Immigration Centers of America, a private prison company, has been actively trying to convince officials in Queen Anne's County to permit it to build a new large detention facility there. ICA's track record in detaining immigrants is deeply troubling. In the one facility it operates in Farmville, Virginia, ICA oversaw the largest outbreak of COVID pandemic in any immigration detention facility. It had over 339 infections and at one point over a 93% infection rate. The Dignity Not Detention Act will rein in the impacts of the grossly mismanaged ICE detention system on this state and its residents. Thank you.
Thank you very much. We're now going to hear from Joanna Silver.
Hello again. I am again testifying as a community advocate in support of HB 16, this time on behalf of Jews United for Justice and Tacoma Park Mobilization, but also as someone who has a close familiarity with ICE detention through my work as a federal public defender. My illegal reentry clients almost always come to me from ICE detention, and is literally a matter of moving from one jail to another. They are detained in the exact same jails as people serving criminal sentences. We just call it civil detention. They have the same loss of liberty and the same harsh conditions of confinement, but fewer benefits, less programming, less access to counsel, and no credit towards any pending criminal case. ICE detainees are no better off in Maryland's jails than they are anywhere else in the country. I have seen firsthand how terrible the conditions in our jails can be, especially during COVID. And the Department of Homeland Security's Inspector General itself found unacceptable conditions at the Howard County Detention Center, which holds one of our ICE contracts. Private prisons are all of this, but made worse by a perverse financial incentive. And we need to make sure that attempts to bring those private prisons to Maryland, like those recently on the Eastern Shore, are stopped. This bill has tremendous support from the community, from immigrants to activists to faith leaders to members of this General Assembly, like the Black, Latino, and Asian American and Pacific Islander caucuses. They all know that administrative detention by ICE is immoral and unnecessary. That we need to detain people awaiting deportation is a false narrative created by the same racist laws from the 1990s that drove the mass incarceration we have today. In fact, a 2019 report by the American Immigration Council showed that in the vast majority of cases, immigrants released by ICE appear in court for their removal proceedings. I see this in my own cases. My illegal reentry clients who were released by a local criminal court before being charged in my case are almost always found by ICE exactly where you'd expect them to be, at home, in their community, working to support their families. None of them flee. Why would they?
Ms. Silver?
Thank you.
Wrap up. Thank you.
They don't flee because they want to be here. Maryland should end its complicity in the civil detention of immigrants. I urge you to reach a favorable report on HB 16.
Thank you very much. We'll take questions now for the panel, starting with Delegate Lopez, then Delegate Conaway.
Thank you, Mr. Chair. My question is for Ms. Curiel. I just want to make sure that I'm understanding things correctly, because it's immigration night, and so we've had a lot of information coming our way. Can you tell me what the difference is between the county contracts with the 287G stuff and the IGSA? I want to make sure I have clarity on what those two things do.
Yes, absolutely. So an IGSA versus a 287G program are two separate and distinct programs that are authorized by separate, distinct sections of the federal statute. A 287G program is an agreement, an agreement to partner with ICE to partner with a local entity, usually a county, to deputize some designated county officials to enforce immigration law in limited capacities. So basically to kind of like switch out their badge for a little bit as an ICE officer. Versus an IGSA is really just like a subcontract with the government. And in this case, it's a subcontract to rent a facility where the federal government is just contracting with a county to rent space in like a county facility in order to house ICE detainees under their custody. And this bill really is only about IGSAs. It's really about ending ICE detention, closing down existing IGSAs, having them terminated by October 2022, and preventing future IGSAs as well, given all of the systemic abuse and all of the collateral, economic, human, psychological consequences of ICE detention.
Thank you so much for that.
Delegate Conaway.
Thank you, Mr. Chair and committee. Thank you, Delegate Stewart, for bringing this bill. I think you said systematic sexual crimes and forced hysterectomies. Who is doing that?
Yeah, well, it's a great question, Delegate Conaway. So there's a facility in rural Georgia that a whistleblower alleged sort of blew the whistle on practices where women were being forcibly sterilized, incidences of forced hysterectomies in a Georgia facility just this past year. I actually forget, one of the other panelists may remember offhand where the systemic sexual assault was. Now that's the systemic sexual assault, meaning there was a report in one of the ICE facilities that the sexual assault was so pervasive that it was systemic. It wasn't just one off case here and one off case there, which we've seen in many other facilities. But there was one facility that basically it became such a habit and practice that that it was a systemic practice where basically the ICE guards were raping and assaulting female detainees. So while and of course here, here in Jessup, there were excessive strip search allegations by the Department of Homeland Security, where folks were coming from chapel. They were trying to pray, and they were being forcibly strip searched before and after, even though the report said there was basically no way at all they could have gotten contraband in the chapel. But it's almost like the ICE guards were doing it for fun. Yeah.
Thank you, Delegate.
Thank you very much. Seeing no further questions, that will conclude our first panel. We're having some technical issues with the next Spanish-speaking panel, so we're going to go ahead and hear from others, and we're going to move down the list here. So we'll hear from Charlene Belsom-Zelmer, Kate Sugarman, Daishi Miguel Tanaka, Joe Spielberger, Fatima Yunus, Zachary Berger, Carrie Ann Murray, Reverend Kobe Little, and Lance Kilpatrick. Ms. Zelmer? Ms. Zelmer? She is coming into the room. There she is. Ms. Zelmer, please.
Good evening, Chair Clippinger and members of the Judiciary Committee. I'm Reverend Charlene Belsom-Zelmer, 50-year Maryland resident and an interfaith minister. I speak with urgency in support of HB 16, the Dignity Not Detention Act, on behalf of Maryland Against ICE Detention, a statewide coalition of 200,000 members who strive to stop immigration detention and systems that contribute to detention and deportation. We oppose both private and public ICE detention, including the IGSAs that reserve beds for ICE to detain our immigrant neighbors, friends, and family. The presence of ICE in our communities is severe. More detention beds result in more community raids, people detained at routine ICE check-ins, and community members detained for civil violations. Many of our fellow Marylanders live in fear of being detained, deported, forcibly separated from their children, and prevented from supporting their families. Profiling and collateral arrest jeopardize the peace and the safety of our entire community. Prison detention's big business for just a few corporations who reap huge profits from inhumane treatment of detainees and less than fair compensation for their employees. There are horrific conditions and predatory contract initiatives. County centers through IGSAs also have documented abuses and stand on unjust moral ground. We cannot continue to be complicit in this cruelty. Maryland must join numerous state and local governments around the country who have rejected being part of ICE's cruel, costly, and destructive system of immigrant detention. Many community-based alternatives to incarceration exist. Immigration detention is an expression of moral bankruptcy that has no place in the state of Maryland. We cannot continue to profit from this brutal treatment of our neighbors. For these many reasons, I implore you, representing MDAID, report favorably on House Bill 16. It will be a blessing to our state.
Thank you very much. Kate Sugarman, please.
Okay. Good evening, Chair Clippinger and members of the Judiciary Committee. The Maryland chapter of Doctors for Camp Closure strongly supports HB 16, Dignity Not Detention. I've been born and raised in Baltimore. I'm a family doctor. I now live in Potomac in District 15. We're part of a nationwide movement, D4CC, Doctors for Camp Closure, which promotes humane treatment of migrants. We have been into ICE jails and we have reviewed scores of medical records of people who are in ICE detention. We know firsthand that there's no healthy amount of time for an immigrant to be detained. The issue has taken on a heightened sense of urgency as we face a severe pandemic. Serious illnesses and deaths due to COVID continue to rise inside the prisons, not only for the detained immigrants, but for the staff at these facilities. All of these deaths are preventable and would not happen were these detention centers to close down. So in fact, ICE detention makes our communities more at risk and less safe. In addition, family members suffer when their parents and spouses are picked up by ICE and locked up out of reach of their family members. Families lose their wage earners and children lose their parents. These children can no longer concentrate in school and suffer a host of psychological consequences. We urge the passage of Dignity Not Detention so that families can stay together and be healthy together. D4CC urges a favorable report on HB 16. Thank you.
Thank you very much. Daishi Miguel Tanaka, please, for 2 minutes.
Thank you, Chair, members of the committee again. Daishi Miguel Tanaka with Asian Americans Advancing Justice, AAJC, to express our support for HB 16. Again, it's really important to emphasize that detention is an issue that affects all communities of color. And as of 2018, there were nearly 5,000 Asian immigrants in detention, with many of them being asylum seekers. Detention subjects immigrant detainees to deplorable human rights abuses. You know, in these facilities across the country, immigrants have been cruelly retaliated against for exercising their constitutional rights. South Asian asylum seekers protesting their prolonged detention by going on hunger strikes have been retaliated against with solitary confinement and abusive force feeding practices. South Asian and Sikh detainees have also been denied religious accommodations, including being banned from wearing their turbans, being forced to cut their hair, not being provided with vegetarian or vegan meals. You know, detainees, including multiple Bangladeshi detainees at the Stewart Detention Facility in Georgia, have also been punished with solitary confinement for refusing to work $1 per day. Immigration detention is cruel and unnecessary, and there is ample evidence that immigrants in removal proceedings show up to court when they're not in detention. A recent study showed that over an 11-year period, 96% of all individuals with counsel appeared in court for every one of their hearings. Now, this allows many immigrants to continue working and supporting their family members, often U.S. citizens. Now, look, you know, we understand that the federal government will have to make the ultimate decision to end or scale back immigrant detention, but passing this bill would have both a real impact on detention and send a powerful message to Congress and the president that Marylanders oppose immigrant detention. So we thank you for holding a hearing on this important bill and urge you to vote for it.
Thank you very much. We'll go now to Joe Spielberger, please.
Good evening, Chair Clippinger, Vice Chair Atterbury, and committee members. Again, tonight I'm Joe the representing the ACLU of Maryland in support of HB 16. Private companies that have turned immigration detention into a lucrative industry have perverted any notion of public safety and accountability. They largely operate without public oversight and are not subject to constitutional requirements, administrative law, open records laws, and other legal checks that would otherwise apply to federal agencies doing the same work. And as they turn upholding the rule of law into a profitable business, they undermine the fundamental values that we in Maryland hold dear. Because without meaningful oversight, there's no incentive to provide for the health, safety, and protection, or to treat humanely those entrusted into their care. And so they don't. Their whole business model depends on locking up more and more people. And as they reap massive profits, they subject immigrants to grossly inhumane conditions and violate the basic dignity and humanity of those in their care. So this bill is important to ensure that Maryland is not complicit in the exploitation and dehumanization of immigrants that we see nationwide. Because here in Maryland, we keep our communities safe despite what it costs, not because of it. So the ACLU of Maryland urges a favorable report on HB 16. Thank you.
Thank you very much. We'll go now to Fatima Yunus.
Thank you, Mr. Chairman and House Judiciary Committee members. My name is Fatima Yunus, and I'm a volunteer with the Council on American Islamic Relations. On behalf of CARE, I thank you very much for this opportunity to testify in support of House Bill 16, entitled Correctional Services Immigration Detention Prohibition, or the Dignity Not Detention Act. CARE is America's largest Muslim civil rights and advocacy organization. The United States' Immigrant Detention Program, which is operated by Immigration and Customs Enforcement, or ICE, is the largest of its kind in the world. Individuals in the ICE detention center are deprived of basic liberty, access to a lawyer, and access to loved ones. According to Cato Institute, 21 people died while in ICE custody in 2020 alone. ICE detention facilities endanger lives and reinforce a system of oppression counter to the democratic principles in our country. ICE has contracts with many local governments that it uses to operate its detention centers, including 3 here in Maryland in Howard, Frederick, and Worcester counties. HB 16 would cut off state and local government's role in either setting up a detention facility or participating in the continued operation of detention facilities, promote transparency by making sure that the public is notified of plans for a new facility, and prevent state or local entities from entering into new contracts or renewing any existing contract for immigration detention, compel existing contract to be terminated by June 2021. This issue is especially timely considering the harmful impacts of these facilities during the current coronavirus pandemic. Our organization is opposed to the construction of more ICE detention centers in our state. By passing this bill, Maryland lawmakers have the opportunity to make sure that no government entity or corporation profits from incarcerating immigrants. It would help reduce family separation and make sure that ICE and its contractors are not able to expand their reach in our state. Passing this measure would send a clear message that the state of Maryland chooses to stand on the right side of history. We respectfully urge a favorable report on House Bill 16. Thank you for your consideration.
Thank you very much. We'll go now to Zachary Berger, please, for 2 minutes.
Again, honorable members of the committee, thank you for your time. As a primary care doctor for undocumented Spanish-speaking immigrants in Baltimore, I've taken care of many patients with COVID in my clinic and in the hospital. I've also spoken to patients whose relatives have been detained by ICE in state correctional institutions, the latter receiving a grisly per capita sum for each detainee. These 2 facts reinforce each other, of course. COVID is widespread among Maryland Latinx, out of proportion to the representation in the population. And ICE, it's well known for its attitude to COVID testing, treatment, and vaccination, at best ignorant and lackadaisical, at worst cool, indifferent. For the state to continue to contract with ICE, either itself or through private concerns, in order to fulfill the latter's need to detain immigrants is nonsensical. ICE is a federal agency prioritizing arbitrary regulations over the good of vulnerable immigrants, and currently heedless of its public health responsibilities during the pandemic. For the state to collaborate actively with ICE to make detention possible, flouting dictates of public health and humanity, is a black mark on the state of Maryland. Thus, I support the Dignity Not Detention Act to cease such misbegotten cooperation, and I thank you in advance for your favorable report on this bill.
Carrie Ann Murray, please. I'm sorry that Carrie Ann Murray is not in the room, so that's fine. The Reverend Little is not there either. Lance Kilpatrick.
Mr. Chairman, members of the Judiciary Committee, thank you for this opportunity to tonight. My name is Lance Kilpatrick. I am the Legislative and Political Director for AFSCME Council 3, representing approximately 30,000 state and higher education employees in Maryland. Among those that we represent are correctional officers in our state's prisons. Admittedly, we regularly butt heads with management over staffing, wages, and working conditions. All too often, the issues we discuss with management have direct negative impacts and consequences on the safety of staff and inmates if they go unresolved. Lack of appropriate levels of staffing harm the ability to implement and maintain ongoing education and rehabilitation programs. However, we can and we do engage with management, raise those issues, and alert the public by blowing the whistle on poor conditions when they exist. For privatized prisons and for-profit detention facilities, there are no whistleblowers, no public servants that look to serve their community with dignity and respect for the lives of others. The bottom line is the last line on the profit ledger. Is it big enough? If not, what more can be cut back, squeezed out of employees and programs to enhance that profit? For-profit imprisonment and detention are among the most immoral institutions imaginable. There is no goal of adjudication or rehabilitation or societal reincorporation. It's all about the money. AFSCME Council 3 asks for a moral, favorable report of this legislation. Thank you.
Thank you very much. All right. We'll take questions for this panel, and then we're going to try to have our last two Spanish-speaking witnesses participate this evening. Any questions for the panel? All right, seeing none, thank you all very much. We're now going to go to two people, Pedro Ordeña and Laura Arroyo. We're going to see if it's going to work this time. See if only Pedro. So it's only going to be Pedro, and he's admitted, and Ms. Roque is also in the room. So if we're ready, we'll go ahead and hear from Mr. Ordeña, please.
Pedro, si te puedes conectar tu audio y puedes iniciar.
Okay. My name is Pedro Jose Ordóñez. I've lived in Hyattsville, Maryland. After spending 14 months in jail for re-entry charge, after spending about over a year apart from my children in jail, I was sent to Howard County ICE Detention Center, where I would serve another 9 months before I would gain my freedom. By winning my legal right to stay in the United States through a status called withholding of removal in 2019, if it had not been for my lawyers, I would have been deported, even though I've spent almost my entire life in this country. The treatment that I got in Howard County was horrendous. I was one of the lucky ones because I spoke English. There was only one Spanish-speaking detention officer, so many inmates were ignored. Even when they were sick, they were not given treatment. I was unable to get asthma treatment in a timely way when I needed them. They say that we are not criminal inmates, but we are treated exactly as such. We barely have any outside time except for church, which is often canceled, and there are no educational programs or recreational activities. The worst is the punishment. I was placed in solitary confinement for 45 days without knowing when I was going to get out. There was one other detainee in a cell next to me who talked about committing suicide, and I think maybe God put me in a cell next to him to stop him from following through on it. Even though I wanted to try to support and help other detainees by being bilingual, the guards would not listen to me. I'm sharing my story because nobody should be in immigration for detention purposes ever. My experience illustrates detention is always worse, no matter what the detention center says or where it is. I believe people should never be detained for simply being an immigrant, which is the sole purpose of the civil immigration detention in this country.
Thank you very much.
All right.
No, thank you
Thank
very
you
much
guys
for
having me.
absolutely. Thank you. Thank you very much. I thought that he required the Spanish language interpretation. He did not. So, but he was the only person on this panel. Does anyone have any questions for Mr. O'Dania, Delegate Cardin, and Delegate Bartlett? Delegate Cardin.
Thank you very much. And thank you very much, Pedro, for coming and speaking to us. Did you, first of all, you were in detention for over 2 years, it sounds like, 9 months and 14 months.
Yeah, it was around 2 years, but 14 months were in a federal detention facility, and then the 9 months was with Howard County, which was for immigration. Yeah.
Have you had a chance to work since you've been out?
Yeah, I was working fine, but there's so much obstacles when you get out of detention, like especially for an immigrant. There is no workshops, no help from the community. I mean, I've received, I'm not saying that I haven't, I've received plenty of help, especially from nonprofit organizations. But it's been a struggle because you don't have a driver's license, you don't have like a halfway program, that makes you rejoin the community. So you fall back in so many ways. You don't have the right documentation, you don't have the support to re-establish yourself in the community.
Thank you for telling us your story. We really appreciate it. It's good to hear that you're doing okay now.
Yeah.
And keep up. I'm glad that you learned English, and keep up the good work. Thank you.
All right. Thank you for your time.
Thank you. Thank you very much for your testimony. All right, that will conclude those people who are testifying in favor. Very briefly, we want to thank Kat Paul from CASA for coordinating our Spanish language witnesses for this evening and making it easier for us to hear their testimony and to have the English version of the testimony available for everyone to hear. It also saved us a little bit of time, which I know the committee quite appreciates. So we do thank you for making it easier for all of our people, for all the witnesses to be able to testify today. With that, we'll hear from the opponents of the legislation. Todd Wyville from the Frederick County Sheriff's Office, Sherry Rendall, Amy Wyckoff, and Brad Botwin. I see Ms. Rendall.
Good evening, Chairman Kleppinger and other members of the committee. My name is Sherry Rindle again. I'm the Director of State and Local Engagement at FAIR. I will jump right in. The majority of immigration and customs enforcement detention facilities are private. Many proponents demonize private detention facilities, hoping to convince the American people that no individuals entering the United States illegally should be detained. This concept of open borders has public safety and national security risks. 90% of the illegal aliens arrested by ICE in the interior of the United States are either convicted criminals or face pending criminal charges. If these individuals were released back into the community instead of being detained, about approximately half would reoffend within a year and 5% would reoffend within 5 years, according to the former ICE director, Tom Homan. Likewise, proponents of the bill claim that these private facilities operate outside the purview of public oversight and accountability. However, this is simply untrue. Private companies and contractors that operate these facilities must comply with strict governmental requirements, as well as national accreditation and certification standards. Moreover, policies like HB 16 hamper ICE's ability to effectively accomplish its statutorily mandated mission to identify and ultimately remove illegal aliens. However, if Maryland enacts this legislation, it will not succeed in stopping the detention of illegal aliens. It will simply raise the detention costs on taxpayers, and it will mean that individuals will be detained in other states further away from their families and counsel. Finally, HB 16 imposes a one-size-fits-all policies on statewide communities that have already made the decision locally that they may or may not want a private facility. For these aforementioned reasons, FAIR urges the committee to have an unfavorable report for HB 16. And I thank you for the opportunity to testify.
Thank you very much. Amy Wyckoff, please.
That have already made the decision locally that they may or may not want.
One moment. Ms. Wyckoff, if you turn off
FAIR urges the committee
the feed.
to have an unfavorable report for HB 16. And I thank you for the opportunity to testify.
You need to turn off the YouTube link, please. Please.
That have already made the decision locally that they may or may not want.
You have to close the window with the YouTube link. Close the YouTube link.
Where
is
have an unfavorable report for HB 16. And I thank you for the opportunity to testify.
You need to turn off the YouTube link, please. Please. Close the window with YouTube. Or just the tab with YouTube. Don't close Zoom.
Okay.
All right,
Okay.
there we go. For
Yeah.
2 minutes, go ahead.
I'll be really quick. My name is
Right.
Amy Wyckoff, and can you hear me?
Yes.
My name is Amy Wyckoff, and I've been a resident of Montgomery County for over 33 years. I am writing in opposition to HB 16, the Dignity Not Detention Act. Private immigration detention facilities generally meet higher standards than local jails or prisons. If illegal aliens cannot be detained in private facilities in Maryland, they will just be held in other states, further from their lawyers and any family. Private detention facilities provide both jobs and a federal income stream to local communities that want them. Adopting a one-size-fits-all policy statewide would take that away from those communities. The #1 priority of government is to keep its citizens safe. That includes keeping them safe from criminal illegal aliens. So it does not make sense to tie the hands of law enforcement agencies when it is their job to keep criminals off the streets. I therefore respectfully request that you vote against HB 16. And sorry for the technical problems. Luckily, my daughter came and saved the day.
Fine. Thank you very much. All right, now we will go to Brad Botwin.
No feedback?
No
right.
feedback.
I sat in silence this time, so nothing, I didn't turn anything on. All right, my name is Brad Botwin. I'm the director of Help Save Maryland. I'm here to express my concerns with HB 16, the bill introduced for the sole benefit of Maryland's growing illegal alien population and their local enablers who have testified earlier. Clearly, the only reason for this bill is to try to muck up law enforcement, that is state, local governments, sheriffs, and their officers, employees, from using efficient private detention facilities to hold illegal alien criminals. And, you know, I really have to ask, after hearing all the testimony tonight, what actual citizens groups asked you to intervene on this alleged problem? If illegal aliens cannot be detained in these private facilities or in local facilities, federal officers will just move them to other facilities out of our state, and they will be away from family members and their lawyers, assuming they can get lawyers. Private detention facilities provide jobs in multiple counties in Maryland, and the income stream is important to those communities that made that decision. Adopting this statewide policy would take away that income stream from these communities. The bottom line is that Maryland citizens, especially Black and legal immigrants, are safer when we remove criminal aliens from our streets and communities. Less places available to lock up criminals is bad public policy. Moreover, forcing federal ICE agents to drive criminals out of the state will slow down the process of picking up wanted criminals. And I think we all can agree on these are wanted criminals because Maryland lawmakers want to make nice with these folks and their handlers. This is shocking public policy. Maryland lawmakers instead should be focusing on the public health and safety and the quality of life for all Maryland residents and not worry about this so-called dignity of those illegally in our country who are set for deportation. Remember, they broke the
Mr.
law to
Bodwin.
get here. They are jumped in line in front of legal immigrants. There is no dignity in that. Please vote this bill down.
Thank you very much. Questions for the panel? Delegate Lopez.
Thank you, Mr. Chair. My question is for Ms. Rendell. So I've heard of FAIR, and I just did some quick research, and it looks like the Southern Poverty Law Center considers your organization a hate group. So I'm wondering, with that in mind, why you feel like you're in a position to comment on this legislation.
Delegate, thank you so much for the opportunity to address that issue. SPLC has designated several groups that disagree with them on political issues as hate groups. We are a nonpartisan group that has been around since 1979. We are funded by donations from our members, and we have the public interest of Americans first. And just because they disagree with us politically doesn't mean we are hate groups. In fact, the Washington Post has an article that has said that is simply not the truth.
Thank you. Just for clarification, it's more about the comments about white supremacy than about disagreeing with your opinion. Certainly, there's lots of opinions that the Southern Poverty Law Center might not agree with, but they don't go so far to call a group a hate group. So thank you for your clarification.
Thank you very much. Are there any questions, please, for the panel? All right, the Vice Chair.
Thank you. I have two questions. I want to follow up on my colleague, Delegate Lopez's question to Ms. Rendell, because I was doing some research too, because I hadn't heard of your organization, but I found a website, and I think it's Federation for Immigration Reform. And it says you have one mission, which is to limit, your organization has one mission, to severely limit immigration into the United States. So, and to essentially maintain a white population here in the United States. So I'm wondering, is that your mission, or can you tell us what the mission of FAIR is? Because I don't know that many of us are familiar with FAIR.
FAIR seeks to educate individuals on immigration policies that reduce the harmful impact of illegal immigration on our national security, public safety, economy, jobs, education, healthcare, and the environment. We do take a position against illegal immigration and believe that legal immigration must be reduced in order to be able to sustain it. We have recommended that legal immigration go to 300,000. That is not much off of the Jordan Commission, which was a commission in 1996 that was appointed by Bill Clinton. And they said that legal immigration should be at 500,000.
So, I mean, and your members are certainly entitled to their opinion, but apparently your founder, John Tanton, and board members said, as whites see their power and control over their lives declining, will they simply go quietly into the night, or will there be an explosion? So I think that kind of colors where you're coming from. Mr. Botwin? Mr. Botwin, your name's not on it this time, so I think it was Botwin.
Yes.
Okay, thank you. So I'm wondering if you think it's okay for detention facilities to, have human rights violations, essentially. Is it, I mean, it sounded like you were saying it's okay because these are folks that are here illegally and they're undocumented. So essentially it's okay. Whatever happens there, happens there, and it doesn't matter.
No, not at all. Of course, human rights is very important, and the safety of people, even criminals in jail, should be kept safe. We've seen that with providing COVID and allowing less violent criminals to be out. But these are, you know, the reality is it's cheaper for a company to run a jail than it is for, you know, you, the government, to do that. And if these communities decide to have this and for the job creation purposes, why not let them? Of course, it's regulated. We just don't throw people in and never see them again. You know, those days are far behind us. But I just think it's a better method. And I think the citizens in the local areas, like we're seeing in your Howard County, where the citizens are now going to have the sanctuary bill on the 2022 ballot in a few days. They have enough signatures. People don't want sanctuary.
Right. So, but
People have
this bill in particular is about, and let's talk about Howard County, because I was quite frankly disgusted. And I want to thank my colleague, Vaughn Stewart, for bringing this to my attention, and to my other colleague, my district mate, who's not on here, Jen Terrassa, Delegate Terrassa. And we started trying to look into the issue ourselves. And quite frankly, the director of that facility, thank God, has resigned, because the young man who testified here today of the violations that were happening in there. I mean, the Department of Homeland Security came out with a scathing, I mean, a department run by somebody that's not in my political party came out with a scathing report about how that facility was being run and how those people were being treated and how they were being strip searched, how they were being denied medical treatment, how, you know, COVID was overtaking the place and folks weren't getting treated. People were getting one mask that you were supposed to hang on to for the 9 months or 2 years that you're in the place. So I'm just trying to figure out, because you were using this term dignity. So is that dignity? How those folks are being treated? Is that dignity?
You're talking about one jail in the whole state of Maryland, and you're going to have sweeping legislation to not allow it anywhere. I mean, I think that's a little bit of overkill on your part. And again, you need to look in your own backyard, because the citizens of Howard are going to overrule you, or not you, I should say, the council on sanctuary. And I was there. I went to watch at one of the libraries where they were getting signatures outside collecting.
Well, sir, I don't want to.
And it was amazing.
I want to focus on this legislation.
A rainbow coalition of people.
I want to focus on the legislation that we're talking about. I'm not on the council. I'm not involved in the sanctuary stuff that's going on. From what I know, I would tend to disagree with you on that.
You're from Howard, and you should actually understand the people that elected you, what they're doing.
So you should not be disrespectful. That's what you should do.
No, I'm not being disrespectful.
You should not be disrespectful.
Your question, and I'm trying to.
Well, you can ask questions. I can ask you questions on the bill, and you were off. You were completely off the bill. We're not talking about sanctuary in Howard. I serve in the Maryland General Assembly for the whole state.
Where were you when the
Frederick
were testifying?
Hold on.
People from Frederick were testifying, attacking Sheriff Jenkins. And
Mr. Botwin. Thank you. The Vice Chair have a question.
No, thank you, Chair Clippinger. I think
thank you very much.
We've all seen what's going on here with this testimony.
Thank you very much. We'll go now to Delegate Rachel Jones.
Yeah, my question is also for Mr. Botwin. You mentioned that this bill would make things less safe for Black and Brown Americans or Marylanders. What did you mean by that?
Okay, the reality is that the crime from illegals affects legal Hispanics, legal Blacks. Just if you look across the state where the problems are, Baltimore City has lots of illegals. They have a very open policy. So it is logical that if you're now going to tighten up and not allow, you're going to allow more and more illegals to be wandering the streets because there's no place to put them, it's going to affect the people in their neighborhoods.
So is your assertion then that undocumented folks are just living in communities among other Latinx folks or other Black folks and not anywhere else where other people are affected by their presence?
of course, people can live where they want. I'm not familiar with that Latinx term, but you are from, I'm looking on my list here. These pictures don't always match your current state of affairs. You are from Prince Calvert and Prince George's. Okay, so.
You mean my natural hair in that photo?
No. It's more not a hair thing. It's more of a age thing on some of these. And the pictures that I printed out are a lot smaller than you are on the screen right now. The Prince George's County, the crime rates in certain areas are higher than in other places. And there are higher, as we heard from testimony, God, all night tonight, that there are families, they have illegals in the families. So what would you expect? You're going to have crime everywhere.
Okay.
And you know, that horrific 2019 rape after rape was just incredible here of 13-year-olds by these same illegal aliens that you wouldn't lock up if this bill passes.
Okay, so I would just
somewhere else.
Okay, I would just assert that certainly no one is a proponent of crime, no one is a proponent of rape, and certainly not seeing our underage youth go through experience things like that. But I think if we also look at the statistics, you'll also see that a significant number of violent crimes are committed by white Protestant Americans, African Americans. Every race has a significant contribution that they make to the crime rates here. So it's not just a matter of undocumented immigrants who are doing that. And my final point.
I'm sorry to interrupt, but the undocumented don't deserve to be here. Legal immigrants deserve to be here. As I said before, when you jump the border, when you jump the line, you are taking away from others who came the right way to come in. As my grandparents did, legally by boat via Ellis Island, legally. Okay, didn't run across the Rio Grande and make their way to Maryland. And there is a difference. So, you know, the terminology tonight, everyone is an immigrant. No, there are legal immigrants and there are illegal immigrants.
Thank you. You did make one point on the final bill that I would just like to previous bill that I would like to just finish my comments with. You said that you were unsure why Black Americans and legal immigrants support a bill like this. And I would just let you know that based on the testimonies that we've heard tonight, a lot of the stories from the children who have seen parents deported, folks who are checking their wallets to make sure that they have paperwork, is very reminiscent of Black Americans making sure they had freedom papers and ready to show so that they were not returned to slavery or entered into slavery because they couldn't prove that they had freedom.
No, that's a stretch. That's
it's not a stretch. It's very
That's like me saying it's like Nazi Germany where my relatives were rounded up because they were Jews. Okay, that's not again.
One at a time, please.
Illegally, you can be deported. You jaywalk, you can be deported. That's the reality of it.
Okay, thank you very much.
Thank you.
Thank you. Delegate Cox, then Delegate Conaway.
Thank you, Mr. Chair, and thank you, panelists. Amy, it's good to see you. Ms. Wachoff, thanks for being here so late. I have a direct question for Ms. Rendell. I think I said your name right, Sherry. Is that how I say Rendell? And if I sound hostile or direct, I'm not. I'm just wanting a clear answer. You heard the Vice Chair ask you a direct question about whether your organization FAIR has a white supremacy element or is a white supremacist organization. And Delegate Lopez asked you the same question, and I didn't hear a clear answer. So I'm going to read from your website. It says, immigration within proper limits can be positive. We respect the dignity of all involved. As such, FAIR opposes policies based on favoritism toward or discrimination against any person based on race, color, religion, or gender. So could you answer the question for me directly? Is FAIR a white supremacist organization?
No, it is not. It is a nonpartisan organization, nonprofit that believes in advocating for immigration policies for a sustainable earth, putting Americans first.
Okay, thank you.
Thank you.
Delegate Conaway.
Thank you, Mr. Chairman and committee. I believe your name is Mr. Bradley, is that correct?
Botwin is his name.
Which what?
Botwin, Mr. Botwin.
Well, it says B-R-A-D, Brad.
That's my
Brad
first name.
Botwin.
I don't know
Brad
why it's
Botwin.
not showing up.
All right, sorry. How you doing, sir? You seem to be very perceptive, and just let me say, my picture definitely looks different now. But my question to you is, who do you think these undocumented people work for? Who do you think these undocumented people work for? I mean, do you think they work for African American companies, or I mean, who do you think?
I think
that's traveling 2 hours to and from work?
Look, you can go to Home Depot and there are people picking up illegals in the parking lot. So, I mean, anyone, anywhere will do this. But I think if you look in the construction business, I think if you look in services, and you know, Mr. Conway, these were jobs that were traditionally Black Americans.
And white Americans. Don't
and
forget white Americans. Yes,
and white Americans had construction.
That's what I was trying to get to.
Yeah.
Thank you very much. That's what I was trying to get to.
So, and I'm, you know, I am, if you ask me, I am impressed with the work ethic of the Latino community. They're out there, but it comes down to there are rules, and they a good number of them arrived illegally, and that that's the game changer for me. Okay,
I hear you, but I think you would have made a very well argument if you would have said, yes, some of your people employ them, but some of your people are losing their jobs because of this, right? Is that what you're trying to get to also?
Wait, I'm sorry, I lost you there a little bit because of the sound.
Some of the American citizens are losing their jobs because of undocumented. That's all you had to say. Thank you, sir. Thank you.
Seeing no further questions, that concludes the testimony from this panel, and that concludes the testimony from House Bill 16. We thank you all very much for joining us this evening. The witnesses are excused. Committee, that concludes the testimony for the House Judiciary Committee for the evening. We are going to have a voting session tomorrow. We will have a voting session after if there is a second floor section, or if the judiciary or whichever is later, the judiciary bill hearings tomorrow, which start at 1:30, or the second floor session, which may happen after that. We will be taking amendments because I'm announcing it when I'm announcing it. We will take amendments all the way up until the start of the voting sessions, so that if you are looking, I understand there are quite a few amendments to House Bill 670. This will be that. So if there are amendments to 670, please get them into the committee's office. If you're having difficulty with any amendments, please let the committee's office know, and we will do the best we can to assist you. Tomorrow, also from 12:15 to 1:15, is the Family and Juvenile Law Subcommittee. I believe that is still scheduled then, and we also have a floor session tomorrow at 10 a.m. Ladies and gentlemen of the committee, thank you very much. It's 10 o'clock, and that concludes the testimony and the hearings for the House Judiciary Committee for the evening.